on an applications without mention, then we'll take up the other matters.
For inclusion in the list.
What matter?
Urgency is the matter.
Is it a hearing matter or application or order 41? Check up and come back, please, tomorrow. Yes.
Lordship, for upgradation, it is as item number 148 in the list. It is a section 37 appeal.
No, we are not upgrading. Sorry.
Lordship,
Yes.
it is an assigned matter.
Even then, yes.
Lordship, it's
No, we are not. Yes.
My lord, item number, serial number 117. My lord, it workman compensation appeal. This court has no determination for heard this matter.
Has no determination?
No, my lord. This is
Then
the.
it will appear as to be mentioned tomorrow and will release. Please hand over the slip. This will appear as to be mentioned tomorrow. Just remind us tomorrow, we'll release it. Yes.
Please, your lordships, to mention a matter, my lord. Impugned order has been passed, my lord, in my suit for permanent.
So what is this? Application or?
Your lordship, this is a stay petition that we are wanting
Application.
Stay application.
Yes,
my
yes,
lord,
hand over.
to be moving today, my lord. There is an extreme urgency.
Today it's very difficult to list it.
Your lordship, the
It can
problem
at
is,
best appear tomorrow.
your lordship, what has happened is we are challenging the
Why
inquiry
didn't you mention last
proceedings.
Friday?
Your lordship, what has happened? The impugned order passed on 11th, my lord. Thereafter, we got the certified copy on 12th, and on 14th, we filed the memo of appeal. Your lordship, the stay petition we want to move today because the inquiry proceedings have been fixed today itself, and we are challenging the inquiry proceedings, my lord.
Today it's not possible. Sorry. It can appear only on Monday.
My lord, at any time
Only
today.
tomorrow.
Any time today, my lord.
No, no.
If your
Hand over the
lordship
slip, you can directly appear tomorrow. Mention it before the forum. Yes.
Your lordship. May I file it for listing tomorrow, my lord?
Yes, do that.
Yes. Grateful.
Maybe I allowed to mention one matter, my lord. Item number 145 in today's list. Actually, new application has been filed in this matter, my lord. Can 3 and 4.
You want the applications to be heard first?
Yes, my lord.
Was there any direction that the appeal along with the applications will be heard?
No, my lord. Actually, there was an interim order which has been already expired. On
Give a notice to the other side and come. Give a notice to the other side, bring the other side, along with the other side, mention it. Yes.
Your lordship, this is an application for modification of interim
Application
order.
handover.
Yes.
Yes.
Your lordship, only one thing, may I intervene, my lord? Leave is required, my lord, for the matter to be listed tomorrow. Otherwise, the matter will.
একটা leave দিয়ে দিন তো এটা কালকে আসবে
My lord, may I be permitted to make
application or order 41
for order 41?
call on the list please. Accordingly, FMA 196 of 2025 is allowed on contest, thereby setting aside the impugned order bearing order number such and such. The respondent one bank and its men, agents, and officers are hereby restrained by an order of ad interim injunction from dispossessing the plaintiff appellant and his men and agents from the suit property, as well as from transferring, alienating, and or creating third-party rights and or interest in respect of the 50% ownership right of the plaintiff in the suit property till disposal of the injunction application pending in the trial court. The respondent number 1 shall file its written objection to the injunction application in the trial court, if not already filed, within 3 weeks from date. It is expected that the learned trial judge shall dispose of the injunction application upon giving adequate opportunity of hearing to both sides as expeditiously as possible thereafter, as far as the business of the said court permits. It is, however, made clear that the findings and observations made in this order have been arrived at for the purpose of considering the plaintiff appellant's ad interim prayer of injunction and shall not be conclusive at the stage of final hearing of the injunction application and or any further stage of the suit. The learned trial judge shall independently decide the injunction application and the suit without being unnecessarily influenced by any of the observations above on merits. Can 1 is disposed of accordingly, no order is to cost.
I am for the that matter.
But this is the matter in which the LCR was not coming from the learned.
Report was sought by us.
Report was sought, and my instruction is the LCR could be traced by much effort by the learned district judge Alipur. He personally was.
It has been sent.
It has been sent. That's my counterpart in the Alipur.
Let us just check up. Yes, yes. Original judgment and degree in matrimonial suit are not traceable. That is what has been challenged. What can be done?
But then my landed friend must be having the certified copy.
We have filed the certified copy.
We'll proceed on that basis then. Let's wait for the certification. It appears from the report of the Assistant Registrar, First Appeal Section, dated February 14, 2025, that the records of the matrimonial suit have been traced out. However, the judgment and degree thereof could not be found. Next para, the trial court records be sent immediately to this court, even if without the judgment and degree thereof, since the certified copies of the said judgment and degree are already on record before this court. Next para, as and when the records are found, the department shall examine the records, and if otherwise found to be complete, shall mark the appeal as ready for hearing, even without the judgment and decree of the trial court. If in the meantime the judgment and decree are traced out, the same shall also be sent to this court, which will thereafter be tagged with the main file. Liberty to the parties to mention the appeal for inclusion in the list as and when the appeal is made ready for hearing.
The paper books.
Yes, there is.
Those directions are there. Yes.
Grateful.
Thank you.
Since
Your
your
lordship,
lordship,
the section.
Unless it's stamped as ready for hearing, it won't be done. It cannot
Because
proceed.
in fact, I am told that it has gone to the where the records are supposed to be destroyed. From there. it
Lucky
could
that those could be found out.
My lord, I apologize for the fiasco that has happened.
You have no role to play in that, Mr. Mukherjee.
Okay. I had a very
You have no role to play whatsoever.
No, I had a very tormenting weekend.
Need not have. You have no role to play. Yes.
I do have.
grateful.
I'm up.
Thank you.
Item number 3.
Lordship, I appear for the appellant. In this matter, 27 January 2025, your Lordship asked for the report for
You have filed a condonation application. Other defects have been removed.
condonation application has been filed. The PR portion of the condonation application is also defective. I find from that
It has already been filed.
it has already been filed. That is Can 1 of 2025. Now the petitioner has filed this application on in person. As your Lordship, I filed the vocalatama to the department. He has also prepared the copy of the number of documents annexing the regularize the section 5 application. So I want to.
There is no question of regularization. You can file a supplementary affidavit.
This is a supplementary affidavit. Number of documents.
File it when the application is listed for hearing. What is the number? We have
That
not
is
mentioned.
Can 1 of 2024.
Oh, it's also. Well, we will direct the can to appear in the list. And when that is filed, they will take leave and file this.
This file.
There is no direction for service of copy on this.
No.
So we'll direct this to be served along. Very well. It is found from the report of the Assistant Registrar, SR section, dated February 6, 2025, that the defects have been cured, barring the delay of about 2 to 48 days. Since Can 1 of 2024 has been filed by the appellant for condonation of the delay, let the application be listed tomorrow under the appropriate heading. এটা application heading এ কালকে ক্যানটা থাকবে।
না আজকে হবে না কালকে।
Item number 4.
Yes, Mr. Mukherjee, what is the?
Sorry, Lord, last day, Lord, I missed out the matter.
But what is
I
the?
couldn't, Lord, I couldn't able to contact my client. If your Lordship, as a last chance, give me 1 week time to put in the requisite. If at all, Lord, I could able to contact my client.
Just let us once check up the report.
LC একটা না?
এসছে আচ্ছা one
One
week's
week
time
as
to
a
file
last
the
time.
requisite. It is found from the report of the Assistant Registrar dated February 14, 2025, that the records of the matter have not been received by this court, However, we are informed by the officer of our court that as communicated by the department, after the drawing up of the report, the trial court records have arrived before this court last Saturday. that is on February 15, 2025. Full stop. Accordingly, the office is directed to examine the records, full stop, examine the records and give a report as to whether the same are found complete, full stop. On the prayer of learned counsel for the appellant, appellants, the time for depositing Tolobana postal cost and other requisites for effecting service of notice of appeal upon the respondent number 2 within a week from date. Full stop. In default, let the matter be listed under the heading Lozima for final orders on February 25, 2025.
Great.
Thank you. You are for respondent number 1.
Item number 5.
My lord, I am for the appellant petitioner led by Mr. Parthopratim Roy.
Right.
My lord, this is my application for expedition.
Tolobana of ₹7 has not been filed, deposited.
My lord, kindly grant us some time, my lord. At that time, my lord,
File
it was not-
it, deposit it today.
My lord,
Pay 7 from your pocket.
my lord,
We'll give you 1 week, but
my lord.
the office report indicates that Tolobana of ₹7, along with written up notice forms for effecting service of notice of appeal on the respondent numbers 1 to 10 have not yet been deposited by the learned advocate for the appellant. Full stop. On the prayer of the appellant, the time for putting in such requisites is extended for a week from date. Full stop. In default, the matter be listed on February 25, 2025 under the heading Lauzima for final orders.
My lord, on that day, my lord, I placed this application, my lord, which is appearing in the list, my lord. That is for, my lord,
No,
because my lord.
no.
there are
If you
several-
deposit, in default only you have directed it to appear as final orders. If you deposit in the meantime, you can mention, wait for a week and then mention the application we will include.
My lord, grateful,
Indicate to us that it has been done
my lord, grateful.
and keep the necessary receipt with you, whatever.
I shall. Grateful.
Thank you. None appears for the parties at the time of call, full stop. It was recorded in the order dated February 10, 2025 that learned counsel for the appellants sought an adjournment for preparing the affidavit of service. Full stop. Next para, as a last chance to the appellants to move the applications, the matter is adjourned till tomorrow.
Number 7.
Seven, Lord,
My lord, in this matter, I appear for the defendant. I mean, led by Mr. Mitra, appearing.
Defendant is the appellant or the respondent?
Well, the defendant, defendant is the respondent is a defendant in the suit.
for declaration, my lord,
No, you are for the appellant.
if appellant.
Yes. What is the application for?
But I was paying for a short passover, my lord. Mr. Chatterjee was leading me.
Why so
Not
difficult?
a cop.
Lord, on the last occasion, Lord, should recall, Lord, order dated 25th of October 2017 was, Lord, indicated before
No,
Lord.
the application is for what?
The application is for injunction. Injunction was granted on 25th of October 2017.
Maybe come back tomorrow, my lord.
Why,
the,
Mr.
the paper,
Mitra?
the paper, my camera is made off from the court only, just I am not visible.
No, if you are otherwise ready, we'll hear you without the.
No, I'll tell you what, it been changed brief for us. And it been served us on last Friday, 2017 matter.
Come back tomorrow then, Mr. Mitra.
Yes, tomorrow.
Lord, we have
I'm
served
only asking
thrice
one
on
tomorrow.
his, Lord, I understand his predicament, Lord, but we have served thrice.
On the prayer of the respondent, the matter is adjourned till tomorrow. Come back tomorrow.
My lord.
Give your names, both of your names.
Item number 8.
My lord, I am for the plaintiff appellant. My lord, it is an
Yes, Mr. Das, what is the application for?
application for restoration along with an application under section 5.
What is the delay?
Delay, my lord, considerable delay because at the
How many days?
much more, my lord, 2 or 3 years.
2 or 3. Have you served copy on the other side?
I have served, but unless your lord,
Serve a copy and come back.
I have served already.
Did you direct you to?
No.
Then you have to serve. Mr. Das, you know. The applicant, the appellants stroke petitioner shall serve copies of Can 6 of 2024 and Can 5 of 2024 on the respondents, indicating that the applications shall be listed together for hearing on February 24, 2025. when an affidavit of service to that effect shall be filed by the appellant.
So instead of 24th, make it 25th.
Very well. 25th.
Date for dealers.
Thank you. February 25th as well. সকাল থেকে কিছুই হচ্ছে না।
I am from the respondent. Ms. Sushmita Sadati is appearing in this matter.
Yes.
She's coming. She's on the way. I'm praying for a very short password.
No, sort of. Was it, ma'am? What is
This relates to land acquisition. Initially, proceedings started under Act 1. Subsequently, my lord, land losers were not happy. They filed Section 18 application before the collector. Collector has passed on before the LA judge. LA judge has enhanced it, challenging that. I have filed the appeal, fast appeal.
Stay of
My lord,
operation.
there is an 104 days delay. My lord, we have served.
What is the ground?
Section 5
What is the ground?
application.
What is the ground for the delay?
My lord, kindly come to my lord, para 3, 211.
Red typism.
Well,
Will I condone the delay? Upon hearing learned counsel for the parties, we are satisfied that sufficient reason for the delay has been explained. Full stop. Accordingly, can 1 of 2018 within bracket old number can 8249 of 2018 is allowed on contest, thereby condoning the delay in filing the appeal. The other application is for stay. Stay, you'll have to deposit the entire amount.
Well,
You'll
we'll
pass
do
the
that.
direction. You have condoned the delay and they'll deposit the entire amount to the registrar, the usual direction. Can 2 of 2018 within bracket old number can 8266 of 2018 is an application for stay of operation of the impugned judgment and order, whereby the amount of compensation payable to the land losers has been enhanced. Full stop. Upon being satisfied that the appeal requires hearing on merits, we grant stay of operation of the impugned judgment and decree till disposal of the appeal, subject, however, to the appellant depositing the enhanced awarded amount with the learned registrar general of this court within 3 weeks.
Give us a 4 to 5 weeks.
Within 4 weeks from date. Push up. There shall be unconditional stay till a period of 4 weeks from date. Push up in default of such deposit within the said period, the stay order, the stay shall stand automatically vacated without further reference to court. Push up upon such deposit being made, the learned registrar general shall invest such amount in an interest-bearing account with any nationalized bank and furnish the particulars thereof upon being approached to the learned advocates for both the parties. Full stop. Such deposit shall be subject to the outcome of the appeal. The appellant shall you are for all the land, only one. Very well. In view of appearance of the learner of the respondent through
One respondent is there.
yes, in view of the appearance of respondent through the his learned advocate, service of notice of the appeal on the respondent is dispensed with. Full stop. The records be called for by special messenger at the cost of the appellant, which shall be deposited within a fortnight from date. Full stop. Next para. Upon service of notice of arrival of the trial court records on the learned advocate for the appellant, the requisite number of paper books shall be prepared and filed by the appellant within 8 weeks thereafter. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm deeply impressed.
Number 10.
None appears for the parties at the time of call. Full stop. Let the matter stand adjourned for the day. Last chance দিয়ে dismiss করি। Interest হারিয়ে ফেলেছে।
My lord, time for the appellant petition. And
Yes. Is there any caveat or have you served?
No, my lord, I have not served, my lord. There are 4 applications altogether, my lord. 3 are for substitution and 1 is for injunction, my lord.
Substitution within time?
My lord, 2 within time, 1 out of time.
Which are the 2 within time?
Within time, my lord, is can 2 of 2022
And
another one is can 4 of 2024, my lord. my lord.
You have checked up. These two
Yes.
are the within time applications.
I have
Those will allow right now.
my lord.
And regarding the others,
Others, my lord,
they are connected. Can
can
3 is for substitution and 5 is for condonation, must be.
my lord, there is three,
Oh, 5 is also substitution.
5 is also
The
substitution.
3 is apparently also within time. Check up. See, there is no prayer for abatement and setting aside.
3, perhaps, my lord, I have missed that application. My lord, 3, perhaps, my lord,
If you don't have a copy,
my lord, 3, I have copy. Probably I have missed.
check up.
My lord. These 2, my lord, are within time.
No, check up 3 also. Why
Yes,
keep
ma'am.
it pending?
Yes, my lord. Yes, my lord.
Check up, take your time, see whether it's within time. Within time once we'll apply, we'll allow, because the registrar can also do that. So that
My lord, here in paragraph number 5, my lord, it is written after setting aside the abatement.
Achha, very well.
Therefore-
So 4, it's the
Yes.
3, it's doubtful.
Yes, my lord. 3.
And 2 and 4, you are sure.
My lord.
Very well. Can 2 of 2022 and Can 4 of 2024 have been respectively filed for substitution of deceased respondent number 3 and deceased respondent number 15, namely Dilu Sheikh and Muslim Sheikh, respectively. Push up next para, since the applications are in form and filed within time, comma, Can 2 of 2022 as well as Can 4 of 2024 are allowed, comma, thereby directing the heirs and legal representatives of respondent number 3 and respondent number 15 in the appeal to be substituted as in place and stead of the said deceased persons as respondents in the appeal. Pushed up next para. The office shall carry out the necessary rectifications in the memorandum of appeal within a fortnight from date. Pushed up. The petitioner shall serve copies of Can what is 9926 now?
996 for injunction, my lord.
Can shall serve copies of Can 1 of 2019 within bracket old number Can 9962
Right.
of 2019, comma, along with Can 4 of 2024 and Can 5 of 2024 on the respondents, comma, including the substituted respondents, indicating that the applications shall be listed for hearing in the monthly list of March 2025. Full stop. The appellants shall file an affidavit of service to that effect on the returnable date.
My lord, that is Can 4, my lord. Mention Can 4, that is Can 5 of 2022, 24, my lord. Which is, my lord, directed to
We have directed to serve Can
5 and 1.
Oh, I said 4.
4.
No, Can 3 and 5.
3.
1, 3 and 5 have to serve. আমি কি 4 বলেছি কোথাও? 4টা 3 হয়ে যাবে। 1, 3 আর 5 serve হবে। Thank you.
Anirban Dash. Anirban Dash.
Within time যেহেতু registry allow করতে পারো। আচ্ছা, portal. You are for the petition. There is no caveat.
No, it has been admitted. Lower court record has arrived. In the meantime, sole respondent expired.
Oh, this is for substitution.
Yeah, substitution and delay of 75 days.
So then you have to serve.
I have served. It has refused and come back.
There was a direction for service.
No.
Without direction, that service is of no effect. You know the rules.
They refused.
Learned counsel for the appellant shall serve copies of Can 2 of 2022
Not Can 2, Can 3 and Can 4.
Achha, shall serve copies of Can 3 of 2024 and Can 4 of 2024 on the respondents, indicating that the applications shall be listed in the monthly list of March 2025 when an affidavit of service to that effect shall be filed by the appellant. Unless we direct a rule to be issued, you cannot serve a copy. I mean, that has no effect.
It has been accepted and thereafter.
Whatever happens. If they appeared, we could have taken up because they have instruction to appear. But if none appears, that is not a good service.
Well, I tried.
The rules, our rules say that when an application is filed for the first time, the court has to issue a rule. We have substituted rule by direct service through postal mode just to expedite matters. But that's a substitute of the rule which cannot be issued prior to moving the application. So your prior service we cannot take note of. Yes.
Lord, I am for the appellant, my lord. Last occasion, my lord, directed for service, but service is not completed, my lord. Kindly adjourn this week, my lord.
Why? Why didn't you serve?
Not service is not complete, sir.
Acha. Learned counsel for the appellant submits that service is not yet complete on the respondent. Accordingly, on the prayer of the appellant, the matter is adjourned till February 24, 2025.
Yes,
Sir,
affidavit of
proper service. What is the application?
Lord, it's a section 5 application, my lord.
What is the delay in filing the appeal?
Yes, my lord. 45 days delay.
What is the reason?
Yes, my lord. I have stated in paragraph number 7, 8.
What has been stated? That is what we are asking.
By 35 later stage, my lord, I have applied for the certified copy, and my lord, my erstwhile conducting advocate, my lord, was failed to take some steps, my lord.
Despite service, none appears for the respondents. Full stop. Upon being satisfied that sufficient explanation for the delay of about 45 days in preferring the appeal has been made out in the application, we allow Can 1 of 2024, thereby condoning the delay in preferring FAT 438 of 2023. Full stop, the appeal be deemed to stand registered and admitted accordingly. Full stop, the affidavit of service filed today be kept on record. Any other application
No,
pending?
my lord, only one application.
We will direct you to put in the requisites and all. The appellant shall put in due requisites for service of notice of appeal on the respondents within a week from date. Full stop. The trial court records be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. Full stop. Upon service of notice of arrival of the trial court records on the learned advocate for the appellants, the appellants shall prepare and file the requisite number of paper books within 8 weeks thereafter. Liberty to the parties to mention the appeal for inclusion in the list as and when the appeal is ready for hearing.
46 days. 45.
ও 45 বললি আচ্ছা 45 টা না তন্ময় 46 করে দিও ডিলে নাম্বার অফ ডেজ দ্যাটস দ্য রিপোর্ট অফ দি
Lordship, I am praying for a short passover.
You move the matter. What is the matter about?
Here for the respondent.
Yes, you move the matter.
Lordship, I am not the advocate or
So what? You are asking for time, you are competent to ask for time, you are also competent to move the matter.
Lordship, kindly short passover.
No passover.
Learned advocate Mr. Dilip Kumar Samanth is on his way to
Nothing
the
doing, nothing doing. Either you dismiss the matter for default or you move the matter. What is the application for?
The original appellant has already died, has passed away.
No, they have to move the application, not you. It's not your application.
Sorry.
Give your copy to them.
I just updated. I
Give your
have not been served with any substitution application. They were required to serve.
Learned counsel for the respondent submits that copies of the substitution application bearing Can 3 of 2024 have not been served on the respondent, full stop. The appellant is accordingly directed to serve copies of Can 2 of 2023 and Can 3 of 2024 on the respondent, comma, if not already served during the course of the day. Full stop. The application shall be listed under the same heading on February 19, 2025.
Can 2 has been served.
If not.
The substitution is.
If not, yes.
Grateful, Lordship.
Please tell Mr. Whoever is appearing on behalf of the appellant to serve copies by today. And you give your name only, please. Yes.
But I'm told, my lord, Mr. Devan Sinha is appearing for the appellant. He has not come to court, my lord. He is probably ill. But I'm told, my lord.
You are for the respondent.
I'm for the respondent.
So what do you do? Whatever you say.
I've got no, I have not filed my objection also on my personal ground.
So we'll keep it when? Ask him.
After a week, my lord.
Very well. On the prayer of the appellant, the matter is adjourned till February 24, 2025. ফাইলটা দিয়ে দিন কি বলছে আজকে হ্যাঁ
On the last occasion, Mr. Orijit Bordhan.
accent তন্ময় your name is being yes.
On the last occasion, Mr. Bordhan craved leave before you lost it to file supplementary affidavit, but we could not file the same. The client has been transferred to North Bengal. I am praying for a fortnight's accommodation.
On the prayer of the appellant, comma, the matter is adjourned till March 4, 2025. সকাল থেকে কিচ্ছু হচ্ছে না। সে আমরা নিচ্ছি, যদি উকিলরা না পারে আমরা কি করবো?
18 Lord,
বেড়ে যাবে না এগুলো লিস্টে
my
পেন্ডিং।
appeal.
ইয়েস,
Led by Mr. Mukherjee, my lord, Mr. Shoktinath Mukherjee, my lord, perhaps he should be there. Is she ঢুকেছেন? ঢুকতে আটকে গেছে কোনো কথা, আমরাই এগোই আছি।
appeal along with the application was to be heard.
Yes. Lord, Mr. Chaudhary is leading. Also,
Mr. Chaudhary is there. Okay, good. You are for the respondent.
Yes, I am for the respondent number 2.
Two.
I am for the respondent number 1 and 4.
I led by Mr. Aniruddha Chatterjee.
And what about 3? 3 is also anyway, let us take up the matter. Yes, they'll come. Yes, Mr. Chaudhary, what is it?
My lord, as I was submitting on the last occasion, my lord will take up the impugned order first again.
But do we find
my lord will find it page 35 of the stay application itself.
Because it's easier to
Yes,
follow
it'll be
from one.
easier.
Yes. Just give us a brief background, Mr. Chaudhary. Suit is for Section 34 Trust Act. Something was.
No, the suit is for cancellation of a indenture of sale made by one of the Shebites, claiming herself now to be the sole Shebite, where the property has been sold on the basis of an order passed under Section 34 of the Indian Trust.
You said that's not applicable?
I'm saying that is not applicable at all.
Fair.
And we'll see the interim order of President no
Yes, the
caveat is
court
filed.
finds that district judge has that order has not been set aside by any higher court.
Yes, basically the grounds are very few. It says, till this date, the order of the district
Yes.
judge has neither been set aside nor declares it ineffective by a higher forum. The disputed matter pertaining to the sale deed is pending, which is this present suit. There's no other suit.
Yes.
It says, be that as it may, said dispute at best be decided after giving an opportunity of being heard to the other side, not at this early stage. That is not a ground for refusal of an ad interim order. Then it says, during the pendency of the suit, if there is any transfer or alienation or creation of third-party interest respect suit property, will be affected by the decree or order of present suit. That means he's saying list pendants. List pendants can never be an answer. Otherwise, Section 30, order 32 goes.
Yes. Very well. So, just show us, Mr. Chaudhary, what is the relevant law, religious and charitable
I
endowments.
believe Mr. Mukherjee is here.
What books will you rely on, Mr. Chaudhary, Mr. Mukherjee? Religious and charitable endowments. That
yes, madam. The first.
So the acts, if you give the names, we can bring the
Madam, the
books.
section 1 of the Indian Trust Act is sent.
You have got 2 copies.
Indian Trust
We require Trust Act and that.
Trust Act is here.
Give the name on a sheet of paper so that we can bring the books. এই বইটা চট করে আনিনি।
কপি করে দেবে না তোমার কাছে এক্সট্রা কপি আছে।
Yes, Mr. Mukherjee, we are waiting for you.
My lord, I am unable to establish the link. My lord, I am waiting from the beginning.
No difficulty, Mr. Mukherjee. We can't see you, but we can hear you. You can start your argument if you like.
May I proceed?
Yes, please. Absolutely.
I beg to appear, my lord, on behalf of the petitioner appellant.
Yes.
To appeal against an order refusing to pass ex parte interim order.
Right.
My lord, before I place the facts, kindly turn to a judgment of the Privy Council, which contains a genealogical table. My land friend will kindly hand over the copy of 43 in the 17 minutes. It's a judgment of 1943.
You are for the other side.
But at page 116, I will find the oh, genial. He said from the Privy Council.
Privy Council, let's talk about it.
Very good. Fresh copy, Rich. Fresh copy.
Privy Council.
Kindly hand over the fresh copy.
Yes, Mr. Mukherjee, you have got copies of the judge. Yes, please.
Second page, my lord, contains a genealogical table.
Yes.
My lord, Shital Chandra Banerjee was the owner of several properties in Calcutta.
Right.
He, my lord, made an endowment in 1922. I mean, laying down the line of devolution. His son was Pancharan. Bhavatarani was his Pancharan sister, and another sister was Sudhanshu.
This pertains to the same property, the present suit property. Acha, very
Yes,
good.
yes, present
Yes.
suit property.
Yes, yes.
So that's dispute.
Acha. Yes.
My lord, Shital made his endowment in 1922. In 1929, he made another endowment covering the same properties and laying down a different scheme.
Yes.
The matter before the Privy Council was the legality of the second endowment of 1929, when he had already made an endowment in 1922. Now we'll kindly turn to the head note of this judgment. The
Yes.
Supreme Court says you can't, the second endowment is void. Having made an endowment in 1922, that will govern them. And secondly, if one of the donees, those who are named in the first endowment as a Sebayat, there will be a number of donees. If he dies below, then the property does not devolve upon the successors of the donee, but reverts back to the founder. And the heirs and the successors of the founder will get it. These are the two propositions let down.
But it was held that on the death of the son who had survived the founder,
Yes.
Sebaiship should go to the sons very well, and not to the heirs of the father. All right.
Yes. Now, my lord, this is the governing judgment in this case. On the basis of this judgment, there is another judgment, the Calcutta High Court.
Yes.
The Calcutta High Court held. That's the page, my lord. Kindly, my lord, turn to page 129 at page 146.
Yes, 146.
146, the relevant paragraph is there. The
Yes.
division in judgment of your lordship's court.
Right.
At page 146, ignore the
Yes.
first part. First part is unique, my lord, as usual. Mr. Justice Sanjeev Banerjee. Kindly turn to page 146.
No, 140. Cannot be 146. That's a district judge's order. Some other page must be.
Oh, my lord. This is the concluding part of the
Ashalata got by the second this deed.
Yes.
And Diptilata by the first.
Yes.
All right.
That is, my lord, now this is settled. Ashalata was not the Duni and the first. And Ashalata comes into the picture when the property reverts back from the last Duni to the founder. In the second round of devolution, Ashalata gets it. And then we get it. Am I clear to your lordship?
Yes, Mr. Mukherjee, but it was held that even Ashalata's heirs became entitled to a part of Diptilata's estate.
That is in second round.
All right.
Diptilata is one of the donees in the first round. Diptilata died issueless.
Therefore, it went to
So as her heirs, Ashalata, some of Ashalata's heirs would get.
After Dipti's interest goes back to the
As
Shital
Dipti's heirs. Very good. Yes.
and Ashalata. And we are coming through Ashalata.
You are claiming through Ashalata?
We are coming through Ashalata. We are several of us.
You are those heirs of Diptilata who are also heirs of Ashalata?
We are not the heirs of Diptilata. Diptilata died issueless.
Acha.
Sir, I mean genealogical
Kindly
chart
turn to
देबो
the
sir.
larger list of dates. the larger genealogical table.
Very well.
That's at page, my lord.
But this is the genealogical chart, Mr. Mukherjee.
So you become Ashalata's heirs also.
Genealogical chart.
Admittedly, I am now, I'm one of the Shivas.
Very good.
But Dipti's heir, my lord, is Ruby.
Lordship would find Apna Mukherjee, my lord, here is the plaintiff.
Yes. All right. Yes, Mr. Mukherjee.
My lord, what's the subject matter of challenge in the suit filed by us is a sale made by Ruby. Kindly look at the second larger genealogical table, which we have annexed to the petition. That's at page, my lord.
128.
Huh?
128. 128.
28, my lord, kindly tell.
But sir, সেটার থেকে better copy I have supplied.
Oh, genealogical table.
Better genealogical chart I have supplied.
Where is Ruby in the better?
Ruby is here.
Right hand corner bottom.
It's look like a direction to the general hospital by the same name.
This would be easier for you.
All the same, yes. So we have got Swapna and Ruby in the chart, Mr. Mukherjee. We hope that you have also got a copy of this new chart.
Yes, yes. I have
Sincerely
got
hope
copy.
that. I mean, because we are following a different chart than that annexed at page 128, which has been handed over
The
by your
synopsis is there in the judgment of the Privy Council.
Yes.
The Privy Council judgment shows the original device.
Yes,
And
yes,
also
right.
the original genealogical table. Now, my
Yes.
lord, Ruby, as you also got Ruby,
Ruby, yes.
right hand corner, my lord, Ruby.
Ruby sold out the entire property as Shebait.
Yes, as the sole survivor.
Soul Shiva.
Admittedly, we are also the survivors. And Ruby's second part of the contrivance was to go to the district judge, file
Yes.
an application under section 34.
Mhm.
She goes along with the prospective purchaser, and the
Hmm.
district judge permits the sale. The subject matter of sale is 20 acres of land. About the area, there is some confusion. 20 acres is about 60 kathas. But I find from the petition, it is 97 kathas on Dr. Radhakumar Mukherjee Lane,
Hmm.
parallel to Rashbihari Avenue in Baliganj.
Mr. Mukherjee, is it an admitted position that both Ruby and Swapna are co-Shebites? I mean, both are Shebites.
That's not a question of admission. It's a question governed by the High Court division judgment.
Very well. But Ruby posing to be the sole Shebite has transferred.
Yes.
By approaching the district judge under section 35 of the Trust Act,
Along
which is
with,
also not maintained.
along with the prospective purchaser. It's not a case
Very
that the
well.
district judge is directing
Yes.
an advertisement inviting option.
All right.
Just come back in 5 minutes.
Yes.
District judge permitted the sale at
Yes.
a price of 1,75 lakhs.
Mm-hmm. Yes.
20 bighas or 97 kathas, I don't know which one is correct. But it's a substantial property
Yes.
on Baliganj, on Dr. Radhakumar Mukherjee Lane, Baliganj, at a price of 1.75 crore. The registration value was 39 crores.
Page 194.
When did the sale happen?
2015.
All right.
16th June 2015. Page 143.
Page 143. Very well. Yes.
We filed an application challenging the sale on these grounds mainly. There are other grounds.
All right.
Fraud and the deed is void. Why
Yes.
void? The settled principle of law. If there are several Shabas, one Shabbat cannot deal with the property.
Right.
Ruby posed as the sole Shabbat, executed the transfer the deed and transferred the property. Now, this is not a matter of adjudication. The adjudication is over.
Right.
Division bench held I am one of the Shabas.
Yes.
Through Miller Ashalata. The deed is void. The sale deed of 2015, as a matter of law, there is no question of adjudication.
And Mr. Mukherjee, your second point is that section 35 Trust Act, that order is null because that section is not applicable. Is that also your point?
Your Lordship will kindly recall.
Yes.
Section 34 is advisory jurisdiction. Advisory. It does not permit.
Thank you.
Is there any Trust Act available to your Lordship?
I have supplied. I have supplied.
Yes, Mr. Mukherjee. It
And
has
it's
been.
under Section 1.
Yes.
Trust Act does not apply to religious endowments. Trust Act does not apply to religious endowment. Section 34 applies to secular property. Section 34 is inapplicable to religious endowments.
Section 1, do you say?
Yes, Section 1 exempted properties at the bottom of
Right.
Section 1.
Savings, yes. Right, absolutely. Very well, Mr. Mukherjee.
Invoking Section 34 was the design to give it a color of legality when the section doesn't apply. First, the person approaching is incompetent to deal with the trust property. She does it, she applies, gets an order along with the prospect. Section 34 is always a liberty to apply inviting law quotations. At 1.75 crores, the property is sold to them.
So at least a strong prima facie case was made out so that injunction ought to have been granted. That's your case.
My Lord, I'm on another point.
Yes.
My Lord, if I don't get an injunction, if I'm subjected to respondent, at best, my Lord, the transfer will be void. The transfer will be subject to the result of the suit. My Lord, they have advance of amount above the table and below the table. That will remain chasing me forever, this devoted state. I wanted to stop it, whatever mischief has been done. Don't deal with the property, get the disposed of as early as possible. The court says respondents, and the court says I am going to hear the other side. Because the other side cannot have any hearing in this matter. Everything is covered by judicial adjudication.
And respondence itself is not a ground for non-grant of injunction, probably Mukto Keshi Doha and other cases also.
So this long back, late lamented Shama Prashanna Raisode was appearing below.
Yes.
Mukto Keshi.
It was 88 Calcutta. 25.
Not 25. I have not that judgment.
It was overruled on another point, but this point was sustained.
Yes.
And that has been followed by one recent on
That judgment also, Mr. Mukherjee. And if you cite, it will be hit by Benami.
Excuse me for 2 minutes.
Yes.
This is the outline of the controversy involved in this matter.
Yes.
Kindly now turn to the order of the court. Court says respondents. Court says I'm going to hear the other side. All that we pay, stay your hands for the time being.
Right.
And the last point, my Lord, is something, my Lord. Hindu religious trusts are treated to be charitable. Something akin to an endowment under Hindu law.
Yes.
Is considered to be charitable. Charitable and religious are, my Lord, connected in Hindu law.
Yes.
That is well treated, my Lord, in Dr. Mukherjee's book, my Lord, 25 pages. There is one chapter, my Lord, in Dr. Mukherjee.
Yes.
Mr. Kormukar.
Yes. 404, sir. Page number 404.
I'm saying, my Lord, the court will be somewhat cautious. This is a printed one, English.
Yes.
Law of charity. Your lordship is the representative of the sovereign. Will be somewhat not cautious in dealing with Devotha property. Devotha property is a religious property, a charitable property, and Laman. Somebody, my lord, is dealing with the take all lecture, my lord.
Take all lectures. Yes, we are at page 404.
Kindly read, my lord, one page.
Yes.
This is quoted with the Supreme Court, this passage, in 1959 Supreme Court.
(942).
Yes. Now, this is the short.
Not a perspective.
Yes, on the concept that in English law it's the crown which is transferring in the capacity of penance patria, but here Hindu law concept is different.
My lord, Hindu law of religious trust is something akin to charitable trust.
Right.
May not be, DT may not be any perpetual infant, but your lordship will not permit the DT to file a suit
Right.
like an infant. Now, my lord, these are facts which cannot be disputed. Now, is it not a proper case where the court will hear the matter at length, in time restrain them? The challenge has come to the fore. Other side, the purchaser is aware of it that we are challenging. He will be very keen. We have to wash off his hands and induct somebody else. We wanted only to stop the further affectation.
All right. So that is all, Mr. Mukherjee.
In short, without that is all.
So let us hear the other side. If there is any other point by them taken by them, then you can.
I'm waiting here, Lord. I'm waiting.
Thank you. Yes.
Led by Mr. Chatterjee, my lord, though I begin.
Begin and end, Mr. Chatterjee, if the other Mr. Chatterjee does not come. Follow Mr. Mukherjee. See how precise he is. And the presumption is people who are precise, they have a better point. What are your answers to his issues?
First, I raise a point, my lord. This is against an order of ad interim order of injunction refusal. My lord, when this order was refused.
Just a moment, my lord, just a moment.
Yes, Mr. Mukherjee.
To mention, my lord,
yes,
that this Ruby herself has obtained an order of stay status quo from the High Court, and the transfer was made in the subsistence of the order of status quo with High Court.
Page 147. First order of
Ruby,
147. 147.
Ruby obtained the order from the High Court status quo. In the continuance of status quo, she transferred the property.
All right. So it's also in violation of the status quo order obtained by herself.
Yes.
That was in connection with what suit, Mr. Mukherjee?
This property is the endowment.
Achha, very good. That was against whom? You are not a party there, obviously.
It was a separate suit.
The suit was for.
But all the same, there was a status quo order which bound Ruby also.
Ruby was bound. Ruby obtained it.
They shows the plaintiff must be.
Yes.
In some of the lists.
This is against the Milord lessees.
Lessee. But the status
Parties were directed to maintain status. You are bound. You are Ruby.
The issue was entirely different.
Status quo. You are bound by your own status quo order. You violated that. What are your answers to this? Yes, Mr. Chatterjee.
This is Milord an
ad interim
order of injunction.
So,
Milord, this ad interim order of injunction was passed, Milord, way back in the year, Milord, refused or rather, Milord, Milord, way back in the year 2021.
Use the microphone so that Mr. Mukherjee can also. 2021 order.
Yes.
Yes.
Now, Milord, we are in 2025.
This was the 2023 order.
We are in 2025.
When was the appeal filed?
The appeal was filed in 2023.
Appeal was filed.
So appeal was filed in 2023, but it is now being heard. So now the court.
I'll tell you, Lordship, on
Yes,
that.
yes,
I'm,
yes.
I'm not even coming to that, but I'll come back later. Because they are claiming a right from the 2022 deed. The 2022 deed, my lord, does not form part of the, my lord, the scheduled property. Let them show that first. Before anything else, my lord, I'll come back to that technicality. 22 deed does not talk about this property at all.
22 deed is a part of this annexure.
Yes, is a part of this document. So if 2022 deed, my lord, does not give, is not a part, then
every question goes. Yes.
Every question goes. Let them first show that it is a part of that. Whether I have a right, whether I don't have a right, they need to show their right in present time. So they don't have a right under the 2022 my lord, deed at all. There is nothing on record to show that this property which they show, my lord, first point.
What is the page number of 2022 deed? Give us that also.
Page 39 and the translated and typed copy is page 58.
True. True. Number one. Number two, my lord, at the ad interim stage,
yes,
kindly turns to their plain form.
What is that, Mr. Chatterjee?
Separate.
Very well, no difficult.
Five separate.
Plain TS. 910 suit. Plain color complaint.
Lord, your lordship will find I'm not even taking your ad interim stage, not even taking your lordship to the entire. I am saying that all what has been stated is true. Even then, they are not entitled to an ad interim injunction. See paragraph 32.
Paragraph 32, yes.
My lord, I'll just read with your lordship. The cause of action of the above suit arose on and from May 2019. And my lord, the plaint was filed in 2023. So ad interim doesn't, my lord, in any manner, they are not entitled to an ad interim order of injunction. Because my lord has held, in where my lord was a part of the division bench, that even a 7 days delay, my lord, they were not entitled to an injunction. Judgment to the.
That depends on the facts of the case.
Absolutely. But here, my lord, there was no facts.
Number of days depends.
My lord, your lordship, my lord, said that if there is so much of urgency and you knew about the transaction, the court said you should have come within a day or two. This is my lord's division bench. Here, my lord, 7 days delay, the High Court, the division bench said you are not entitled to an ad interim injunction. Here what happens is, my lord, from 2015 the sale, 2019 they admittedly no, 2023, my lord, they filed the suit, 2023 they filed the appeal. Number of times, my lord, the appeal has been heard before different benches, my lord, never even prayed for an ad interim order. Never even prayed for an ad interim order. I am making this submission because I've been there from day one, along with Mr. Kormokar in the other side. Apart from Mr. Kormokar, my lord, there have been other lawyers who have changed from time to time, but Mr. Kormokar was there. So there was never, my lord, one day there was a prayer, my lord, for an ad interim injunction. Now, the right to the property. If the 2022 deed goes, if the 2022 deed does not have this property, my lord, they don't have a right to the property. So whether the sale is good or bad, they have no right to say. This is not a public interest litigation. Let them show, my lord. I beseech, my lord, your my learned, I can't call him senior.
Super senior.
He's not even super. He is my great grandfather.
Mega senior.
Then say great senior.
Great grandfather.
He is great.
Absolutely.
Duper is not applicable in court of law. So you can you have to say only super, not super duper.
My senior, then his senior.
Whatever. But what has he done wrong?
So he needs to show. No, he's seen 4-5 generations of my.
Obviously, we know that.
He
needs to show what? Tell him what he needs to do.
That this 22 deed contain, my lord, this property.
Okay.
Simple. There's nothing beyond.
So make your comprehensive arguments on the other points also if you want,
So
if you have any.
this is below
This is all. Yes.
interim stage. Now,
But don't make a new argument if you have to have a rejoinder. You won't have a rejoinder, but even then.
now the other part is the point of limitation. This is a deed which was below executed in 2015. And now, my lord, the suit is filed in 2023. Registered deed. My lord, I need not tell your lordship, my lord, Mr. Mukherjee's my lord argued matter, British Airways, which was my lord deferred to my lord by firstly the Honorable Division Bench of Justice Chatterjee and Justice Banerjee.
With Justice Chatterjee.
Kabir. Referred to Justice Kabir. Justice Kabir my lord said Justice Chatterjee's view was correct.
All right.
So if the suit is not maintainable, my lord, they are not entitled to an injunction. Now, Shopna is not claiming a right, my lord, as an owner of the property. She is claiming a right as a Shebayat.
Yes, obviously.
So that Shebayatship comes to her from the 22 deed.
Yes.
So that 22 deed doesn't contain this property.
Very well.
My lord, kindly have a look at the schedule and satisfies my lord's self. Lord, at the
143.
79.
No, 7.
Stay application. Looks to the schedule, my lord. This is the schedule of the 22 deed. Lord, we have a lot of defense with respect to this, but since it's ad interim, my lord, I'm not, my lord, placing that before your lordship right now. I'm on the basis of their own plaint itself. C79 looks to the schedule. Every which way, my lord, your lordship, my lord, sees I'm not placing. It's quite a big one. There is nothing, my lord, with respect to the plain schedule, which your lordship will find
in the plaint.
1A Radhakumud Mukherjee Sharoni or Cornfield Road. Just, my lord, compares the two deeds. That's it. The plaint is at page 21 of the schedule is at page 21 of the plaint. And, my lord, the deed on which Mr. Mukherjee relies, as per his own submission, my lord, is the 22 deeds, looks to the schedule. It's not a part of this. Because Shitol, my lord, had a lot of properties. Some of them probably which have been added in this, my lord, are not even his properties. But that's a different aspect altogether. 1A Cornfield Road, my lord, is nowhere in the deed at all. And if I'm not mistaken, my lord, even the Chouhoddi, my lord, has not been given. So they can't even, my lord, understand what property, my lord, they are trying to, my lord, come up with.
Stated some part of these holdings have fallen on the eastern boundary of Cornfield Road.
Eastern boundary of Cornfield Road. Nothing. Lord, I've checked it.
So nothing stated in the plaint to connect.
Nothing. Even the plaint is silent. Why it is from
the
there?
trial court did not give this reason.
No, the trial court did not give this reason. But my lord is an appeal, my lord, under Order 41 Rule 33. Trial court did not give this reason at all. Maybe it was not pointed out at that point of time because this is ad interim.
But some of the properties go very close to Cornfield Road.
It doesn't. In my respectful submission, my lord, nowhere near. Now, he's a plaintiff. He can't say, I am going close to that property. I am somewhere close around. My lord, it can't be in the air. Property has to be, my lord, definite. If there was any ambiguity, my lord, the law of contra preferentum, it will go against him. He is the propounder. He is claiming a right on the 22T. He is the propounder, if Mr. Kormukar understands that meaning without laughing. He is relying upon it. Yes. Transport Corporation's case. I can scold him this. Transport Corporation's case, my lord, he is putting it forward. He is the propounder. Say any ambiguity anywhere goes against him. And I am saying come directly. That show me that this is a part of that 22D. That's it.
Yes, strategy, anything else?
My lord, the limitation part, your lordship has,
Limitation you have said.
I've said, and also it sees, my lord, it's a 1915 document, which they are now trying to challenge.
2015.
2015. I'm sorry.
2015 document challenging 2023 registered deeds. So limitation none.
Knowledge 2019. That's his prayer. That's his, my lord, paragraph 32.
Yes.
So
Yes.
ad interim for 4 years cannot happen.
That is a different aspect.
Yes.
That's delay,
No, that-
defeats equity,
Yes.
and limitation also
Yes.
2015.
My lord, I was relying upon that division bench, if your lordship sees, Justice Shonjit Banerjee and my lords. My lord, kindly take it up one, the GP. We had given it to your lordship.
On the last occasion. that.
তোর কাছে আছে? ওখানে গেলি না মামা।
এটা না আমার ঘরে কাউকে বলুন এটাকে প্লেন করে দিতে রোজ। এটা তুলবেন। হ্যাঁ, এই জিনিসটা হ্যাঁ, টোটাল জিনিসটা মানে খাঁজ থেকে সরিয়ে প্লেন করে দেবেন। এটাই আমার অসুবিধা। কাল থেকে করে আমি উঠে গেলে রিসেসে করিয়ে দেবেন কর্প থেকে। এই জাজমেন্টটা রেসপন্ড হচ্ছে। ওখানে কপি আছে।
My lord, I can give your lordship another copy if your lordship wants.
It could be. এটা একটা Yes.
Lordship, kindly takes up, my lord, paragraph 14. I read with your lordship's, my lord.
Yes.
Unfortunately, on the basis of the averments in the petition and the grounds as to urgency indicated therein, the trial court in this case could not have been prompted to take up the matter with the kind of alacrity that has been shown. The trial court did not indicate any reasons as to why it was necessary to pass an ex parte ad interim order, and the petition did not contain adequate grounds in such regard. The construction had already commenced. That the construction had commenced on March 5, 2017 could not have been the guiding factor in this case, since, on the plaintiff's version, the plaintiff was aware from November 2016 that the appellant herein proposed to make a construction on the land in the appellant's possession. Even if the plaintiff had rushed to court within a day or two of the construction commencing, some modicum of reasons or rationale in its favor could have been discovered. But the plaintiff waited for more than a week before coming to court, and in between there was a complaint where the innocuous allegation of the boundary wall of the plaintiff was being damaged, not of a person wrongfully constructing on the plaintiff's property. The only object of the present exercise is to ensure that trial courts are careful in exercising their discretion to entertain interlocutory applications ex parte or pass ex parte orders. It is only in the exceptional case that an ex parte order may be passed when it appears to the court that denial of the order at such stage will amount to the action being defeated, or an irreparable injury or gross prejudice being occasioned to the suitor. So here is a case, my lord, 7 days construction started, court says, no, you can't. My lord, in our case, he looks to the timeline, 2015 deed, 2019 knowledge, that's their own plaint. 2023 suit, whether it's not even possible on the ground of limitation is really doubtful. Then 2023 to 2025, my lord, appeals heard everywhere. Nowhere, my lord, a prayer for an ad interim was ever prayed. Ever prayed. My lord, there was a confusion as to even the admission of the appeal.
Why?
My lord, because it was admitted only on the last occasion. It was, my lord, heard.
No formal order of it.
No. Because they wanted to hear out the appeal, they started off arguing the matter, my lord. Several lawyers changed in the meantime. Whenever the matter would come, some different lawyer comes in. Nobody has prayed for an ad interim injunction. So if you could stay without an injunction, my lord, for 10 years, there is no reason why, my lord, just today, my lord, on the basis of an ad interim, my lord, has to be granted in its favor.
An application for addition of party.
And my lord, there is a prayer, there's an application for addition of party, which my learned friend, Mr. Banerjee, my lord, is probably.
Who is he?
They have filed.
Let them move it if they want.
So move could be not.
Mr. Banerjee has purchased in the meantime.
No. Now the problem again is, kindly looks to the array of the parties. Array of parties, below, the plaintiff is Swapna. Swapna becomes, below, the Shebai. May I ask this question to myself, from where? There is nothing. She's just given herself that Shebayat. The others, she's not the sole Shebayat. Take it for granted, my lord, whatever he's saying is true. I have a different take on it altogether. But at the ad interim stage, I'm only on the plaint. But may I ask this question to myself and for your lordship's kind consideration? How does Shopna become the sole Shebai? And then where are the others? They're not parties. The other party, my lord, is Shubhadeep, Orko, that's me. Priya, my lord, is my wife. And Tirupati is Mr. Banerjee. So there are definitely, my lord, if what they say is true, there are many others, my lord, who are Shebaites to the property.
The Tirupati assets has purchased.
Purchase.
And Priya and Orko
Orko is me.
Shubhadeep.
I have sold. My mother sold. So from mother, my lord, I.
So you are also Shebaites.
Yes. Yes.
So
But
she has
we
made
have-
the Shebaites parties.
No, there are many others. If they are to be said to be what they are saying is true.
As per their genealogical table also.
Table. Their genealogical table. There are many others.
All right.
Many others. So none of them were made parties. My lord, what happens is there is a lessee who is in possession. The entire thing, in my respectful submission, my apprehension is being orchestrated by him. Now, who gets benefit, my lord, if an injunction is granted today? The only person who gets a benefit, my lord, is that lessee, who has absolutely no right, my lord, to remain in possession.
No, even if it is transferred, he retains his right as a lessee.
Gone, the eviction suit there. So what he will do is, there is an eviction suit. My lord, there what he
By
will do-
Tirupati assets.
Yeah, by Tirupati na kiya, both amrai korchi. Ruby had initiated, my mother.
Achha.
So what he will go and say there is that, look here, there is an injunction, status quo, you can't remove me. So this is the, my lord, the actual picture, my lord, before your lordship. So my point, my lord, ad interim, 10 years they are there without an injunction. Limitation is a point. On the face of it, on the basis of, my lord, their argument, that section 34, my lord, they have not, my lord, moved beyond, my lord, whatever they have moved. They are taking adjournments there. Thirdly, my lord,
Section 34, they are parties.
Section 34, they have now
Already obtained
filed
an order.
application. They have filed an application.
Section 34 was disposed of.
Disposed of, now they filed an application. And
For what?
has passed an order, my lord, here. For
Recalling.
recall. And that order, my lord, was stayed.
Impugned order record করা আছে
It's recorded, my lord, in the impugned order, if your lordship sees.
What
So they've gone there.
the Section 34 order has been stayed.
Yes. The state.
How can section 34 order be?
Section 34 order has been stayed, then
রিকলিংটা যেটা ফাইল করেছে যে আমাদের
must be something else.
সেইটা শুনানি হচ্ছে ওখানে পেন্ডিং আছে দে আর টেকিং অ্যাডজর্নমেন্টস দেয়ার আর এখানে যেটা কথা না স্টেট
No stay of that order.
এখানে রেকর্ড করেছে সেখানে ওরা পেন্ডিং আছে সেই কারণে
Anything else, Mr. Chatterjee? Let us cut short. Yes.
Hello. Now, the 34 part below, they are also, my lord, going there, my lord, and they are
Shorter recall.
agitating shorter recall. They have not moved that 34 order. No moving. My lord, I'll tell your lordship, I can show your lordship that they have not, they have prayed for an adjournment there. They prayed for an adjournment there. Then, they've also now filed a suit, my lord, in the High Court.
For what?
In the High Court on the same ground.
Challenging what?
Challenging the same thing, Shebaiteship. Now saying that I am not the Sheba.
No, suit is for declaration that
That I am not the Sheba. They've done that as well. So, and who does it? Only Shopna. Why? Because Shopna is in the hand of that lessee.
no, why can't one of the co-sharers point out the defects if there is any?
One of the co-sharers,
Co-Shebites, I'm sorry.
whether he's a co-sharer, whether he's a co-Shebite. Milord, whether what is he claiming? He's kindly looks to the prayer in the plain once. He is claiming, my lord, for only cancellation of the deed. If there is a dispute with respect to her Shebaiteship, my lord, and we have sold, my lord, as a sole Shebaite, there has to be a declaration with respect to her Shebaiteship. Her right in the present time, that is in dispute. I have sold, my lord, as if I am the sole Shebite. So if
At the ad interim stage, we had to go by the plaint.
by the plaint itself, I am saying, my lord, even
The
34
plaint, she must have stated that she is a Shebaita as per the
Have a look
genealogical
at-
table.
Kindly have a look at paragraph 2. That the plaintiff number 2 is the Shebaite of the said deity and duly authorized in the meeting of Shebaites duly held to represent the cause of the plaintiff number. Who are the other Shebaites? May I ask this question to myself? This is not a public interest litigation.
The one rule 8 leave has not been sought.
Nothing. Nothing.
Order 1 rule 8 may
Order
not be
1
applicable.
would have come in, Milord, but this is a private litigation.
Private litigation, right. Order 1 rule 8 is not strict.
But the others have to be made parties. Others have to be made parties. It's not that, Milord, that she is the only Shebai.
All right.
And this is, Milord, another point on 34 as well of this specific relief. Shebaitship, Milord, is the only thing in dispute, not prayed for. Though Akamma has come into play, I can't say much on that. But even then, Lord, here on their own right, their present right to sue is something, Lord, which is very important. Their present right to sue. This is most important. 22 deed is the only deed, not a part of the disposition.
Let us hear. You cited Wonder Limited and something.
No, GPT,
1990
GPT
supplementary SCC. For what purpose? You want to add some ground or adopt their ground? Mr. Chatterjee, let us hear. Mr. Bhatt. Yes. What is the other ground?
My lord has seen, my lord, the composition of the suit. My lord has been shown, my lord, the plaint. My humble submission was that, my lord, the existence of breakneck urgency is a jurisdictional fact for grant of ad interim order of injunction. That existence has got to be pleaded and prima facie proved on the basis of the materials on record. If your lordship kindly takes up the plaint just once. Mr. Chatterjee has, my lord, very ably, my lord, pointed out, my lord, the date of their knowledge. Kindly let us see, my lord, what they say, my lord, regarding the urgency. Now, my lord, the plaint is verified in June 2023. And if your lordship sees, in my reciprocal submission, there is nothing in the plaint which would show a breakneck urgency to the extent that unless an ex parte ad interim order of injunction is not granted, any of the settled principles of ex parte ad interim order of injunction would be invoked here.
Paragraph 26, 27 are there.
Please see, my lord, paragraph 26
of the plaint. We hope it's a replica. This will be a replica in the injunction.
Yes.
As is
So, my lord, this is in context of their knowledge. My lord will have to see the urgency in the context of their knowledge of the alleged offending act. If their knowledge of the alleged offending act is in the year 2019, someone sits over it for a period of 3 years, and then in order to show, my lord, 4 years, in order to show, my lord, typical urgency, comes up with a single line paragraph saying, yesterday I found that some people were loitering around the premises, with a registered deed being the thorn in their flesh, then, my lord, this will not be urgency for the purpose of your lordship's consideration. My lords are, my lord, under when your lordships are examining an ex parte ad interim order of injunction, either in appeal or as the first court, my lord examines it, there has to be a meaningful reading of the plaint. Whatever is there in the plaint has to be taken to be true and correct, but it has also got to be meaningfully read. Now, if I sit over whatever is my alleged offending clause for a period of 4 years, how can I, in the year 2023, my lord, say that, my lord, there is such breakneck urgency that, my lord, the trial court could not have waited even for 7 or 10 days after issuing notice to hear out the defendants, my lord, and finish off the suit? This is number one. Number two, that there are other Shebaites in the fray appears from paragraph 2. Please come to paragraph 2.
Yes, they have empowered him or her.
Allegedly, they have empowered her. This is a statement. My lord will take this statement, my lord, on the basis of some material which is brought on record along with the plaint. Now, my lord, with the changed law, the documents have to come up along with the plaint and the originals have to be filed. Otherwise, my lord, leave has to be sought under Order 7, Rule 14 for filing the originals later. But all the documents have to come in along with the plaint. Lord, kindly see, my lord, what are the list of documents annexed to the plaint? This is, my lord, this is well, my lord, with the knowledge that a 714 provision is there in the statute book. Now, kindly see, my lord, the verification. Even the affidavit is defective. The affidavit ought to mention the documents which are in the power, possession, and custody of the plaintiffs or their advocates, which are being brought, my lord, on record along with the plaint for the purpose of bolstering whatever case is made out in the plaint. It's not as strict as Commercial Courts Act that if they don't bring it at the first instance, they can never bring it in. But they have to bring it in. Where is this so-called, my lord, resolution of the Shebites? Who are the other Shebites? If the other Shebites are already there in that resolution, then why are they not parties here? How does the court believe that this is one lady who has been brought forward when this lady was not there in the scheme of things ever? My lord, anyone who comes to court in the capacity of a Shebite has to say, I am a Shebite, I am looking after the property, I am doing Sheba Pujo, I am doing, my lord.
So you're taking a point of non-joinder also of the other.
100%. Non-joinder, my lord, of necessary parties, these are all co-Shebites according to them. My lord, treating the averments in the plaint to be true and correct and giving them extra mileage to see whether they are true and correct are two different things altogether. No extra mileage can be added. They have to be treated to be true and correct with a meaningful reading. Kindly come, my lord, to see.
Where is the extra mileage when it goes against you?
No, the extra mileage is if they
There is
say
extra mileage. You have to read it as it is. They have said that yes, other Shebites have empowered.
Other Shebites have empowered me.
They have to primarily satisfy the court by document.
There's the empowerment, number one.
In the injunction application, any document was annexed regarding that.
Even 714, there is no document, my lord, which comes in along with the plaint. That it had to come in, it has not come in. Now, my lord, with your lordship, see another thing. Please come to the plaint and be satisfied when I submit that apart from paragraph 2, there is not a single whisper of this person having ever done Sheba Pujo or looked after the property of the Sheba deed. Please, my lord, come, my lord, very quickly scan, my lord, after the history part is over.
That absence of averment that she has ever done a Sheba Puja may not be
Shebiteship is a office
fatal.
attached to property.
Maybe may not be fatal at the ad interim stage.
That line of judgment, Lord.
No, she has stated that she's a Shebite. She claims to be a Shebite.
She claims to be a Shebite.
At the ad interim stage, we do not. They need not. We do not go to the hilt. I mean, and they need not prove their Shebiteship to the hilt by saying that they also perform Sheba Puja.
Because
they claim right of Shebiteship by virtue of a 1922 deed.
But then the non-joinder point remains.
Not the other points remain.
Other points remain. As far as this
Sheba
point is concerned,
Pujo by her may not be a.
What I'm trying to bring forward is something, Lord, which I would have developed had this been, Lord, a further, a later stage of
later
the suit.
stage of the suit, definitely
The
relevant.
point is simple. Shebiteship is a property attached to an office. The hereditary nature of that comes in, but as Bijon Mukherjee's, my lord, judgments reveal, my lord, in that treatise, this right of Shebiteship or of property would not automatically be exercisable as a right estate in fee simple. It has to be accompanied by the discharging of obligations that office puts in. That is why Justice Sanjeev Banerjee in the division bench that was passed did not pass any final order declaring anyone to be a Shebite. Lord, kindly come to that order just once. That's been shown as the sheet anchor of their case. Page number 12, order. This was passed in connection with a 711 application being allowed by the City Civil Court, this Honorable Division Bench.
129, starts at 129, yes.
Please see, my lord. There was just a doubt expressed that maybe this lady will also have a right of Shebiteship. Maybe. It was kept, that doubt was kept.
At order
reserved.
7 rule 11 stage, that is the only thing the court can say.
The 711 and sent it back for trial. And then that suit has been dismissed now.
No, that was a different suit.
Same suit.
This
Not this suit. Not this suit. That was a different suit, not this suit at all. This Justice Shonji Banerjee is
For the same reliefs.
for the same release by another Shebai, in which there are other persons were there. Then there was an Order 7 Rule 11 filed. The 711 was allowed. Against that, appeal preferred. In the appeal, Justice Banerjee's division bench, my lord, came to a prima facie conclusion that maybe dismissing the suit at the 711 stage was not proper. Sent it back for consideration for trial on all issues, keeping everything, including the points in the 711 open. My lord, kindly see, my lord, the order. And that suit has now been dismissed. Please see. Please see page 129. Does this order remain today? First of all, my lord, see the purport of the order. Then, my lord, will see whether the order remains today in the scheme of things.
What order remains?
My lord, page 129, my lord, will kindly see.
Yes, 129.
My lord has seen, my lord, it has been filed by Roktima. That's the other alleged Shebai, my lord. Sister.
Yes.
Versus Ruby Ganguly and others. Now, my lord kindly sees.
How does that bind this person?
It doesn't bind this person. It doesn't give this person any leeway also. They are trying to say that Justice Shonji Banerjee's division bench has stated that insofar as the other sister is concerned, she would still, her heirs would still get Shebayachit by way of succession. But Justice Banerjee was pleased not to make any such observation finally. Kindly come to page 134.
Yes. It cannot be conclusively said at this stage that the plaintiffs have no case to carry it to a trial. So that's not a conclusive adjudication on that.
For the reasons aforesaid, my lord kindly sees the second last paragraph from the bottom.
That is what we said.
Yes.
Cannot be conclusively said.
And
So
therefore,
at the Order 7 Rule 11 stage, it's not a conclusive finding. Cannot operate as res judicata.
Including the points under 711 are kept open.
Yes, it's obvious. There has to be. Yes.
From Roktima and Swapna, they are the same people.
Yes.
They are the same.
Yes.
So there, Roktima's right with respect to the leadership, that's not dismissed.
That was not turned down. This ultimately that suit has been dismissed.
This is for default.
Dismissed.
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 Not
Dismissed.
adjudication.
Dismissed or default?
Dismissed what?
No Order 9 Rule 13.
Order 9, no, 13 no, 9.
No.
9.
9.
Order 9, Rule 9, to the best of our information.
Anyway, very well.
So, my lord, this order of Justice Shonji they can't be heard saying it over again. So that's that. This ought to have been pointed out to your lordships, my lord, when this matter was being moved. I am sure, my lord, my learned senior friend has not been properly instructed, my lord. This ought to have been pointed out. The fact that Justice Shonji Banerjee's division bench order was made in a suit by the sister, that suit travelled at the 711 stage to this honorable court, matter remanded back, all points kept open, including the point of Shebayachit, and that suit ultimately gets dismissed for default, has not yet been. And Swapna is a party to this suit. Swapna was sitting, my lord, on her haunches. There she could have gotten herself transposed as a co-plaintiff. There she could have taken steps. So she was aware of, my lord, some action or the other taking place in the year 2017.
Very well. Mr. Banerjee, anything else?
On 20.
Slightly.
Tell us, quick, be quick. Yes. So we'll come back and hear you. But please conclude within 5-10 minutes. Yes.
All right. কর্মকারকে ফোন করো। হ্যাঁ বাবু কথা বলেন, বাবু কথা বলেন। এই আদার্স এবার কি পারি করতে দরখাস্ত করে করা হয়েছে তো? হ্যাঁ হ্যাঁ আচ্ছা, আর একটা কথা বলছি, ওরা তো দেবল তো স্বীকার করেনি। ঠিক আছে, আমি আমি সেটা নিয়ে ভাবতে হবে না। আর ওই সুদটা কবে ডিসমিস? সঞ্জীব ব্যানার্জি গো। কি? আমার একটা কথা শোন, আমার কথা শোনা, আরে আমার কথা শোন। ও সুদটা আমাদের সুদটা ফাইল হয়েছিল এই সুদটা 1923, এই সুদ তার আগে ওটা ডিসমিস হয়ে গেছে না পরে? সেটা ভাব। পরে হলো আমার খুব পরে হয়নি তো সুদটা ডিসমিস। আমি এই সুদটা সঞ্জীবী পরে হয়নি তো, পরে হলে আমার খুব ভালো। হ্যাঁ কবে হলো? 23-এর পনেরো হয়তো আমাদের এই সুদটা 23। হ্যাঁ ঠিক আছে। হ্যাঁ কে ছিল? আচ্ছা ঠিক মনে আছে তো? আর অ্যাডমিনিস্ট্রেশন অফ দিস হতো। হ্যাঁ ও ডিক্লারেশন খালি declaration of by the right and administration। ঠিক মনে আছে তো? ঠিক মনে আছে তো? আচ্ছা ঠিক আছে চল।
Yes, Mr. Vanessa.
Only, my lord, these are, my lord, basically the points after, my lord, reiteration of what certain additional points which I have given, my lord, for your lordship's consideration.
Yes.
Only one judgment, Wonder versus Antox, is absolutely settled law. 1990 supplementary Supreme Court cases, page 7 to
You are
7.
respondent number 4
I am respondent number
in the appeal?
4. 4.
Yes.
Copies are there with your lordship.
Yes, yes.
The scope of interference, the scope of interference, my lord, at the appellate stage, my lord has seen, my lord, from the order concerned that all that the trial court wanted, my lord, was for the heard in connection with the matter, and found 4 things, 3 of which are completely factually correct. One, that lease pendants thing was contrary to, my lord, Muktokeshi, where Mr. Roy Chaudhary had argued that lease pendants is a proper defense to the grant of injunction. That was negated by this honorable court. But then 3 of them factually what they say are correct. This deed is a registered one. There's a dispute regarding that registered deed which is still pending. The order of the district judge has not yet been changed. Coupled with all that, he said that in the facts and circumstances of the case, he would want to hear
What portion, which portion of Wonder you are relying on, Mr.
Wonder is
which paragraph?
Paragraph 14. This also, my lord, relies upon another Supreme Court judgment, my lord, in.
Yes. What is the proposition?
Kindly, may I just place for paragraph 14 for your lordship's consideration? The appeals before the division bench were against the exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principles of law relating to grant or refusal of interlocutory injunctions.
Yes.
An appeal against exercise of discretion is said to be an appeal on principle. Appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below, if the one reached by the court below was reasonably possible on the material.
Right.
The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the matter at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court's exercise of discretion. After referring to these principles, Gajendra Gatkar in Printers versus so-and-so, these principles are well established, but has been observed. Law as to the extent of to the reversal by a court of appeal of an order made by a judge below in the exercise of his discretion is well established, and any difficulty that arises is due only to the
Yes, Mr. Banerjee, you have seen.
That's all.
Thank you. Yes, Mr. Mukherjee has to reply. Yes, Mr. Mukherjee, if you're there.
My lord, may I take up the first point argued by Mr. Chatterjee?
Yes, yes, please.
That the property was not there in the 1922 deed.
Yes.
My lord, there is a fine distinction of law that if there is an existing debutto, a DT, and a debutto estate, and then a subsequent dedication is made, it will be part of the original scheme. The donor of the subsequent donor of the property cannot change the original. Admittedly, there is a 1922 deed. Admittedly, there is a debutto. If this property was not there, if the property is subsequently dedicated, the original scheme will govern. We are relying on 17 then appeal for the line of succession that we become a Shivite under the original scheme. And the origin, my land friend Mr. Chatterjee's client has transferred the property as a debutto property, has asked for permission under section 30 as a debutto property. Debutto of the given DT. If there is a subsequent dedication of the property, the dedication will be subject to the original scheme. If I am a Shivite under the original scheme, I become a Shivite in respect of this property also.
Mr. Mukherjee, with our limited understanding, we could not understand your point. If do you mean to say that even if the property was not a part of this scheme, of this deed?
Original deed, not the scheme. Original deed.
This is 22 is the original deed?
Yes, it is supposed it is not the part of it.
Then
subsequently it is given to the DG by third person. Even then the original scheme will govern it. I become a Shivite.
Where is the pleading to that effect that subsequently it was given?
No, this is admitted as the deed of the DG.
What is admitted?
He is applying under section 34 as a deed of the DG.
Sir. All right.
Sale deed too.
No, all right, very well. And in that section 34, they also rely on the 1922 deed.
Yes. No, 29 deed.
On the 29 deed which has been set aside.
They are admitted to be the part of the release foundation.
And sale deed is also
subsequently given. Then it will govern by the 22.
Don't make comments in the meantime. Please take it.
May I explain it over again? In
Yes,
1922 is a DT established. A DT is dedicated.
Yes. Some properties.
A debutto is established.
Yes.
With a line of succession, Shivite let down, and a line of succession also let down.
Yes.
Now, Milord, a stranger comes and makes a donation or dedication of some other property, the same DT. It will not be separate debutto. It will be same debutto, same set of the Shivite. Subsequent donor cannot insist upon a different scheme. Now, in this case, the property is admitted to be debutto. Admitted to be debutto of the DT.
No, here there is a case made out that there was a subsequent donation of this property to the.
Mr. Chatterjee is saying, I am not concerned. It is treated to be debutto property. Admitted to he himself is saying he applied as a debutto property. He claims to be the Shivite of that DT.
Is there section 34 application or plaint, whatever, that has been annexed anywhere?
136, 136.
Let us find out from that what was their case.
Yes, yes, my lord, kindly have it read.
Para 1.
All right.
Even a stranger, here is a family member. He is a Shivite from original scheme. Even a stranger does it, he cannot change the scheme. He cannot change the nature of the debutto. In all well-known debuttos, my lord, there are subsequent dedications.
Yes, it becomes a part of the debutto, definitely.
He cannot change the dedication, original. Scheme he cannot change, he has to accept it.
Hmm. All right. Very well. This is on the first point.
First point. My second point is, my lord, urgency.
Urgency, yes.
I am not challenging the 2015 deed in this application. This application is for anticipatory injunction. Not what has been done, but I am apprehending that they are going to do.
You came to know about this deed in the year 2019, Mr. Mukherjee, as per your plaint case. Now,
That
they
are
say
the main relief trades paid for it. Main relief is in
Yes.
respect to the 2015 deed. I am not asking for an interim order in respect to the 2015 deed. I am asking an anticipatory injunction so that they may not further transfer it, deal with
No,
it.
I mean, was there no threat when you came to know of the deed? At that point of time, didn't you perceive a threat to
No,
that property being
when I
sold?
applied for the injunction, I applied
Yes.
for addition of party. They filed an affidavit in opposition. In that, they were claiming it to be secular property. Mr. Kormokar will show it, and then we decided to pray for an injunction. They were converting this property to be secular property. Only then we applied for injunction, anticipated
Affidavit in opposition filed where?
In Can 2. Can 2.
Can 2? Before in this appeal? Then how could that relate back to the date of filing of the suit?
Sir, at
No.
8.
It is
No.
subsequent fact. For that I have applied for anticipated. Originally, matter is
Mr.
not
Mukherjee, let us understand this clearly. When you filed that injunction application in the trial court, what was the occasion for you to wake up after this
future
4 years?
transfer may not be done. Future transfer may not be
Then
done.
what is the ad interim extreme urgency for grant of ex parte ad interim, which is a
Because they were
testimony?
treating it to be secular and going to transfer it.
Sir, page
Treating it to be secular property. Going to transfer. Kindly have a look at it. They are now claiming it to be secular property. Previously, I challenged in the main suit the 2015 deed. I am not asking for an interim order in this 2015 deed. I am asking an anticipatory injunction. Anticipating further things to develop. Kindly look at it, not there.
They filed an opposition where? In which proceeding?
When I applied for additional part.
In this court, in the appeal?
Lord, we behind the trial court.
Trial court?
Then they filed the affidavit and then we come to law.
Probably not, Mr. Mukherjee. In the trial court, there is no affidavit. And even if there was, in connection with this suit, that couldn't relate back to the date of filing of the injunction application. So on the date of injunction application, you had to have an urgency.
Injunction application was filed thereafter.
Sir, Lord, may I?
Ask Mr. Mukherjee if you can.
Sir, suit যখন ফাইল হয়েছিল, that is page 271. That's the urgency. 271 page is the urgency.
Yes.
Pending appeal, they came up and filed an affidavit to our application for addition of party, indicating that this property is secular and it is not Devottu.
In this appeal?
In this appeal.
Kindly below, I made a mistake about date.
271 page is our ground of urgency. We tried to mutate their name as a secular property. This is the first step they took in furtherance of the sale deed.
That's why we came.
They are now negating this as a Devottor estate and proceeding is at a secular property. That is 271.
That is post facto. After the ad interim order was passed by the trial court, we have to see only at the juncture when the ad interim was refused. We are sitting in appeal over that.
Page 271 is pre-suit. 271 document is pre-suit. That is dated 17th of August 2022.
What do they do by this?
They are applying it as a secular property.
This is not even mentioned in the plaint.
This is the cause of action of the plaint. One of
Was
the
that?
This is the annexure.
From the plaint? There is no annexure to the plaint. Maybe to the injunction. It was the show us from the plaint. Anywhere mentioned in the plaint?
Page 25, para 25, page 15. This is the notice that we are talking about. That is at page 271. This is for the first time that we come to learn that they are physically trying to deal with this property as a secular one. Now we come up in appeal, we file an application as under Order 1 Rule 10, including for addition of party of the other share buyers. In that, some of the share claiming to be share defendants, the defendant number 2 and 3, they file an opposition, or defendant number 1 file an opposition, and they say that this property is a secular property and they are entitled to deal with it.
Very well.
This is what Mr. Mukherjee was.
All right, Mr. Mukherjee, we get your point on urgency. And what about the other points that?
My lord, delay in paying for interim order
Yes.
or ad interim order is not taken to be seriously when the objector is guilty of fraud. Objector is acting mala fide. That's a Mr. Karmakar.
The judgment site, sir.
Karo.
2007, volume 9, SCC 304, paragraph 9.
Who is objecting? Who is guilty of fraud? Who is guilty of diversion of devoted property into secular property, seeking to make an attempt to abuse it? This is an objection never entertained at their instance.
Right.
Delay will not cure their fault. Approach the section 34 court mala-fide. Both join hands. Is it a fault which can be cured by delay?
All right. Yes.
You
What about?
Kindly
Sorry.
remember, yes, Lord. I'm sorry.
No, Mr. Mukherjee, sorry. But what about non-implement of the other kosher-bites?
I have applied for them. You Lord also remember, even a worshipper could have filed this. A worshipper could file the suit without the bill. When the devoted property user is being diverted, I am not asking a relief for possession. I am not asking any personal relief in this case. I am saying your dealing is mala-fide. Your dealing is contrary to established rules. How could you convert? But you are more guilty because you are in the position of a quasi-trustee. Claiming to be the sole trustee, sole survivor, you are converting the devoted property to for sale.
All right.
This is not an objection can be entertained at the instance of such a person who is making an abuse of his status. That is below Supreme Court case below one paragraph kindly read. Mala-fide, this objection cannot be raised by him.
Very well. Another point was taken, Mr. Mukherjee, by Mr. Chatterjee that this suit is barred. Why shouldn't that suit be held to be time barred? 2015, date of registration should be noticed.
And kindly turn to section. Have you got kindly, my lord, if your lordship has got a copy of the Limitation Act?
No, yes.
Lord, kindly excuse
Two
me.
limbs of that probably.
Kindly turn to section 94.
94. Article 94.
Yes.
Hey, I'm sorry, Article 94.
It's Article 9. Thanks.
Hey, Karmakar.
Lord,
Mr.
Mr. Karmakar is busy laughing, Mr. Mukherjee.
At me, my lord, I am always laughed at, my lord.
Nobody
I'm
dares to laugh against you, Mr. Mukherjee. Nobody has that.
Mr. Chatterjee, তুমি তো বলছিলে কি বলছো পড়ে যাবো আমি
Mr. Kindly turn, my lord, to Article 94.
Yes.
What is the commencement of the period of limitation?
Right.
It's a question of fact to be decided.
Hmm.
12 years from when the transfer becomes known to the plaintiff.
All right. Very well. Very well, Mr. Mukherjee. So at best, it's arguable, even if they succeed in their point that this is a secular property. It's arguable, so there's a prima facie case, injunction ought to have been granted.
They cannot argue, my lord, it's a secular property. Their predecessor was a party to the 1917 and appeal. They can't
Alright.
argue this point.
All right.
They are claiming to person, they are claiming to be survivors. They are
Yes.
governed by the 17 level. They are governed by the judgment of Justice. Kindly turn to one page of Justice Sandeep Banerjee's order.
129.
For that.
And the internal page 4.
স্যার একবার সেল ডিটটাও দেখিয়ে দেবেন স্যার
Yes. 129, internal page 4. Yes, page 4.
My lord, kindly read that paragraph, my lord, at 130.
We are reading. Yes.
Kindly excuse me for a second.
No, we'll read it. Yes.
I beg to read out. Tamil channel. Kindly excuse me, sir.
No, Mr. Mukherjee, it's all right. We have seen the paragraph. Yes.
Last paragraph, below last but one paragraph.
Yes. We have seen that paragraph only. Page 1.
Ashalata's ears are coming in.
Yes. 132 and 134 in similar light.
Similar light.
All right.
This is binding for the present. And my lord, the question of discretion. Mr. Banerjee has cited my lord a Supreme Court judgment. My lord, this is the principle of section 170 of the civil procedure. Appeal court has the same power as a trial.
Yes.
In any good textbook, particularly Sarkar, your lord, you will find several judgments.
Yes.
Where discretion is used. If the discretion is reasonable, not perverse, then the appeal court will not interfere, even if the appeal court takes another view.
Yes.
These are the cases under section 170 of the criminal civil procedure code. Now, my lord, if the trial court does not consider anything, does not consider binding judgments, the points are covered, it's not unreasonable. I am relying upon Privy Council judgment. I am relying upon the division bench judgment. A property is the property of the DT. The DT is taken care of by the court. Your lordship as the courts as the representative with sovereign power will not look into it. You are only preventing further delay, not depriving anybody in possession, not depriving anybody of enjoyment. Only not transfer. Don't deal with it until the matter is out.
Yes.
The transfer of 2015 is not disturbed. Only don't transfer because the matter has come to the fore. On the board, everybody will be inclined to wash up their hands and get out to the prejudice of the Devotar state. This is
very well, Mr.
a well-known judgment. Interfere with the discussion. The discussion is unreasonable, not considered anything, and applied below the doctrines least vendors.
Very well, Mr. Mukherjee. Thank you so much. Yes.
It
So
will
this
go.
is all, Mr. Mukherjee. We are closing, and we'll hear them only, the respondents only on this judgment which has been cited. No further rejoinder to rejoinder. Only this 2007-9, malafides and fraud, Mr. Chatterjee and Mr. Banerjee. Mr. Chatterjee in the previous order, yes. What is your answer to this?
Sorry, on 94. Except 94, Article 94. And then come back to because this is related Mr. Mukherjee's submissions. 94 says
yes,
to set aside a transfer of immovable property comprised in a Hindu, Muslim, or Buddhist religious or charitable endowment. So the first question that I raised was, it is not. And then by whom? Made by a manager. Made by a manager. So clearly, my lord, they are not claiming to be a manager. Or they're not saying I am a manager. There is a distinction between a Shebayat and a manager. First thing, number one. The first argument made by my learned by Mr. Mukherjee, my lord, was with respect to that there has been a subsequent dedication. There is no subsequent dedication.
You have relied on
Nothing. I relied on the 29 deed. My lord, my relying on a deed doesn't make that property, my lord.
Admit that it belongs to a.
My lord, what they are saying now. I am saying that.
But did you approach the court under section 34?
In my defense here before your lordship, the approach is that this is a secular property.
In the section 34 application, what did you plead?
It's a 29 deed.
29 deed.
Yes.
Confers it to the DT only.
I am saying 29. This was a part of the 29 deed.
29 deed conferred it on the title of
Separate
that property.
Completely. 22.
But on the DT, the DT was at the receiving end.
Deed is said to be bad, wrong.
You relied on the 29 deed.
Yes, I relied, but they are saying that 29 deed is.
Our question is very simple, Mr. Chatterjee, whether the 29 deed gave the property to the DT, not to the DT.
29 deed is said to be void.
The 29 deed, which is said to be void, did it confer rights and title on the DT?
Not claiming.
What did you claim?
They didn't have a defense.
What was your section 34 application?
My section 34 application, my lord, was, in my respectful submission, superfluous because it doesn't
That
apply.
superfluous application did not contain a pleading that 29 deed
My lord, even
gave
if
the
it-
property to
I
the
say, my lord,
DT.
even if it contains, does it
You are
become
not. You are
dedication?
avoiding the question, Mr. Chatterjee. Our simple question is whether you claimed in the section 34 application that the 1929 deed conferred title in the property to the DT.
No,
Yes or no?
Very well, I'm saying yes. Take it for granted, yes. Then what happens there? My lord, if that 29 deed, they are saying, my lord, is a question, is a void document. And my saying that it's a Debottor property doesn't make it Debottor.
Yes.
It needs to be a dedication.
Mr. Chatterjee, what is your answer to this?
I am saying secular.
We are not reopening the arguments.
My lord,
What is
here-
your answer to this?
This is my lord, a land acquisition matter where, my lord, the state's action cannot be defrauded by way of, my lord, fraud, by way of delay. And that in a civil proceeding on, my lord, the Order 39 Rule 1 and 2 at an ad interim stage, what is the urgency? Completely different. Now, very importantly, my lord, one thing, since they were allowed to, my lord, kindly have a look at the plane in the suit.
No, we will not reopen
My
that.
lord, kindly look
No,
into it.
no.
My lord, because there was a party, my lord, your lordship allowed them
No rejoinder to
also
rejoinder.
bring
No.
in this. Kindly,
They
my
were
lord,
entitled to
just
this.
for a second.
No.
Kindly allows me one minute. My lord, that suit which was filed by the sister Ruktima, where she prayed, my lord, that the properties could not be dealt with. Where Shopna was also a party. That suit, my lord, was dismissed.
That you have already argued.
Yes, my lord. Can
Why
you
are you
look? The
repeating
prayers are, my lord, that this cannot be, my lord, this sale was under challenge. This very sale.
Very well. Yes, Mr. Banerjee, what is your, we have heard you, Mr. Chatterjee. Mr. Banerjee, what is your answer to this judgment only?
Paragraph 9
Yes.
has been relied upon.
Para 9 years.
100%. Learned counsel for the respondents our attention that the same notification was set aside by the High Court, and the said order of the High Court was also upheld by this court by dismissing SLP such and such and SLP such and such.
What is your point, Mr. Banerjee? What do you want to say?
There was a notification under section 4 and 6.
Yes.
That notification was set aside by the Supreme Court, by the High Court, not interfered with by the Supreme Court when it came up there. Under the same notification, when this particular, my lord, writ petition was considered, their delay or acquiescence will be of no effect. That is, my lord, the ratio. A notification which has been tainted and found to be set aside, if under the same notification the present writ petitioner was belatedly claiming relief, that would not stand in the way because the notification is not there. It's void.
Already gone.
How does, my lord,
And also, Mr. Chatterjee's point that this is not a
not
not a proposition in respect of ad
ad
interim
interim order of
prayer,
injunction.
which requires urgency on a different footing. Thank you.
I have not found any judgment which says that urgency can be done away with by granting an ex parte ad interim order of injunction.
Thank you very much. We'll close arguments on this, but we'll not pass judgment right now. We need to look into it. We're not passing any ad interim order because it was not there. We're not
Never
passing.
saw.
Hearing is concluded. The matter is reserved for judgment.
We understand the assurance will remain. There was
They have
assurance
given
from
an
the other side.
assurance previously.
There was assurance.
Since they have till date not transferred, we don't think they are their strategies there, Mr. Banerjee.
এর
They-
মাঝে করলে তো ক্ষতি
তোর
হবে,
কি?
আমাদেরই ক্ষতি হবে,
10 বছর ধরে নিয়ে হঠাৎ করে এখন-
আমাদেরই ক্ষতি হবে। আমি যদি এই
They'll have to
সময়
arrange for so many things before the judgment is passed. এটা একটু অ্যানেক্স করে দিতে হবে। এটা অ্যানেক্স করতে হবে। আমি একটু সাজিয়ে দিচ্ছি, তা নাহলে পরে ঝামেলা। এইটার সঙ্গে একটু স্টেপল করি। এটার সঙ্গে স্টেপল করতে হবে। এইগুলো স্টেপল করে দিন। জাজমেন্ট গুলো একসঙ্গে রাখবেন।
There's a pending application that they are not pressing.
addition of
That application will dispose of along with this, I mean, consequentially, as we do in the other matters.
We haven't pressed, so we haven't.
Yes.
Press for a formal application. Nobody is opposite.
We are definitely.
Lucas in your opposite.
No, no.
এই বইটা ওদের, হ্যাঁ। এই বইটা ফেরত দে। Can you take out photocopies? It's because it's an old book.
Lord, I shall supply the photocopies. Lord,
If you can,
kindly
please
promise
do.
me, Lord, I shall supply.
Of this.
কোনটা?
বিজন মুখার্জি।
Yes.
I
But be careful because it's a not so
Scan and
dilapidated condition.
I'll scan and do it.
No, but there
I'll
are
do that.
scanned versions available on the internet of বিজন মুখার্জি।
That will do. That will suffice for us. এই বইগুলো সঙ্গে যাবে, পাঠিয়ে দেবেন।
মুখার্জি স্ক্যান ভার্সন আছে ইন্টারনেটে।
লিমিটেশন অ্যাক্ট কি আছে ওনাদের দিয়ে দিও। আর একটু আমার আর্দেলকে পাঠিয়ে দেন। আর্দেলকে ডেকে আপনি না কাউকে দিয়ে ওদের ডেকে নিন। Thank you. Call on the next matter. Yes. Show us next matter.
Item 90.
No paper book has been filed as yet.
No.
You have to file paper books.
Earlier occasion, you has to directly to file an opposition and reply thereto.
That's okay.
And
It will be for the opposite party, my lord. Senior is engaged in another courtroom number. I have completed the evidence of opposition and the
File it.
yes, my lord. But the problem is I have another copy for
Haven't you served copies of the
never
affidavit?
served copy.
Why not?
serve, my lord.
A limited time was given to you.
I can serve
By
now. my
5th
lord.
February. By
21st of January, we directed you.
But at that day, I have affirmed the same, my lord. At that day, I have affirmed my lord.
Could have given copies. Hand over copies anyway. We'll extend the time for reply. What is the application for alimony?
Yes, please.
You are the husband.
I am for the wife.
No, she's the husband. You are for. Why are you dealing the matter just not to give alimony then?
My lord, I'm just
Was any ad hoc direction given?
Already given.
My lord, I'm
50,000.
advocate on this. Is
That does not cut ice here. You may be a newly appointed. Why do you take the briefs then without knowing the facts? You are a newly appointed advocate, does not give any benefit to your client. Tomorrow another counsel will be engaged and your client will go on not paying alimony. This is not done. Anyway, hand over copies right now. File the opposition.
Yes, my
Affidavits in opposition.
affidavit of assets, my lord.
কোথায় এলো না তো এখন আমাদের যে আর্দেলি কি করছে সে রাজকার্য?
Affidavit as
The time for filing reply is extended for a week from date. Full stop. The application shall be listed next on February 25, 2025.
I have paid
ad hoc alimony. Ad hoc alimony.
যেখানে বললাম affidavit in opposition along with affidavit of assets of the respondent husband.
And ad hoc alimony, what was directed to file 5th February or paid. But let it go on.
গেছে দাও কি করছিল এতক্ষণ ডাকেন অনেকক্ষণ ডেকেছি তো ও yes next
Let it be go on paying, bro. Ad hoc alimony, you have received directly paid. Let it go on paying.
he said it
Ad hoc alimony.
alimony was paid.
Paid already paid. Whenever you next matter you taken up next time, let it go on paying. But still,
Go on paying arises only when you dispose of the application. একটা লাইন অ্যাড করে দাও তো। It is submitted by learned counsel for the parties that the respondent husband has paid ad hoc alimony of rupees 50,000 to the appellant wife as per the previous direction of court.
And I think paper.
No question of go on paying. 25th will take up the application.
Regarding the paper book, all record has come.
You will have to file paper books.
Yes, by March, but it could not. It will be extended. 8 weeks up to.
You will extend the time when you dispose of the application.
Yes,
Paper.
Grateful.
Item number 20.
20 is my appeal, my lord.
Yes.
Arising out of a partition suit. I'm the plaintiff and the partition suit has been dismissed.
Dismissed.
On the ground that I could not prove the title of the predecessor of my vendor.
That is also necessary. That is also one step further the court can go.
X is the owner.
Somebody sells a property and
My lord, X is the owner. X has got 3 sons, A, B, and C. 3 of them sell their part of the property to me.
all 3 sell
All 3.
by separate deeds.
By separate deeds, they sell it.
All right.
And since it is a part of the property, I file a subsequent partition suit.
You could not prove title of X. That is the
I could not prove the title of X.
X factor. So this is appearing for the first time.
No, I find that it has appeared and there was a direction to serve.
What about that?
But
Ad interim granted.
no, not ad interim granted. But on a trial court's judgment was ex parte.
What about service? No, here you have to serve. Trial court judgment was ex parte. That does not absolve you from serving.
I will serve and come back, my lord.
Serve and come back.
Serve and meanwhile, kindly calls for the lower court records. Let that process also be expedited.
No, only when you dispose of the injunction application. There was a previous direction for service. Why didn't you comply with that?
And this I noticed when I was getting ready for this.
Then we will not grant any interim order because you have not complied with the order of court.
I know, I cannot seek now.
When was the direction passed?
15 December 2023.
Despite a direction having been given to the appellant to serve copies of the application on the respondents, comma, we find that no such copy has been served as yet. Push up next para. Accordingly, the petitioner shall serve copies of the application on the respondents immediately, indicating that the application shall be listed in the monthly list of March 2025, when an affidavit of service to that effect shall be filed by the appellant.
I will.
Number 21.
21 Lordship, I am appearing on behalf of the appellant. Wife is the appellant before your Lordship. Pursuant to your Lordship's direction, we have served the copy of the application.
What about service, Mr. Rai?
Lordship, we have served.
Good service. You have filed your affidavit of assets also.
We have to file the affidavit of assets.
Yes.
The affidavit of assets. In the meantime, after service, there is a development. The husband wants to make a compromise with the wife. So,
After getting the alimony application. Good.
your Lordship,
Compromise means, sorry, this is against the divorce decree. He wants to come back, take you back.
he wants to take back the wife. So Lordship will adjourn the matter for 2 weeks. In the meantime, if some
Definitely.
development is there, we will file a
Definitely.
joint application.
Definitely. Learned counsel for the appellant wife files the affidavit of assets and liabilities on behalf of the appellant, which is kept on record. Full stop. The affidavit of service filed today indicates that the respondent husband has been served. Full stop. Although no affidavit in opposition or affidavit of assets is filed today on behalf of the respondent, comma, nor is the respondent represented in court, comma, learned counsel for the appellant in his usual fairness, comma, submits that there is a chance of settlement between the parties, and as such, a fortnight's time may be granted in order to permit the parties to resolve their disputes. Full stop. Accordingly, on the prayer of the appellant, comma, the matter is adjourned till March 5, 2025, when it will be listed under the same heading. So that it does not come in the combined list, then it will go All the common list also we reach.
In this matter, I am appearing for the respondent.
Respondent, that's it.
Right.
Yes, you're for the right.
There's a delay of some days, 12 days.
20 days. Yes, you are condoning the delay. What is the reason? Mr. Chatterjee, what is the reason for this?
Because that, stated in paragraph 3 that the petitioner and her daughter suffered some injuries in course of discharge of their duty, and resulted in their requiring medical treatment and all that. But the records are here. The medical records are good.
You have alleged that the defendants when
That
assaulted you.
That their agents. The dispute is a parking collection,
No, then
parking fee.
have you seen the amendments made?
Yes, these are the medical records. All
Those are not annexed. Those are not annexed.
Usually, I do not oppose to the.
No, this you have to oppose because it's specifically against you.
In that score, my lord kindly comes at page 23.
23 of what? The application is of 5-6 pages. We are on the section 5. Section 5, they have alleged that your men hit them, for which they were under medical care, which was the reason for the delay.
For that reason, they have lodged a diary.
Yes.
Before the police authority.
Yes.
And
He could have taken a more innocuous ground so that they would not have opposed. This will have to permit them to oppose. Yes.
in their application, they at page 20 they.
What application? Page 20, the other injunction application.
It is in the stay application is being referred to the application.
Injunction application. There's an injunction application.
I am
Application for
referring
injunction.
injunction application at
Page 20, yes.
Page 20 annexed P5.
Right. That's that complaint.
Yes, that complaint.
Right.
So in the middle portion, they by name, as I cannot drive name Deepak Shankar suddenly charged his behavior. By
Yes.
name, they have given allegation on the.
Yes. Absolutely.
Thereafter, my lord, kindly see the allegations at page 21, the bottom of the page. Not that the police are sitting idle; they have launched criminal cases also. But we have to make our ends meet, and this is our only source of livelihood.
Yes. What do you say?
And thereafter, if my lord kindly comes to page 23, here they gone to the NRS Medical College Hospital, and now at point number 11, short history of the case as stated by the patient, blow on whole body by Dhananjay.
They are your main agents according to the complaint also. In the
earlier portion,
yes.
page This is not the solitary example.
The person named as Deepak Shankar.
This is not the solitary
Mr.
incident.
Chatterjee, please don't interject. Yes.
And here the name differs. And thereafter at page point number 12 of the same police report, on examination, no such external injury take into on observation. That is clearly stated.
Where is page?
Page 23.
Where is that? No such.
Point number 12, on examination.
Yes.
Here it is written, no such external injury
Yes.
taken into observation.
Like cut or abrasion. Yes.
So this does not corroborate the GD they have initiated before the police authority. That is my humble submission.
What is the appeal against?
The appeal is against the refusal to pass an interim order. Here the dispute is regarding the
Criminal cases are pending. So this will be
Yes,
subject matter of the criminal case.
Many criminal cases are pending. My lord,
and gory allegations.
I am submitting the facts behind the case. There is a parking authority. The respondent is a authority which grant license to collect parking fees from the respective.
That is the merit of the case. We'll go into that.
Yes. But my lord, prior to give any order,
to that respective effect, in that particular point, another case was pending before the learned.
We'll look into that when you take up this injunction. Yes, Mr. Chatterjee, what is your answer to this page 23? No such external injury.
This medical
Your
report,
annexure.
I know medical report does not pertain to the complaint. Well, this is not an enclosure to that.
Yes.
But there are no. This
Why have you have annexed this in support of your case?
annex this, Malad,
Which says it does not disclose any cut or abrasion even.
many which says they disclose. I am not on that at all. The nature of allegations are serious. Well, kindly reads the allegation at page 20, but these are so gory. I do not intend to
Anybody
trouble
may
my
make any allegation, Mr. Chatterjee, but the allegations are not corroborated by your own medical report.
Page 23 is not an enclosure to page 22.
But it's a part of your application in
Yes,
support of your case that they have hit you in such a manner that you are you had to go to the hospital.
My lord,
Please, yes, one minute. And it says your medical report annexed to the section 5 says there was no external injury even.
This is not the section 5.
Oh, this is the injunction, but it's your annexure all the same.
Yes, the enclosures I have craved leave to refer to those, Malad, the medical reports on basis of which I pray for condonation of delay. There are quite a bunch of those, and even a minor was not spared. If she is slapped,
Nothing is annexed. Nothing is annexed to the section 5.
I have your petitioner craves leave to refer to the medical.
All right, that's there.
And
where are those?
Even a minor was not spared.
Where are those?
If she is slapped, that will not reflect on her face when she goes to a doctor for examination. Maybe she'll be. There you go.
All right, we'll say that you are denying these allegations and you have pointed out to certain discrepancies.
and my lord, now I
But
have
since a police
finding
case
that
is pending, it's a
copy
prima
of
facie
this
case for
application has ever been served upon us.
no copy of section 5.
Only the memo of appeal
No,
and the
no,
injunction. has been-
মাঝখানে দুটোর মাঝখানে আগে এই
I am handing over my bill.
এইটা it's there. Mercifully it is there. And it was so short, my lord, that it is.
I am sorry. But where they have by name have lodged the complaint before the police authority and known the person by name Deepak Shankar, and on the same date they rushed to the NRS Medical College Hospital due to getting treatment arising out of that alleged assault. And here the name as also the observation by the medical authority differs. Name also differs. The person, that is Dhananjay.
I think, my lord, I'll hand over much,
Go on
my lord,
hold
to my
by
learned friend.
Dhananjay.
No, we are allowing the section 5, we are giving our reasons. The delay in preferring the appeal is of about 12 days. Push-up, the plea taken in the application for condonation of delay is that the petitioner has to suffer from physical injuries and mental trauma due to assault meted out, METED, by the men and agents of the defendant stroke respondent number 1 with regard to a dispute regarding a parking space, which is also the subject matter of the litigation. Push up next para, learned counsel for the petitioner places reliance on certain copies, places reliance on certain copies of medical documents which go on to indicate that there were several injuries on certain occasions on the person of the petitioner and other family members of the petitioner. Push up next para, learned counsel for the you are for respondent number 1. Learned counsel for the principal defendant stroke respondent number 1 controverts the allegation and submits that it will be evident from the annexures to the injunction application also filed in connection with the present appeal that there are contradictory statements in the complaint lodged by the petitioner with the police, insofar as it was alleged that one Deepak Sonkar committed assault, but thereafter it is seen that some other persons have been mentioned in the FIR lodged in the context of the said complaint, which of that apart, comma, from the medical report annexed at page 23 of the injunction application, comma, it is seen that no external injury like cut or abrasion was found on the body of the petitioner. Which of next para, however, comma, upon hearing learned counsel for the parties, comma, we find that the allegation in the complaint was not confined to assaults made by Deepak Sonkar alone. Push up, it was alleged in the complaint that Deepak Sonkar had stopped the petitioner from collecting parking fees and discharging her duties, whereas as physical assault was perpetrated on the petitioner by musclemen sent by one Shamul Manna. Full stop, next para. Thus, comma, there is no palpable discrepancy on the face of the complaint to give a complete go-by to the veracity of the complaint at this stage, comma, particularly since criminal cases are pending. So that apart, comma, the medical document relied on by the respondent number 1 is not the sole document handed over by the petitioner. Push up from the documents, comma, a bunch of which are handed over today in court and kept on record, comma, for which leave was craved in the application to be produced, comma, we find that several injuries were also suffered apparently by the petitioner and other members of her family. Push up next para. Thus, comma, we find that a strong case of the petitioner having suffered from injuries which prevented her from preferring the appeal in time has been made out. Stop. Accordingly, without going into the merits of the allegations and counter allegations which are sub judice before the concerned criminal court, comma, we find that a case of condonation of the minuscule delay of 12 days has been made out. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay in filing FMAT 175 of 2024. And now, full stop. Accordingly, the appeal be placed in the list. The appeal is taken up for hearing under Order 41, Rule 11 of the Code of Civil Procedure. Yes, move the appeal under Order 41. Then we'll hear out the injunction application. We'll hear you on that.
If,
what is your
the ground
ad interim has been diffused, Mr. Chatterjee?
Yes.
Let us see the memo. Yes. The suit is for exactly what? Declaration that?
The suit is for injunction. That
suit is for no declaration, injunction only.
Declaration and injunction.
What declaration?
That the petitioner is the authorized parking fee collector in respect of a certain locality, my lord. Yogendra Kaviraj Road, eastern side.
You have been appointed by the corporation according to you.
Corporation has appointed defendant number 1. As defendant 1, my lord, is the recognized agent of the corporation.
You are a sub-agent?
Yes, yes, yes. And they have issued identity. Before me, my husband, who died in the pandemic in 2020, and after his death, my lord, kindly see page 15. Page 15 and 16 are the documents pertaining to my husband.
All right.
And page 16.
So is it automatically heritable?
No, certainly not.
Then?
But they recognize me at page 18.
Achha.
I give this to come.
All right, yes.
It's a compassionate appointment, my lord.
Yes.
Page 18. This says eastern side.
All right.
The dispute is whether it is eastern side or western side. It is as narrow as that. Why I lay emphasis on it should be eastern side is because, well, according to the corporation, my lord will find that at page 14. The eastern side is where the cars can be lawfully parked, is the sanctioned parking area. This is the page 14. This is taken from the portal of the corporation's parking department. Kalaka Street is the area towards the middle of the page, left hand. This is KK Tagore Street East. E is East.
All right. Yes.
And MG Road
Very well. Yes.
with Jogendra Kobiraj Road. In the earlier suit that Malad, the learned court has referred to in the impugned order pertain to western side, not this side. So the cause of action Malad was different. Thereafter, I came to realize that Malad, western side is not the authorized parking zone, and I was being saddled with hefty fines by the police. Maybe that was the natural consequence, and I could not deposit Malad with the defendant number one the requisite amount that I was required to. And then Malad, and also Malad, page 18 says is the only document I have. It refers to eastern side.
Mr. Chatterjee, my learned brother has another bench till 1:15. So we'll resume at 2. Please come back at 2. We'll resume with this matter. We'll continue. Yes, yes.
Well, we'll kindly go through paragraphs 14 to 17 of the application.
Of the injunction application?
Yes, what I was submitting, verbally, that western side, the disturbance created by the police who were charging hefty fees, they were entitled to, because that is not the authorized site.
You have been given the eastern side.
Yes, officially eastern side, but now I'm being forced to discharge duty on the western
Let
side.
us see the relief sought in the plaint, Mr. Chatterjee.
Page 33.
B may be barred under section 41A and read with section 14 of specifically, but A is there. Till you are there, you are seeking a declaration that I am still there, unless you are, ousted by due
Strength
process.
of page 18, the letter authorizing me to collect from eastern
Yes,
side,
yes.
and which has apparently been continued because they still do not disown me totally.
Because if it started with B, then Mr. Chatterjee, your suit is definitely barred, but determinable by its very nature.
I have pleaded in paragraph 17 that I was made to pay hefty fine. Paragraph 14, at page 8.
You had to pay that fine from your pocket, obviously.
And as a consequence, could not submit the minimum amount that I am required to do.
Why did they assault you? Their men and agents?
Because they were forcing me to discharge duty on the western side, and the
When
lady
you
and
tried to
her
go to the eastern side, so let us see the impugned order once. You naturally stated your case.
Only reason
Let
cited
us see
is
the
at
reason.
page 3, last page.
Yeah. Gone through the yeah. What is this? The petitioner do have cases with the OP pending before this court apart from this suit?
Pertaining to the western side, that is what I have stated, in my grounds, if my lord.
No, there is a different suit.
That is a different suit in respect of the western side.
You had filed that suit?
Yes. Got an injunction also, and then it was vacated because I could not deposit the necessary amounts.
No, you said yourself said that you don't have any right to collect on the western side.
But initially I didn't know.
But that suit is still pending. Both are still pending. Why didn't you amend that suit then? Why didn't you amend that suit? You are seeking rights both in the western and the eastern side.
No, I'm seeking only on the eastern side.
Now in this suit. But what about the other suit which is still pending?
That may be taken as abandoned. I'm ready to withdraw that. Only because of page 18 and the corporation's portal saying that this eastern side is the legal side. I've no other quarrel with the western side. In their written statement,
how can there be peaceful possession of the
that is absurd.
That's an absurd.
In their written statement filed in the earlier suit, they do not disown me. They say I am the agent in respect to the western side.
Yes, but what is the injunction sought in the court below? Let us see that also injunction application. What is the question of possession? Even they don't have a right of possession.
Just no interference
Dispossessing the plaintiff from
discharge of duty. No interference in discharge of duty.
No, the prayer you have made is different, Mr. Chatterjee. Dispossessing not only that, from transferring, alienating the same or any portion to any intending purchaser. This is not maintainable in the
For a degree of declaration that the plaintiff is entitled to operate as the fee parking.
No, in the temporary injunction application also, you reiterated what injunction you are seeking from dispossessing you from the scheduled suit property and transferring, alienating the same in to any intending stranger purchaser.
They were trying to deploy a
That's a different
agent.
prayer. They don't have title.
This
injunction. No, not a question of pardoning you, Mr. Chatterjee, but this prayer is not maintainable in the frame of the suit.
Maybe in this application it has been bettered a little bit.
How can we go beyond the prayer in the code below?
The purport of the prayer was that
even if you want, we fully want to grant you some relief because you are a lady. I mean, you are being harassed and all. That allegation is there. He'll be denied.
Just injunct them from restraining with my duty on the eastern side.
Can we do it beyond the prayer of your suit and injunction application in the court below? Suit should have been framed properly, and injunction application also dispossessing. How can we pass an order in connection with your the contract? Molding relief has a limit. You want protection regarding dispossession and alienation. That they
Kindly
can
sees the first few lines of page 34.
Yes.
Continuation of the prayer. They are not entitled to create any disturbance and or to oust the plaintiff from operating the said field. That's I limit my.
But that is also hit by section 14 unless we say that without due course of law. I mean, which will mean nothing though. Even then, we can consider
But
that.
they say in their written statement, that is what I am harping on, that
yes,
I am the agent on the western side. It is up to my learned friend to explain.
They are a licensee. Defendant number 1 is a licensee. They are entitled to fee parking, to collect parking fees. You are a sub-agent under them. The contract is by very nature determinable. So whether the suit lies on that count at all,
So long as the contract is there.
so long as the contract is there, they can right now, rescind that contract. They don't even need to give a notice to you because you are a sub licensee.
True for employments under private parties, not very much so. But they say that I am the. Well, this is the written statement that was filed in the earlier suit. There, they are sticking to the stand that the plaintiff is an employee under the defendant for collecting parking fees on its behalf in the location Jogendra Kubiraj Road, western side. If western side is not the authorized side, authorized by corporation, my lord.
What happened to you? Also asked for an injunction there.
Yes, injunction
That was
was
refused.
initially granted, but because I could not deposit the requisite amount as directed by the learned court, that was vacated. Thank you.
I am handing over.
Wait, we'll come to you. We'll come to you.
Because of the failure to comply with that direction stipulation.
Let us hear them. Should we dispose of the appeal itself?
Yes, my lord, you can.
If both of you agree, then we will take up and dispose of the appeal itself right now. Yes, what is your case?
But kindly see the written statement filed, western side.
No, but that does not. That is neither here nor there.
So that
was regarding a different part.
Only limited to this, that they are not
But
totally
that prayer, if
disowning
you look
me.
into that prayer, Mr. Chatterjee, that would be contrary to your present suit.
I do not want western side. I'm stressing
That suit
on
is
this.
still pending. You have not abandoned that. You are
I-
saying you are
I
abandoning it from the
undertake
bar.
Here, my lord.
We can record that. Let us hear the other side. Yes. Please take your seat, Mr. Chatterjee. We'll
First,
just.
I am handing over the plaint
Yes.
filed in the earlier suit.
Right.
That is title suit number 736.
Yes.
Kindly see the prayer.
My lord will also go through the cause of action paragraph.
Here they have clearly filing the suit with an direction for declaring them as an agent for the western side. In that suit, initially they have got the order of ad interim injunction. Thereafter, we have filed our objection. The ad interim injunction application came to a contested hearing, and in that application, the learned trial court clearly directed them to deposit an amount to our account because only for the reason that we are giving the license from the corporation. I am handing over the order portion. Without obeying the particular order and declining to deposit any amount, any single farthing in our favor, they have. This is my copy, and for that reason, it has been.
As per your contract, they have to pay you something. What is that amount? Where do we find that?
That is according to their job card, 1200 rupees per day.
Acha. Acha, now that's regarding western side. This is regarding eastern side. The subject matter is different.
Yes, but
and they have substantiated by this authorized letter that prima facie eastern side was given to them. So we have to focus on this present suit at present. Now, regarding this system, because there is,
I am handing
these are not mutually exclusive. At the same time, they may claim that they have a right in the western side and the eastern side. One may be bad.
the peculiarity of their submission or
Yes.
sometimes they have claiming that they are want to get job in respect of western side and
No, we'll
sometimes-
record their submission that they're abandoning that suit. We'll record it right here. So because these are not contradictory, mutually contradictory. I can at the same time say that I have been conferred right on the west and east. So these are west and east don't go together so that they cannot be mutually destructive.
even
Let us focus on the present suit.
on that score
Why do you say page 18 should not have been taken in their favor? Because 18 says it's just east side has been given to them. And if that be so, why shouldn't they be protected regarding you unlawfully ousting them from eastern side?
actually there is no mentioning to that regard by the corporation authority.
No, you have given eastern side, page 18.
Yes.
This is by you.
Yes.
No, in the present suit, page 18 of the injunction application, please come there. Page 18 of the injunction application in this appeal.
Actually, the appellate hearing was entitled to collection fees for the east side.
If you admit that,
Yes.
then they have only paid for injunction now so that you cannot oust them from that east side. So why shouldn't they be granted identity protection?
No, we are not entitled to collect any fees from the east side, and he is not the employed. He is only employed for collecting east side only. Eastern side.
Their suit is for eastern side.
That's it. But
This suit.
yes.
You're confusing between east and west. Let us focus on the present suit. They have annexed a document whereby you have authorized them to collect from east side. You are bound by this letter.
If you're if my lord kindly comes to their stay application in this suit at page 6, paragraph 9, which is applicable here.
Paragraph 9, yes.
That opposite party number 1 illegally started to operate the free parking zone at Jogendra Koviraj Road western side. He himself admitted.
Western side, they are admitting here. It's illegal. We are concerned with the eastern side. Let us not be bothered with western side now. This suit is for eastern side.
Yes.
Relief sought is for eastern side. Why shouldn't it be given to? They say you do not have any right regarding western side, but you force them to work on the western side.
No, we are not forcing you.
That is their allegation. Let us understand their allegation.
Yes.
Their allegation in the present suit is that they were given the eastern side by you, authority, but you are forcing them to go to the western side where you do not have any right to collect. That is not correct, definitely you are saying, but at the identity stage, you have to take their plaint as sacrosanct.
In their prayer portion, they have not stated, they only stated interfering with the peaceful position of the appellant.
Position, we are not bothered. But regarding you cannot oust them. No, there are two parts.
Kindly comes to 11, page 11 at the bottom portion
Yes.
of the KMC parking zone on Jogendra Koviraj Road, eastern side.
Exactly. But still you are confused between east and west. This suit is for eastern side.
Yes.
You have given them authority to collect on the eastern side, but you are forcing them, their allegation is you are forcing them to work on the western side, where you don't have any right, you have not. Anyway, let us grant that injunction, let us dispose of the appeal. Ash. In view of several questions of fact and law being involved, we admit the appeal, and the appeal will be heard on the questions of the questions framed in the memorandum of appeal. Next para. On consent of both sides, the appeal as well as the application are taken up for hearing together. Next para. Since we have not invited affidavits, it is deemed that none of the allegations made in the injunction application are admitted by the respondent number 1, which is the principal defendant in the code below. As such, service of notice of appeal on the pro forma defendant stroke respondents numbers 2 to 6 is dispensed with. Next para, the bone of contention between the parties is the right of the petitioner, comma, in the capacity of an agent authorized by the respondent number 1, comma, to collect parking fees on the eastern side of Jogendra Kobiraj Row. Full stop. Next para. Learned counsel for the appellant argues that the learned trial judge, comma, without assigning appropriate reasons, comma, refused to grant ad interim injunction. Pushed up. Next para. It is submitted that initially the husband of the appellant stroke petitioner was a parking fee collector under the respondent number 1, and thereafter on his demise, comma, the authority letter was given on October 1, 2021, empowering the present petitioner to collect such parking fees as a sub-agent under the respondent number 1, comma, the latter being entrusted by the Kolkata Municipal Corporation to collect parking fees in the concerned area. Push up. Next para. The grounds assigned by the learned trial judge were only that there is no urgency in the appeal and that other litigation is pending in the same court between the parties. Full stop. With regard to the first ground, comma, learned counsel relies on the annexures to the injunction application, which go on to prima facie establish that the petitioner was severely assaulted and forced by the respondent number 1 and its men and agents to collect parking fees on the western side of the said road, comma, which even the respondent number 1 is not authorized to do. Full stop. Next para. As such, comma, it is alleged that the appellant petitioner had to pay huge penalties to the police. Full stop. Next para. Learned counsel for the respondent number 1 opposes the prayer and argues that the plaintiff stroke petitioner appellant has filed a parallel suit which is still pending in the self-same trial court, where the plaintiff has claimed right to collect parking fees under the respondent number 1 in respect of the western side of Jogendra Kobiraj Row. Push up. As such, comma, it is argued that the plaintiff is seeking to breathe hot and cold in the blow hot and cold in the same breath. Push up. Next para. Furthermore, comma, it is pointed out that there are discrepancies in the complaints lodged by the appellant. Push up. Next para. Learned counsel appearing for the respondent number 1 denies the allegations made by the appellant and submits that the plaint as well as the injunction prayers, comma, as framed, comma, are not maintainable. Push up. Next para. Upon hearing learned counsel for the parties, comma, we find that the plaintiff has sought several reliefs in the plaint. Pushed up. The primary relief sought is a declaration that the plaintiff is a bona fide collecting agent under defendant stroke respondent number 1 and continuing to run fee parking zone at Jogendra Kobiraj Row within bracket eastern side. Pushed up. The second limb of the relief sought is a declaration that the plaintiff is entitled to operate in such capacity within the local limits of the Posta police station, and that the defendants and their men and agents are not entitled to create any disturbance thereto. First up, although we have some doubt as to whether the second relief is maintainable in view of the bar under section 41A small a of the Specific Relief Act, comma, we choose to desist from making any conclusive remarks in that regard, comma, since it will be open to the trial court to enter into such issues. Pushed up, however, comma, the plaintiff apostrophes first relief sought in the suit regarding a declaration that she is a collecting agent and continuing to run fee parking zone is legitimate in view of such case being prima facie established by virtue of the annexure at page 18 of the present injunction application, which is an authority letter dated October 1, 2021, issued by the respondent number 1, empowering the plaintiff stroke appellant to be appointed as a car parking fees collector on a temporary basis under the respondent number 1 for collecting parking fees at Jogendra Kobiraj Row within bracket east side. Pushed up. Next para. insofar as the prayer for injunction is concerned, comma, both in the plaint as well as the temporary injunction application filed by the court in the court below, comma, there are two limbs to the same. Full stop. The first limb, comma, which seeks a restraint order on the defendant number 1 from interfering with the peaceful possession of the plaintiff and or dispossessing the plaintiff from the scheduled suit property or any part thereof and or transferring or alienating the same or any portion thereof to any intending stranger, comma, we are of the opinion that the said relief is not maintainable, comma, being incompatible with the frame of the suit, comma, which claims a right of the plaintiff stroke appellant merely in the capacity of an agent of the respondent number 1 to collect parking fees and does not seek any declaration regarding any immovable property or possession thereof as such. Full stop. However, comma, we also find that the temporary injunction application, comma, which is in aid of the final relief sought in the suit regarding declaration of her right to operate as a collecting agent under the defendant number 1, comma, we find that the second limb of the injunction prayer is in consonance with the frame of the suit, comma, since the plaintiff also seeks a restraint order on the defendant number 1 stroke respondent number 1 from disturbing the functioning of the plaintiff stroke petitioner as parking fee collector of the Kolkata Municipal Corporation regarding the parking zone on Jogendra Kobiraj Row within bracket eastern side, comma, Kolkata. Full stop. Next para. We find that a sufficient prima facie case has been made out to go for trial in the suit as well as the injunction application insofar as the authority letter dated October 1, 2021 empowers the petitioner stroke appellant to collect parking fees, although on a temporary basis, comma, in respect of the eastern side of Jogendra Kobiraj Row, comma, which is the subject matter of the suit itself. Full stop. The learned trial judge, comma, however, comma, without adverting to such facts and documents, comma, merely refused ad interim injunction on a cryptic premise, holding that there is no urgency in allowing the said ex parte order. Full stop. However, comma, in view of the alleged assault on the petitioner and the allegation that the petitioner is being forced, appellant is being forced to collect parking fees from the western side, where neither the respondent number 1 nor the appellant has any authority to collect, comma, we find considerable urgency in the matter, as well as that the factors of irreparable injury and balance of convenience operate in favor of grant of injunction. Full stop. As regards the pendency of a different suit by the petitioner, by the appellant in the same breath, comma, regarding the western side of the self-same road is concerned, comma, the claim of the appellant regarding the western and the eastern side in the same breath are not mutually destructive. Full stop. However, comma, since the appellant relies on the self-same set of documents to claim such reliefs, comma, we put a question to the learned advocate for the appellant as to how the two suits could be maintained together. Full stop. At this, comma, learned counsel for the appellant before this court, comma, on instruction, comma, submits categorically that his client, the appellant herein, undertakes to abandon stroke withdraw the prior suit in respect of the western side of Jogendra Kobiraj Row. Full stop. Next para. Thus, it is expected that appropriate steps in that regard shall be taken by the appellant at the earliest. Full stop. Insofar as the present injunction is concerned, comma, the impugned order is devoid of reasons, full stop, that apart, comma, the learned trial judge failed to take into consideration the extreme urgency involved as well as the prima facie case made out by the appellant insofar as the present right of the appellant to collect parking fees from the eastern side of the said road is concerned. Full stop. Accordingly, FMAT 175 of 2024 is allowed, comma, thereby setting aside the impugned order and granting ad interim injunction restraining the respondent number 1 and its men and agents from disturbing the collection of parking fees by the petitioner on the eastern side of Jogendra Kobiraj Road till disposal of the injunction application in the court below. Full stop. The respondent number 1 shall file its written objection to the injunction application in the court below, comma, if not already filed, comma, within a fortnight,
Within 21 days.
within 3 weeks from date, full stop. Next para, it is expected that the learned trial judge shall endeavor to dispose of the injunction application as expeditiously as the business of the said court permits. Full stop. Next para, it is made clear that this court has not entered into the merits of the case conclusively and has been dealing with only the veracity of the impugned order in respect of the grant of the refusal of ad interim injunction, and it will be open to the learned trial judge at the final hearing of the injunction application as well as all subsequent stages of the suit to decide all issues on merits independently without being influenced by any of the observations made above. Full stop. Consequentially, comma, can 2 of 2024 is also disposed of in the light of the above observations, no rise to cost.
My lord, my only prayer
Yes.
is that so the appellant must have been deposited in our favor.
Achha, you have to deposit that money. Yes. We'll make it subject to
Kindly make an order to that regard.
1200 per month is the contractual rate. 1200.
For us to
Understood.
Because of the
1200 per day.
Yes.
because the fines imposed by the police and the
No, that is no excuse.
I have to come back with instruction.
From now on, you will be paying the contract at the contractual rate. You will be paying.
From now on.
Uh,
Side.
It is made clear that the above injunction is conditional. এটা ঢুকিয়ে দিও একটুখানি আগে ওই যেখানে disposal.
As per the contract.
It is made clear that the above injunction is granted subject to the condition that the appellant shall go on paying the remuneration as fixed by contract between the respondent number 1 and the appellant, comma, to the respondent number 1 for collection of parking fees from the eastern side of Jogendra Kobiraj Road. Full stop. Next para. In default of such payment, comma, it will be open to the respondent number 1 to apply for vacating the interim order before the learned court below.
Really, there is no contract aspect between the
Then you are not entitled to get any money. Only that authority letter he can collect, she can collect.
Yes.
Item number 12.
Yes. এটাই ঠিক, এটাই আপনি লোক ডাকছেন কেন? এটাই বলছি না। Yes, 23.
My lord, I am for the appellant.
Yes.
Lord, on the last date, my lord was pleased to make a direction for payment of costs upon them. My lord, I have paid already.
What did you do to? Oh, opposition.
Yes. I was late in filing my opposition to their my reply to their opposition, my lord.
Substantially late, probably. So this is the payment. Very well. What is the matter? Move your matter.
My lord, today it's for my lord the hearing of the stay application, my lord.
Yes. What is the appeal against?
My lord, the appeal is against a decree in a suit for recovery of khas possession. My lord. Now, admittedly, at the stage of evidence, what came out was that it's a waqf property. The suit property is a waqf property. And there was 711. 711 was allowed. That was set aside, my lord. I'm not going into those facts. I'll come directly into the, my lord.
711 has ultimately failed.
Ultimately failed.
Failed on what ground? If it's a waqf property?
My lord, it failed that disputes between the licensee of a waqf and his licensee that can be tried by the
civil court.
Civil court.
Very well. Now, what is your what is the impugned degree?
Now, my lord, coming directly to the impugned decree, my lord.
Yes.
My lord, the final conclusion of the court below is that I am a licensee. Another fact, my lord, I would.
You filed this suit for eviction against them?
No.
They filed it?
They filed. And my lord.
Your license eviction has been granted. What is the wrong in your judgment?
No, my lord, my contention there, I had also filed a counterclaim, my lord. And in the counterclaim, my claim was that I am a premises tenant. So that was my claim in the suit bill. But the court finally came to the conclusion at page 65 of my application.
Give the internal page.
Internal page is 14, my lord.
14, yes. Did you produce any rent receipt or anything of that sort?
No, my lord, I am not going into that controversy. I would keep
For
it.
that, my lord, from the counterclaim, no appeal has been preferred. Only from the decree for eviction, my lord, only one appeal has been preferred.
No.
Their counterclaim is for declaration of tenancy right. That was dismissed. From there, no appeal.
Then,
yes. My lord,
if that degree stands, then you don't have a case here.
No, my lord,
it's a foregone conclusion that you
lord,
were.
I am. Probably he is arguing on, my lord, res judicata. My lord.
No.
I am not on that, my lord. I would be purely on a jurisdictional issue. As the court below has come to the conclusion that I am a licensee, and I am a licensee.
Today, if the declaration stands, if your declaration has failed that you are a tenant, then you are not a tenant. That's an established position of law. Therefore, the eviction decree can definitely be granted.
Yes, my lord. But then again, when the eviction decree stands on the ground that I am a licensee whose tenure has expired, the Waqf Act provides for a specific provision which empowers the Waqf tribunal, my lord, to pass the actual order of eviction.
Can you reopen that after that 7-11? Same point was decided.
7-11 was on the ground that I am a premises tenant. Right now, my lord, in this appeal, my lord.
But that was turned down on the ground that it's a license.
It's a license.
And civil court has jurisdiction.
And the civil court has jurisdiction. But
that issue has been decided.
No, my lord, right now the trial court has come to the final conclusion that I am a licensee whose tenure expires. And now when I am a licensee whose tenure has expired, I am covered by section 3EE of the Waqf Act, which is, my lord, encroacher. I become an encroacher. Now this encroacher point was never dealt with by any court. In the
constructive res judicata. Constructive res judicata.
My lord, on constructive res judicata, my lord, this point arises only when the trial court comes to the final conclusion that I am a licensee. In a way, my lord, I am admitting that yes, I am a licensee. But if I am a licensee, then I am entitled to that protection. I immediately become an encroacher under 3EE.
Did you take this point in the court below at any point of time?
No, my lord, this point was not taken. But my lord, constructive res judicata, my lord, my submission would be that only when the trial court came to this final conclusion, licensee whose tenure has expired, only then I get the opportunity to make this point, my lord. And if I am an encroacher, section 54 of the Waqf Act is attracted, my lord, which provides a detailed procedure.
You have to set up a plea. It's a mixed question. It's not a pure question of law. You have to set up a case that you are an encroacher after license was expired, but your case was contrary in the court below. You cannot now resile from that position and take a mutually contradictory stand that you were an encroacher after your license was evicted.
But that position, my lord, emanates from the decree. My lord, the crux of my submission is the moment the court below holds that I am a licensee whose tenure has expired, it cuts its own jurisdiction short. Kindly, my lord, if I may show the relevant provisions which I am relying upon, my lord, possibly it will be clearer. My lord,
Waqf Act.
My lord, that's he can apologize.
Waqf Act আছে কিনা দেখুন না একটা। একটা কপি হলো না সাহেব কি Which section you are relying on?
My lord, first is section 3EE, my lord. My lord, I am giving my book,
Give one copy to my learned brother.
My lord, it defines encroacher, my lord.
Yes.
Encroacher means any
one
person or institution,
yes,
public or private, occupying a Waqf property in whole or in part without authority of law and includes a person whose tenancy, lease or license has expired or has been terminated by the mutwali or the board.
And the jurisdiction flows from which section? Let us come to that.
Thereafter, my lord, section 54.
Yes, 54.
Yes.
Yes, 54.
Section 54 is removal of encroachment. Whenever, my lord, I am reading.
Yes, yes.
Whenever the chief executive officer considers whether on receiving any complaint or of his own motion that there has been an encroachment on any land, building, space, or other property, which is a Waqf property, and which has been registered as such under the Act, he shall cause to be served upon the encroacher a notice specifying the particulars of the encroachment, and calling upon him to show cause before the date to be specified in such notice as to why an order requiring him to remove the encroachment before the date so specified should not be made, and shall also send a copy of the notice to the concerned mutwali. The notice referred to in subsection 1 shall be served in such manner as may be prescribed. If after considering the objections received during the period specified in the notice and after conducting an inquiry in such manner as may be prescribed, the chief executive officer is satisfied that the property in question is a Waqf property and that there has been an encroachment on any such Waqf property, he may make an application to the tribunal. He may make an application to the tribunal for grant of order of eviction for removing such encroachment, and deliver possession of land, building space, and other property encroached upon by the mutwali. So, my lord, the ultimate order of eviction has to be passed by the tribunal. The ultimate order of eviction, that becomes an issue that is to be triable by the tribunal. And once that becomes an issue,
but if you come to
section 85,
31 EE, yes, then 85 comes. 31 EE, then encroacher means any person such and such without the authority, occupying without the authority of law, and includes a person whose tenancy, lease, or license has expired, or has been terminated by matwali or the board. The presumption is that he or she has to be a licensee or tenant in the first place under the board. This could have been applicable if they were treated to be an encroacher and an initiation of proceeding was. This relationship, the relationship sought to be severed here, is licensee and sub-licensee. So that is not covered by this. Here the Waqf board has nothing to do.
My lord, in this case, my lord, my humble submission would be that the Act does not create a specific distinction in that regard. That licensee and licensee of a licensee, this distinction, my lord, which the trial court has also.
The language is very clear. Or terminated by the.
It applies to any licensee whose license has expired, tenure has expired.
Has to be read ejusdem generis, and nociter also applies. The rest of the words have to be seen in similar context. It's very obvious from the language. And moreover, first of all, the interpretation. Secondly, you had the opportunity. Have you annexed somewhere the order 7 rule 11, the final order? Shows that 20 of the injunction, stay application.
Yeah. You could hand up to page 22, the first paragraph.
No, let it. Yes. Yeah, absolutely. No. No prima facie case, Mr. Das.
That, my lord, that was my case, my lord. I cannot develop on that, my lord, but that is what it is, my lord.
Fully decided. Order 7 to 11 stage you can appreciate, But this operates as res judicata. There's a specific distinction drawn. And we are also of the same view, in fact, independently also, as we expressed, without looking into this event. We don't have a prima facie case. So we'll refuse stay. We cannot dismiss the appeal at this stage.
But well, then again,
And we
my lord,
won't.
execution is also proceeding, well.
Yes, that's why we will refuse the stay, that will suffice. And we will say that the execution may be proceeded with. What else can be done? You don't have a prima facie. This will keep the matter hanging for years and we'll earn a bad name. Cases are pending, not decided. You don't have a prima facie case. You don't have a right to get an order of stay here. This is not such a case. Come with a better case, Mr. Das.
My lord, only thing is,
It's a matter of right, because it's a first appeal, you don't have a right of getting stay. That notion has to be dispelled now.
but thereafter, my lord, if my lord looks into page 24, there is also an order.
Yes.
Although it's a single bench order, my lord.
Yes. What does it say?
Actually, my lord, the fact that it's a Waqf property, that came out at the stage of evidence. So thereafter, my lord, immediately we filed an order 7 rule 11. But thereafter, my lord, the board was added.
No, Mr. So you are your argument is very interesting, Mr. Das, that you are arguing that even without an appeal against the counterclaim dismissal, proceeding on the premise that I am a licensee, then also civil court did not have jurisdiction.
Yes,
we appreciate, but that was specifically dealt with here. The finding is very clear. There is no ambiguity in the finding.
And that also, my lord, when the suit is for recovery of khas possession simpliciter, my lord. No declaration.
What declaration is required?
So no, my submission would
Against
have
a
been-
licensee, nothing is required.
my submission would have been that jurisdiction of the civil court is cut short.
And next paragraph of page 22 also, hearing of the suit may be expedited. All other points are left open before the trial court. Other points meaning thereby that not this point, obviously not that point. The effect was that the issue was decided.
My lord, if my lord is pleased to come to page 28, my lord.
28, yes.
Page 28. This is Honorable Justice Shampa Sarkar's order, my lord.
Yes.
The order of the Honorable Division Bench was restricted to determination of the issue whether the plaint could be rejected at the threshold. However, the observation of the Honorable Division Bench cannot prevent the learned trial court from deciding the issue of maintainability. A plaint is rejected on formal reading thereof, but the issue of maintainability would be decided upon evidence.
What else? What other evidence is required? It's an admitted position that it's a work of property.
Admitted position.
We'll respectfully differ from this view of the learned single. Because yes, there are two types of order 7 rule 11. Unless if it's on the ground of a bar of law, it has to be palpable on the face of it. And if it's held that that bar of law does not apply or applies, then what remains to be decided? No further evidence is required. If evidence was required, we could have understood. Then in the first place, order 7 rule 11 could not have been, entertained even. How do you say that?
One thing, in the written statement filed by my learned friend, page 31, they are not challenging their induction in the suit premises by us. They are admitting.
No,
page 32, subparagraph
that
1.
is said. Mr. Das started with that. He started with that.
Therefore, if that is not the induction, then 3 is very clear. It has to be a licensee or tenant under the board and revoked by the Mutawali.
This would be an interesting question, but this we are of the opinion that this has been decided by a coordinate bench. That is conclusive. The present appeal has been preferred against a decree whereby the suit of the respondents for eviction of the appellant on the ground that the appellant was a licensee under the respondents, was decreed. Full stop. Next para. Learned counsel for the appellant argues that the learned trial judge did not have jurisdiction, did not have inherent jurisdiction to entertain the suit and pass the decree for eviction in view of the bar contemplated in section 85, Mr. Das. 85 of the Waqf Act, 1995. Pusap, it is contended that even if it is deemed that the appellant was inducted initially as a licensee and thereafter the license expired, the appellant comes within the definition of double inverted encroacher as given in section 3 within bracket small double e bracket closed of the Waqf Act, Waqf in the Q, Waqf Act 1995. Full stop. Next para, it is thus argued that under section 54, under section 54 of the said act, the chief executive officer has the jurisdiction to issue notice, give a hearing and pass an order of eviction.
No, my lord. Pass an order of eviction by the tribunal. Order of eviction has to be passed by the tribunal.
Achha, very well.
Not the CEO.
Very well. Under section 54, it is the chief executive officer who can initiate an inquiry into that regard. And ultimately, the Waqf tribunal has to, it's Awqaf tribunal now, forgotten. Awqaf tribunal has jurisdiction to pass an order of eviction. Full stop. Next para. Learned counsel for the appellant further contends that although a similar point was decided by a coordinate bench while deciding an application under Order 7, Rule 11 of the Code of Civil Procedure, the said adjudication was only for the purpose of deciding the said application under Order 7, Rule 11 of the Code of Civil Procedure and cannot be treated to be a conclusive finding in the suit itself. Full stop. Learned counsel places reliance on an order of a learned single judge dated September 19, 2023, passed in CO number 2861 of 2022, where it was observed, inter alia, that the order of the division bench was restricted to the determination of the issue whether the plaint could be rejected at the threshold, semicolon. However, the observation cannot prevent the learned trial court from deciding the issue of maintainability. Full stop. Next para. Learned counsel accordingly argues that even in the absence of an independent appeal against the dismissal of the counterclaim by the appellant seeking a declaration of the appellant's tenancy right, the present appeal is very much maintainable and ought to be heard on merits. Push up. Next para, Mr. Das, please take your seat. You also take your seat if you have it. No seat. Sit on a senior's lap. Learned counsel appearing for the respondents argues that the finding of the coordinate bench with regard to the Order 7, Rule 11 application by VDA order dated April 25, 2022, as regards the civil court having jurisdiction is final and binding on the parties. Full stop. Next para, it is argued that the self-same point, having once been decided conclusively, cannot be reopened at this juncture. Full stop. Next para. Secondly, it is argued that in the absence of an independent appeal having been preferred by the appellant against the dismissal of his counterclaim seeking declaration of tenancy rights, the appellant can no longer claim to be a tenant in respect of the property as well. Accordingly, it is argued that the appeal is not fit to be heard on merits. Next para. We find at the outset, upon hearing learned counsel for the parties, that the respondents are justified in contending that in the absence of any appeal having been preferred against the dismissal of the counterclaim filed by the appellant in the code below, the appellant can no longer agitate the point of his tenancy rights. Full stop. Having attained finality, the decree in the counterclaim, the dismissal of the counterclaim operates as res judicata insofar as such claim is concerned. Full stop. Next para. The first factor which operates against the appellant is that the appellant is seeking to blow hot and cold in the same breath by taking mutually destructive pleas. Full stop. In the trial court, comma, all along, comma, the appellant took a plea that he was a tenant in respect of the property, whereas now, comma, in order to get the benefit of the Waqf Act, comma, the appellant seeks to impress upon the court that he is a licensee. Full stop. Such dual and mutually contradictory stand of the appellant cannot be given a premium to by a court of law. Full stop. Next para. Secondly, comma, even if it is assumed that the appellant can be permitted to so argue, comma, we find that the specifically same issue as to the jurisdiction of the civil court in the teeth of the Waqf Act was maintainable or not by the division bench while deciding the application under Order 7, Rule 11 of the Code of Civil Procedure filed by the defendant stroke appellant himself. Pushed up. With utmost respect, comma, although the learned single judge, comma, while deciding a civil divisional application had observed that the said determination by the division bench was not conclusive for the purpose of the suit, comma, apart from the said observation of the learned single judge itself being tentative, comma, and not binding, comma, being arrived at in connection with an application under Article 227 of the Constitution of India, which is merely an offshoot of the main suit, comma, we are also unable to agree with such proposition in law. Full stop. Next para. Insofar as an Order 7, Rule 11 application is concerned, comma, if the plea taken therein is as to bar of law on the issue of jurisdiction of the civil court to entertain a suit, comma, no further documentary or oral evidence is required to be adduced for the purpose of deciding such issue, comma, if the matter is otherwise evident from the face of the application of the plaintiff. Push up next para. The presumption would be in the present case that since the division bench entertained and decided the application under Order 7, Rule 11 of the Code of Civil Procedure on the issue of jurisdiction, comma, the said bar of law was evident on the face of the said bar of law or otherwise would be evident on the face of the plaintiff pleadings and would not require any further evidence to be looked into. Full stop. Otherwise, comma, there would not be any occasion for the division bench to decide the application under Order 7, Rule 11 of the Code on merits, and it would have been relegated by the division bench for final hearing of the suit to be taken as an issue in the suit. Full stop. Thus, comma, the very fact that the issue of jurisdiction of the civil court was decided conclusively at the Order 7, Rule 11 stage goes on to show that no further evidence was required to be adduced, and as such, the decision on the issue was conclusive for all practical purposes at all further stages of the suit as well. Push up next para. The telltale, T-E-L-L-T-A-L-E, the telltale sign of such view of the division bench is also given out by the third last paragraph of the order dated April 25, 2022, passed by the said division bench in FAT 243 of 2021, whereby the Order 7, Rule 11 was decided finally. Pushed up, it was expressed by the division bench therein that all within double inverted other points, double inverted clause, are left open before the trial court. Pushed up, the preceding paragraph stated that the dispute raised in the suit does not come within the purview of Section 85, read with Section 7 of the Waqf Act 1995, comma, since the instant dispute is between the tenant under a Waqf and his licensee. Full stop. Hence, comma, it is clear that apart from such issue, comma, the other issues were left open to be decided in trial, comma, indicating that the said issue as to maintainability of the suit was adjudicated finally by the division bench. Full stop. Next para. Even otherwise, comma, we are at one with the conclusion arrived at by the previous coordinate bench on such count. Full stop. A plain reading of Section 3 within bracket double small e within bracket of the Waqf Act 1995 goes on to show that the section contemplates an encroacher to be an encroacher under the Waqf board. Full stop. Next, or the Waqf estate. Full stop. Next para. The very fact that the last limb of subsection small ee provides the expression within double inverted or has been terminated by Mutwali or the board, double inverted close, shows that the encroacher, comma, to come within the meaning of section 3 within bracket small ee within bracket, comma, has to be an encroacher directly under the board and not under a tenant of the board. Full stop. In the present case, comma, what has fallen for adjudication before the civil court is the mutual rights between a tenant of the board and a sub-licensee. Full stop. Such secondary jural relationship between the tenant of the board and its licensee cannot come within the purview of the term encroach at double inverted mudde under section 3 EE of the 1995 Act. Full stop. As such, comma, by necessary implication, comma, the such a jural relationship falls outside the ambit of sections 54 read with 85 and 7 of the Waqf Act, and as such, the civil court has jurisdiction under section 9 of the Code of Civil Procedure to decide such issues. Full stop. Next para. Hence, comma, in the absence of the hence, comma, since we have held that the civil court has jurisdiction, comma, and no independent appeal has been preferred against the dismissal of the counterclaim, whereby it has been finally established that the appellant is not a tenant but a licensee in respect of the property under the respondents, comma, we are of the opinion that the appellant has failed to make out any prima facie case to for the appeal to be heard on merits. Full stop. Accordingly, comma, we dismiss Can 1 of 2024 on contest without, comma, however, any orders to cost. Full stop. It will be open to the respondents to proceed with the execution case in accordance with law. Should we direct you to put in the special messenger cost and everything? Whatever it is. Let that direction be there, since the appeal we have not decided. In view of character line, in view of appearance, all the respondents, Mr. Bhattacharya. In view of total, there are 6.
My learned friend is from the Waqf board.
Acha. In view of appearance of all the respondents to their learned advocates, comma, service of notice on the respondents is dispensed with. Full stop. The appellant, the trial court records be brought by special messenger, comma, barring, by retaining a skeleton brief for the skeletal brief for the purpose of proceeding with the execution case by special messenger at the cost of the appellant, which shall be put in within a week from date. Full stop. Upon the arrival of the lower court records, the trial court records, comma, notice of appeal, notice of arrival of the record shall be served on the learned advocate for the appellant. Full stop. The learned advocate for the appellant shall prepare and file the requisite number of paper books within 8 weeks thereafter. Full stop. Liberty to mention the appeal for inclusion as and when the same is ready for hearing. Now you know what to do. Advise your client properly. Yes.
You're on behalf of
Sorry.
On behalf of the appellant petitioner, my lord, on the last occasion, your
Lord, I'm
lordship-
led by
Banerjee, please take the microphone a bit closer. Yes.
Lord, I'm led by Mr. Tanmay Mukherjee. We have not received the Vakaratnama. I need I'm praying for a week's accommodation, your lord.
Matrimonial.
my lord.
Alimony has been granted.
No. It's a can is for section 5, my lord, condonation of delay. And there is a supplementary, there is a leave grant.
Have you served on the other side to file the affidavit of service?
This is the affidavit of
How
service.
soon can you get that Vakalatnama?
I'm praying for a week's accommodation, your lordship.
What do you say, Ms. Banerjee?
It's a supplementary affidavit.
Supplementary affidavit for what? Giving further reasons for the delay.
My lord,
Actually, the calculation of delay, day or days of delay.
No, Ms. Banerjee, we think it's better for to permit them to appear by otherwise, if they appear, we can dispense with service of notice and all these things. We cannot do that unless they appear.
Fine. If they want to file their opposition, then
Section 5. If Mr. Mukherjee, what is the delay?
delay is for 563 days.
No, they cannot even submit that they want to file an opposition.
But not yet received the vakalat.
If you want, we can direct them to file affidavit. We can pass that direction.
1 week.
Why? What is the reason for the delay?
That the I don't have any. My client has no knowledge of the suit pending, my lord. Though they are.
No, let them appear next week. If Mr. Mukherjee opposes, only then we'll direct affidavit. Unnecessary delay. Affidavit of service filed today be kept on record. Full stop. Although service has been duly effected, comma. You are Mr. What is your name?
My name is Shomabho Shatra.
Shomabho?
Shatra.
Mr. Shomabho Shatra, having instruction to appear on behalf of the respondent, comma, submits that he requires some time to obtain vakalatnama from his client and the matter be adjourned for a week. Full stop. Accordingly, let the application be adjourned till when?
Next Monday, my lord.
Next Tuesday.
Next Monday, my lord.
Next Monday, very well. Adjourned till February 24, 2025. Acha, give your name. One namta record korbe, advocate have also her. Yes, give both your names. Except Mr. Tanmay Mukherjee. Advocates having instruction to appear for the respondent. এইভাবে থাকবে এদের নামটা রেকর্ড হবে appellant.
My lord, one thing, my lord, supplementary affidavit filed today. Kept.
আচ্ছা, supplementary affidavit filed today be kept on record. Full stop. A copy thereof me, you have served copy?
Yes, my lord. Advance copy I have.
ঠিক আছে, আর কিছু বলো তো।
আর পারবো না। দেয়া হয়ে গেছে client
Defect
থেকে।
আছে? আচ্ছা, Ms. Banerjee, the name of presiding officer has not been given properly. Sandipon, you have stated Sandy.
No, my lord, it is not. It's a change brief, my lord. I have gone through the defects, my lord.
Make Sandy Sandipon again, please. Leave is granted to the learned advocate for the appellant to rectify the name of the learned trial judge in the preamble of the memorandum of appeal by tomorrow. No, আছে। Sandy আছে। Rectify করতে হবে। সন্দীপনটা কি তাহলে?
Not Sashi.
Sandy নাকি দেখলাম?
It's a Partho Pratim, my lord. Learned judge name.
Oh, Sandipon is client. Oh, the name is not there at all.
No, my lord.
তাহলে rectify না? Incorporate.
But now can I incorporate the name?
Right now you can, yes. When they're free, their hands are a bit free, then. Or come back when we rise, just rectify. Right. Yes.
Appear for the appellant, my lord.
Yes, Mr. Vardhan, what is the matter?
This matter recalls whether the 6th bench of the city civil court has been designated to be a commercial court.
2 courts have been designated. Last information we could obtain. No specific designation, probably.
But this has to be a special designation.
No, but all the courts in city civil court are taking up commercial matters and they are being treated to be commercial courts. So, Mr. Vardhan, that we will sustain that objection.
My lord, but subject to correction, my lord, kindly cease.
We had sought for all the notifications from the
Yes, madam. I have
registered
made a bunch
commercial.
I have handed over to your lordships on it. Today I have
Yes. And there are cases pending, commercial suits pending in all the courts of the city.
Well, those were even prior to the 2015 Act.
No, not only those. After also. Whatever you said, exactly that was said by the commercial register, the registered commercial courts. He said that previously also commercial suits were filed. Under what provision, he does not know. No one knows. But even apart from that, we are totally ignoring that. Even now, subsequently also, several suits are being filed distributed to all the courts. Whether
Now it kindly takes up
it was a commercial.
section 3 for once.
So it's the Commercial
Courts Act.
Commercial Courts Act din to? We have with it. Thank you.
But the language used, my lord, is constitutes.
Give us half a second just.
No.
দুটো কপি ওখানে চলে যায়নি তো?
Madam, আমারটা নেই।
দে।
The lordship would kindly pardon my lord mark. No problem.
We pardon it being handed over to us, but we cannot pardon books being marked. Pencil is still all right. Yes, Mr. Bardhan.
My lord, the language used is constitutes such number of commercial courts
Yes, yes.
as it may be necessary for the purpose of exercising jurisdiction.
File a writ petition, public interest litigation for not being constituted, but they are functioning as commercial courts. You should file a
question I posed to
making all
myself.
of us parties because we have administrative.
My lord, the question I posed to myself is, can they do it, my lord? Do they have the jurisdiction to do so? And my lord, more importantly, the suit, the orders that are being passed are being passed as a regular court. Kindly sees Judge Bench 6 Civil Court. It's not a commercial court because the designation has to be of a commercial court. Kindly sees, my lord. Subject to correction, though, my lord. Constitute commercial courts.
No, not this. The city civil code specific notification is also there.
Internal page 5 and 3, my lord.
Yes, yes. Can you hand over copies to? Internal page 3 is the general designation, the local limits and all. There's a valuation notification also separate.
Yes, page 4.
Yes, page 4 is that valuation 1 crore up to 1 crore.
Yes.
But please come to the last page.
Page 5.
That is what is lastly there. In exercise of the power, governor after consultation is here pleased hereby to constitute with immediate effect 2 commercial courts at Calcutta for the purpose of exercising the jurisdiction powers.
2 commercial courts.
Now the
Which are the
difficulty is their point is that this is a commercial suit and as such has to be the order was passed in the capacity of a commercial court.
Well, that could not have been, my lord. That could not have been because the suit was not filed under the Commercial Courts Act.
By
Primarily,
your logic, then this notification will be rendered void because there is no commercial court then. Either all the courts have to be commercial courts because suits are pending for all.
but the issue today, my lord, 2 commercial courts.
Yes, why shouldn't this be treated to be one of those?
Because my
why
lord,
shouldn't this be valid and the others invalid?
My lord, now, if this thing is this, my lord, all the courts are taking up commercial suits.
If we get more than 2 appeals, then we can say that.
No, my lord,
because till there are 2 courts, I mean, this is the first matter which this bench is getting on this. So we'll say this is one of the 2 courts.
But
and another matter comes, we'll say that is the other court.
The other one.
The third matter, he will suffer.
My lord, in that even, my lord, kindly calls for a report from the registrar, my lord. But kindly.
I have taken, informally you have taken, we'll take judicial notice of that and put it in order.
Kindly seize this.
Put it in order. Registrar cannot improve whatever he told us.
No. Not that, my lord. I didn't say that.
And we have a bitter experience of calling for reports from the registrar.
No, I will not go into that. My lord. But there were 2 courts designated, my lord.
Yes.
And that apart, my lord, the suit as it stands, my lord, kindly seize the plaint for once.
Let us see the plaint and the construction, the framing of the suit.
Well, kindly seize the affidavit. The affidavit is a giveaway, my lord, whether the suit is a commercial cause or not.
Let us see those.
Page 17, my lord.
Page 17 is the plaint.
Page 17 is the affidavit.
No, this is the injunction application.
My lord, this is the opposition, my lord.
Oh, opposition. No, the plaint is annexed to the main application.
No, the plaint is annexed to the opposition, my lord. My learned friend is annexed to, my lord. The plaint starts at page 7.
7. Yes.
In the City Civil Court at Calcutta, before the learned 6th.
So this commercial suit does not mean anything because previously also.
Yes. So it's not a commercial division. Now, my lord, most importantly, my lord, page 11.
The valuation comes within the definition of
but the court has to pass an order acting as a commercial court. And whether, my lord, that such a suit is maintainable, kindly seize, my lord, page 11. That's page 17, my lord, the affidavit portion. This is the affidavit, my lord, which is used in a regular suit.
Maybe defective. Commercial suit may be defective, but the relief claimed is in respect of a commercial transaction over specified value.
I say, my lord, if it had to be filed as a commercial suit, then, my lord, the statement of truth, my lord, as in Order 6, Rule 15A, would have his application, my lord. Kindly seize Order 6, Rule 17A, my lord, 15A.
Now, here what has been done? I mean, the injunction has been granted. You are challenging grant of injunction.
Yes. But whether I come before the normal court or
yes,
the
that
commercial
is,
division,
that is
that's the issue.
We're considering that only now.
But kindly seize, my lord, after Rule 15, the following shall be inserted, namely, Order 6, amendment of first schedule, my lord, this Commercial Courts Act schedule, my lord.
Yes.
My lord, this amendment of first schedule, that's 4. My lord, it starts in order 6.
Yes,
Oh,
where is
B,
the
my lord.
where is the appendix? Appendix is in the Commercial Courts Act.
Yes, my lord, the schedule.
Schedule, yes.
It's after, my lord, section 23. The repeal and savings, my lord, section 23. Then after, my lord, schedule.
Yes, schedule.
C, section 16. My lord, text 4. Amendment of first schedule.
No, what is that? Appendix.
My lord, this the schedule, my lord.
Schedule appendix to the
It's after, my lord, section 20.
schedule you have got. Yes.
Schedule, my lord. Kindly sees. First is amendment of section 26.
Yes. Yes.
Then is substitution of new section for section 35. 2. Then, my lord,
এখানে তো অন্য পাতা। Yes. 15. Fine.
amendment of first schedule, my lord, that's 4.
Yes. Yes.
Now, my lord, kindly comes 4B in order 6.
Yes.
Order 6.
Rule 15A we have got.
Yes, my lord. Verification of pleadings in a commercial dispute. Notwithstanding anything contained in Rule 15, every pleading in a commercial dispute shall be verified by an affidavit in the manner and form prescribed in the appendix to the schedule. An affidavit such and such. Now, my lord, kindly takes the appendix.
No, we are wanting the appendix only.
Well,
This is
that's,
that the same.
my lord, that's after, my lord, 12. 11 is amendment of order 20. Then 12 after appendix
Yes,
8,
yes.
the following appendix shall be inserted.
Yes.
Kindly seize, my lord.
Yes. Yes.
I am the party in the above suit, competent to swear the affidavit, sufficiently conversant in facts of the case. I say statements made in such and such, true to my knowledge, statements made such and such, based on information, then such and such. I say there's no false statement. Then, my lord, 5. I say all documents in my power, possession, control, or custody pertaining to the facts and circumstances of the proceedings initiated by me have been disclosed and copies thereof annexed to the plain. And I do not have any other documents in my power, possession, and control or custody. Then I say the above mentioned pleading comprise of such and such pages, annexed as true copies, ever of any false statement. This has to be, in a commercial suit. This statement of truth must be there. The fact, that the affidavit appended to the plaint is not this giveaway that this suit is not a commercial suit.
Mere affidavit will decide that. If it's beyond the specified value and also it's relating to, it comes within the, suppose it's a commercial dispute.
But I choose not to file. I am the plaintiff.
Yes.
I do not intend this to be tried by the commercial division.
Do you have that option?
Suppose I do not intend.
Suit can be held to be not maintainable.
True, my lord. Now today, my lord,
it will be returned and presented.
Today, my lord, today there's no affidavit to the effect. The suit as it is filed, my lord, there are two issues, my lord. I say the suit as it is filed.
But the affidavit cannot determine the power of the court.
No, my lord.
The difficulty is, Mr. Bordhan, then this notification has been implemented. This has come into force. 2 courts in city civil court. Now we have to give some effect, because then the difficulty will be commercial suits will be filed before the, otherwise those will be time barred. Those have to be permitted to be filed in the city civil court.
The valuation of this suit is 78 lakhs. So probably the High Court has concurrent jurisdiction.
That's true. But that point also has to be taken by before the commercial division.
But may I put this to question by myself? Now
you can take both the points. That affidavit point you can take the point whether these. But
today I am on a point that the suit as framed and as decided by a court, that court was not functioning as a commercial court. Let's put it this way, many times tribunals are formed pursuant to notifications, but tribunals do not function. So it is not as if, my lord, once a notification is floated, my lord, the tribunal start functioning or the court start functioning. Here, my lord, the notification is there. There's no qualms on the scope, my lord. But whether, my lord, the designated benches of the city civil court are functioning as commercial courts, that is the core issue, my lord.
But Section 13 determines the appellate power. Section 13(1)(a) is very clear. Any person aggrieved by the judgment or order of a commercial
court
at the level of district judge.
But I say this order that has been passed was passed by a court not exercising the jurisdiction of a commercial court. Because, my lord, there has to be two commercial courts, but there has to be a designation. My lord, kindly sees Rajarhat Court functions as a commercial court. And here it says two commercial courts at Calcutta for the purpose of exercise jurisdiction. Madam, whether the existing courts can function as commercial courts, that is also an issue, my lord, which has to be gone into.
Direction immediately
is hereby
designate. Is to constitute immediately notification came in English. Two commercial courts at Calcutta for the court. Courts separate to commercial courts have not been constructed there in civil court. That is the current scenario. So now the power has been given to all the.
How can that be, my lord? I may pose the question myself. My lord, kindly takes it one step further, my lord.
What will be how will the void be filled? Suppose physically the commercial court has not been constructed. How will the commercial suit be filed?
In cases where the high
court, they are
court
filed in ordinary courts, then they will be held to be not maintainable there.
Well, may I put this to myself, my lord? If they are filed in normal courts, my lord, merely because the court is not functioning, my lord, a person cannot be held guilty or cannot put to ransom because of that, my lord. My lord, most importantly, my lord, two courts have to be designated. And here is the case, my lord, the valuation of the suit is 78 lakhs. So it is not a case or not a situation, my lord, where the plaintiff cannot approach any other court or he is precluded from knocking the doors of any other court. I would have still understood if that city civil court was the only court where the plaintiff could have gone to, my lord. But here, my lord, the plaintiff could have very well knocked the doors of his Honorable High Court.
Interesting point. Yes. What else, Mr. Vardhan, on this?
This is but so far as
we are hearing only on the
yes, merits are concerned.
Merits will come later. Yes, Mr. Banerjee, what do you say to this?
Your lordship would kindly take how I have framed my suit.
We are telling you the factual scenario. You argue on that so that you can argue on that also. Commercial courts, this notification is there. Physically, two commercial courts have not yet been created in the city civil court. Now, what is being done is that the commercial suits which are being filed are being allocated to distributed between the courts. First of all, whether that can be done, because if it's not a designated, if two particular courts are not designated as commercial courts without any designation, whether they can function as commercial courts. If they can't function, then appeal lies as an ordinary court. And secondly, whether these two courts, I mean, how do you ascertain whether this court was there? And also this violation of 15A, the affidavit, procedural violation.
So far as the procedure.
And you had an option to file the suit before the commercial division of our court.
My lord, so far as the procedural violation, my lord, it has fallen from your lordship, and that will be my submission also. That mere non-compliance of a procedural formality does.
All right, that is the best point you have. The other points.
Other base point.
You
I
could
have-
have, if you wanted it to be a commercial suit,
The other
intended,
base point.
you could have approached the commercial division of our court.
The other
Yes.
best point I have is, my lord, whether in view of the proviso appended to section 13 of the Commercial Court Act, my lord, can my learned friend maintain this appeal before your lordship? Why I tell your lordship? I'll just, my lord, an appeal is a creation of statute. An appeal, my lord, is a substantive right.
No, the question here is whether that was functioning as a commercial court.
Difficulty is this, my lord.
13.2 is obviously there if it's a commercial court.
The commercial, my lord,
Only
whereas-
then.
my lord, he has to raise this issue before the hierarchy set in the Commercial Court Act.
Why should he, if the court in the first place was not a commercial court?
My lord,
It was not functioning as a commercial court.
but
If it is not
according-
designated specifically as a commercial,
according to me, my lord, it was functioning as a commercial court. Because I have the notification, I have filed it.
you have what notification?
Notification that
There is
I have
no
produced.
specific notification that this court was a commercial court.
My lord, this is
What is the system there? You file it before the chief judge and it's allocated to a particular bench.
Not true. My lord, that, my lord, I have to take instruction.
Even if that be so, then even the chief judge, if the chief judge allocated it, then also it would not be rendered, turned to be a commercial court automatically.
It takes paragraph 17 of my plaint once. Kindly takes paragraph 17 of my plaint. Page 13 of my affidavit in opposition.
Yes, para 7.
That as the issue involved in the present falls within the category of commercial suit, under section 2 of the Commercial Courts Act 2015, filed an application under pre-institution litigation under 12A of the Commercial Courts Act on 18/4/2024 before the District Legal Services Authority. However, the notice of the same has been served. My lord now kindly takes their averment to my injunction, to their injunction objection. Objection of my injunction application.
Who filed? They filed this application.
This is
12A application was filed.
ad interim, my lord, it was mine.
12A application.
Yes. Their application.
Oh, you are the plaintiff, sorry. Yes, the plaintiff obvious. So you filed this application, right?
Filed the mediation, my lord. We
So
could
they participated in the mediation.
not participate in the mediation because no notice was served, my lord. Under such compelling circumstances, I had no other alternative other than to file this commercial.
Difficulty, Mr. Banerjee, language of section 13 is not in respect of a commercial dispute. It's if an order is passed by a commercial court. That is the difficulty. The language is not against an order, appeal against an order passed in a commercial dispute. That is not the language. Order passed by a commercial court. Suppose it's a commercial dispute, it's wrongly filed before an ordinary court. Then also, then this appeal does not lie under this act. Unless it's a commercial court in the first place.
My lord, my submission, it's a commercial court because, my lord, there is this is the latest notification that I could lay my hands on.
This notification says 2 courts will be designated.
Commercial courts.
Till date, 2 particular courts have not been designated. So what will be the effect?
My lord, will kindly take into consideration, my lord, where family courts in all districts have not been formed. But
Always they are designated to take up matters from some district. Like Rajarhat. Like Rajarhat, these commercial courts, all of them have been designated with particular areas. The city civil court, we discovered through your matter that this is the mess happening in the city civil court.
But they are taking the commercial disputes and, my lord, orders are being passed. Orders are being passed and, my lord,
At this point was never taken in an appeal.
and they have not, my lord, would kindly also visualize this situation. This point have not been taken by them in the trial.
Could not before an appeal is filed. They,
Ad interim order. No, it's not an ad interim order. It's a injunction order.
what point will they take? Where an appeal will lie, they cannot take before an.
They could have said that you do not have jurisdiction to entertain this suit. You are not exercising jurisdiction under. Kindly visualize section 21 of this Code of Civil Procedure.
Again, Mr. Banerjee, you are coming back. Suppose you filed it as a commercial suit.
Yes.
Both parties proceeded on such premise. The court has to be a commercial court for an appeal to lie before the commercial division. Even if both of you proceeded, but the court is not a commercial court, not a designated commercial court, then an appeal will lie before a normal court.
My lord, they ought to have raised this issue there also, my lord. They have not raised this issue that
Could not have before the appeal is filed.
My lord, when this injunction order was passed on contest, my lord, in their written objection or during the hearing, they could have taken this plea that this particular court does not have jurisdiction under the Commercial Courts Act. That they have not taken.
You have not framed the suit as a commercial suit.
Yes, I have framed that suit. That's why I read
So
out
as-
paragraph 17, my lord, of the claim.
That is the only, but the affidavit is not in line.
The affidavit is not in line, but my
What
lord,
else is there? You have mentioned anywhere else that it's a commercial dispute.
And my lord,
Where,
kindly
where?
take- Your lordship would kindly take the cost title, page 7, commercial suit number 17.
Commercial suit happened before this act also. So that is
Commercial-
not an indicator.
Now, I have said that this transaction between the parties is a commercial transaction, and they have admitted that this is a commercial transaction.
Suppose it's a commercial suit filed in a non-commercial court, non-designated commercial court. Then what happens? Under section 13.
But I would say, my
Can
lord,
we treat it to be a commercial court?
but I would say, my lord, this court has jurisdiction.
Which court has jurisdiction? This court does not have jurisdiction. This court does not have jurisdiction. The commercial appellate division has jurisdiction.
Yes, that I am saying, my lord, the learned fifth bench has.
Acha.
Lord, now the situation would have been otherwise. I would still
But Mr. Borden, that will be an injustice on them. Because they filed the suit, definitely the intention was.
kindly visualize this.
See, it falls within a commercial dispute. 12A they resorted to. They expressed clear intention that it was intended to be a commercial suit. Now, if it's an issue with the administration, what can the parties do? I mean, it has to be treated to be a commercial.
I would have understood, Lord. I would have understood.
It's our
I-
fault, not
I would have
the
understood.
party's fault.
I would have understood had they availed of the jurisdiction of the Honorable High Court. They had a jurisdiction, my lord. It is not that they did not have the liberty to
But they
approach this
also
court.
had the option to go to the city civil court.
But if a city civil, my lord, may I put this way?
Can you appreciate what the consequence of our judgment will be if you say that this is not a then all the commercial suits filed in the city civil court go.
But I understand, but at the same
All of
point,
them will become rendered with a stroke of a pen. All suits will be rendered non-maintainable.
understand, my lord, but kindly visualize this.
That's
Here is a,
clear.
my lord, here is a case.
Proportionate.
I would understand, my lord, but here is a case where the doors of this court was open to them. It is not as if they were without a remedy. I would have understood the valuation of the suit was such that they were without a remedy. I would have understood. But here, my lord, they have had this court, my lord. They had this court to come to. It was not as if they were without any remedy.
What would be the effect, Mr. Borden, in cases which fall beyond below that 10 lakh or 3 to 10?
Ordinary suit.
Then they
Till
won't
that
be.
time,
They will be deprived from the Commercial Courts Act. What view?
May I say this, my lord?
Cannot be.
Well, may I say this? But till the designation is done, can that court, my lord, exercise the power of a commercial court?
We'll deem that this is one of the two courts. Nothing in the
But tomorrow, my lord, may I put this? If tomorrow a third court comes, what happens then, my lord?
whatever you said.
My lord, kindly visualize, my lord. Courts have to be designated to be functioning as commercial courts. And my lord, I was still would have understood, my lord. As I say, my lord, for sake of repetition, my lord, the High Court was open to them. Had they been without a remedy, I would have understood. They were without a remedy, they approached the court.
এটা তো স্টেট করতে হবে পার্টিকুলার কোর্টকে কি আমরা ডেজিগনেট করতে পারবো স্টেট তো যা করার করে দিয়েছে দুজন জজের প্রভিশন করে দিয়েছে কমার্শিয়াল কোর্ট করে দিয়েছে হাইকোর্ট কি করবে সাজেশন হাইকোর্টকে দুটো কোর্টকে ডেজিগনেট করা বুঝছেন কোর্ট নাম্বার পেজ নাম্বার সেটা হাইকোর্ট করবে না সিভিল কোর্টের চিফ জাজ করবে ওর ক্ষমতা নেই ক্ষমতা নেই আর সেকেন্ডলি বিলো 3 লাখ আছে সেটা ডিস্ট্রিক্টের কমার্শিয়াল কোর্টে যাবে এখানে তো কনকারেন্ট জুডিকশন হচ্ছে হাইকোর্টও করতে পারে সেটা 3 লাখ থেকে 10 কত আছে 10 লাখ না কত সেটা কোন তো শুধু ওর তাহলে সেই ম্যাটার গুলো কি হবে এটা এক্সক্লুসিভ ওখানে যাবে এক্সক্লুসিভ ওখানে যাবে কোথায় যাবে সিটিজেন কোর্ট সিটিজেন কোর্টে সেটাই there is no আজকে দাঁড়িয়ে এই নোটিফিকেশন থেকে আজ পর্যন্ত কমার্শিয়াল কোর্ট থেকে আজ পর্যন্ত তাহলে এই সুটগুলো কি হবে আমরা যদি বলে দিই তাহলে সব সুট চলে যাবে সব সুট নন পয়েন্টেবল তাহলে অ্যাক্টের পারপাসে ফ্রাস্ট্রেট হয়ে যাবে না we reserve judgment on this point what can be done think it over because the effect will be disastrous your logic seems to be more feasible but the effect consequence of that order will be disastrous We'll also have to think of that.
No, my lord,
We are also a court of equity.
my lord, may I put this to my lord? Suppose, my lord, tomorrow, 4 orders passed by 4 different courts come before your lordships. All commercial disputes.
Those will be deemed to be commercial courts because the chief judge allocated to them. Those have to be deemed. Although it's written to till the commercial courts are formed, ordinary courts we shall put it in our order that they will be deemed to be commercial courts if the suit is above specified value and
I bow down, my lord. Had this been a case where the value would have been somewhere in the range of 3 to 10, I would have understood. But this 79, so this court was open to them. They were not without a remedy. I could appreciate, understand, my lord, where 3 to 10, where does the litigants go?
Mr. Borden, we cannot take away the collateral jurisdiction which
I must say that, my lord,
can avail of that.
My lord, may I put this? My lord, suppose, my lord, where tribunals.
Their case, it may be that scenario, but in a case where they don't have that option, it's between 3 and 10.
My lord, in my
What
most
happens to them?
Submission, my lord, it should be on case-to-case basis, my lord. Where, my lord, a party has the liberty of approaching some other forum, he must approach some
If
other
it's
forum.
between 3 and 10, what can be done? They have to go before a commercial court under the Commercial Courts Act. And what will be the remedy for those people? They won't file the suit.
May I put this? So far as 3 and 10 are concerned, my lord may pass directions or whatever.
The same logic, why shouldn't it apply to a collateral jurisdiction? Because that's an advantage given by legislation to them.
Yes, my lord.
Not legislation, exactly notification.
Notification.
That's an advantage given to litigants. You can go either to the city civil court or to the high court.
But till the time that's
the
not
fee
constituted-
structure may be different. There may be several reasons I may choose. I have that option.
Yes, my lord. I say
That option is taken away then by judicial order.
My lord, next issue is, my lord, many
And there will be discrepancy then between collateral jurisdiction matters and where only civil court has jurisdiction.
even otherwise, my lord, till the time this came into effect, my lord, when the city civil court and the high court exercise concurrent jurisdiction, my lord, people were free either to approach this court or the city civil court, my lord. Those options are always open to them.
Yes. They've exercised one of the options.
Yes, my lord. So here,
if
my
they
lord,
choose that option, why should that be closed to them?
what I say, my lord, for 3 to 10, I understand, my lord. But above 10, my lord, as it stood at the time when the suit was instituted, my lord, they had a liberty to coming before this court.
No, Mr. Borden.
My lord, all those, my lord, kindly visualize this, my lord, where, my lord, tribunals are formed and tribunals don't function, where, my lord, a particular a tribunal takes, my lord, the power out of the civil court on some clause or the other, my lord, till the time the tribunals are formed, my lord, the civil court exercise jurisdiction. Till the time, my lord, the tribunals are, my lord, formed and functioning, the civil courts exercise jurisdiction, my lord.
Does the act give an option to them to choose an ordinary court? I don't think there is an option. Don't think there is an option.
No, my lord, I don't say it gives them the option to choose the alternative court. I say they had an option. The
That is
act
for their
gave-
case, but we are generally deciding whether this court is a commercial court. It's on a larger footing, Mr. Borden. Not about this case only. We then have to hold that this court was functioning as a commercial court or not. And that is the language of section 13.
Yes, my lord.
So our decision will not be on this case where they had an option, they could have gone, might have. We have to hold whether that court was functioning as a commercial court or not under the act. For that, we have to be on a general premise. We cannot take a marginal case. Am I clear on the, are we clear on that, Mr. Borden?
appreciate
Because
that.
we have to hold that this is a commercial court or not a commercial.
Broader picture.
Yes, we have to hold due to the language of section 13. It's not that in respect of a commercial dispute, appeal lies before.
No, commercial court.
Commercial court. So we have to hold whether that is that was
commercial court or
function
not.
as a commercial court or not.
Now, my lord, as a cost of repetition, my lord, now tomorrow, my lord, if 4 different orders come before your lordship, 4 different courts.
We'll have to hold,
Hold that-
Mr. Porter, the answer to that is,
two courts.
we'll have to hold that all, despite this, the governor's designation of 2 commercial courts, those courts have not been formed, which will be our reason here also if we hold against you, that 2 commercial courts have not been formed. As such, for the time being, all the courts of the city civil court will be deemed to be functioning as commercial courts. We'll make it a judicial order.
Then my lord will hold this suit.
It will be judicial legislation.
So my lord will hold this suit to be a commercial suit.
No, this suit has been framed as a commercial suit. 12A has been resorted
So
to.
my lord, no, my lord, so this suit is a commercial suit then. If my lord holds in fashion, so my lord, this suit will be.
You have to go before the commercial appellate.
But the suit will be a commercial suit.
Yes.
So my lord will hold it that this suit is a commercial suit.
Yes. Means What does that
Fine,
mean? That's
fine.
a threat, warning or threat or what?
No, that's not threat.
We are very shaky.
Probably,
When you say this, oh, then we are very shaky. What do you mean exactly?
Probably I'll be able to save my client.
Achha, very well.
This is a commercial suit as well.
Hmm.
If this suit is a commercial suit, I might advise my client that he has a good enough case to plead.
No, yeah, very well, but no, we'll have to. The only doubt in our mind is with what will be, whether it will be a vacuum, as you said, as you argued. I mean, till suppose a commercial court is not formed, what will happen in the interregnum? Whether ordinary civil courts, whether the suit, they can file ordinary suits then.
Or else they can file suits in any court of civil court.
That is a different proposition. Then those will be deemed to be commercial courts.
But they can only 2 commercial courts.
As per this notification, we'll override the notification. We have till will not override actually. We'll say that this has not been materialized as yet. So what will be the vacuum? There cannot be a vacuum. What will be the situation in the interregnum? So we'll judicially hold that all these city civil courts of the city civil court will have power. That's a tall order, but we'll have to look into the act also, whether we can do that at all.
That I leave you lot.
And all the more because there is no further challenge before this court against our order. That's why you have to be all the more cautious. কিছু নেই, যতদিন না হচ্ছে কোথাও কিছু নেই, একটা কোথাও বলো না, এতদিন তো এই ঘাটছিলাম আরবিট্রেশন নাকি।
On the first day, I expressed this to you, my lords, that I couldn't lay my hands on any notification designating this court.
There is no notification, not your fault or his fault. এটা অর্ডার লিখে নিন, ফেলে রাখলে কোনোদিন হবে না। A preliminary objection is taken by the respondent as to whether the present appeal is maintainable ওটা তো আলাদা, ওটা অর্ডিন্যান্স। কি বললাম? Before this court, comma, which has been conferred power as an ordinary court of first miscellaneous appeals as per the roster of this court, comma, as opposed to the commercial appellate division of this court. Who's up next para? Learned counsel appearing for the respondent argues that the suit as framed, comma, is a commercial suit within the connotation of the Commercial Courts Act 2015. Full stop. Learned counsel relies on the caption of the suit as a commercial suit and also attracts the attention of the court to paragraph 17, where it has been specifically stated that the present case falls within the category of a commercial dispute under section 2 of the 2015 Act, and that an application, a pre-institution litigation application under section 12 capital A of the said Act has been filed by the plaintiff stroke respondent before the District Legal Services Authority. Pushed up next para also, comma, it is pointed out that the value of the suit and the relief sought in the suit comes within the ambit of specified value as referred to in the 2015 Act, and the transaction between the parties, which is the genesis of the legal action, comma, is also a commercial transaction within the contemplation of the 2015 Act. Full stop next para. As such, comma, the present appeal has to be filed before the Commercial Appellate Division of this court in terms of section 13 within bracket 1 capital A of section 13 within bracket 1 capital A of the 2015 Act. Push up next para. Learned counsel for the respondent also relies on several notifications pertaining to the City Civil Court, pushed up by a notification dated March 20, 2020, issued by the Judicial Department of the Government of West Bengal, comma, power was conferred on the City Civil Court of Calcutta to take up commercial disputes not less than rupees 3 lakh and not more than rupees 10 lakh exclusively, and exceeding rupees 10 lakh but not exceeding rupees 1 crore, comma, concurrently with the commercial division of this court. Full stop. Next para. In case of commercial division of the High Court Calcutta, comma, the jurisdiction would lie of an amount exceeding rupees 10 lakh. Full stop. Thus, comma, if the specified value of the dispute is between rupees 10 lakh and rupees 1 crore, comma, the commercial division of this court and this commercial court of the City Civil Court at Calcutta would have concurrent jurisdiction. To sub next para, learned counsel also places reliance on a further notification of the self-same date where it was mentioned that in exercise of the power conferred by subsection 1 of section 3 of the 2015 Act, comma, the governor, comma, after consultation with the High Court, was pleased to constitute with immediate effect 2 commercial courts at Calcutta for the purpose of exercising the jurisdiction and powers conferred on those courts under the said Act. Full stop. It is submitted that, however, comma, since no such commercial court has been specifically designated by name till date, comma, all the courts in the City Civil, all the judges, all the benches of the City Civil Court of Calcutta at Calcutta are deemed to be conferred with the power to deal with commercial disputes and are being allocated commercial suits. Full stop. Next para. Learned counsel appearing for the defendant appellant categorically controverts such allegations. Full stop. Learned counsel places reliance on the amendment to Order 6, Rule 15, capital A of the Code of Civil Procedure by virtue of the Commercial Courts Act 2015. Full stop. It is argued that in terms of the said amendment, comma, a statement of truth has to accompany the affidavit in support of a plaint in a commercial suit, comma, the format of which has been given in Appendix I, capital I, to the schedule of the 2015 Act. Full stop. It is pointed out that the affidavit accompanying the plaint in the present suit does not at all adhere to the requirements of the said format, and as such, comma, it cannot be deemed that the suit was intended to be a commercial suit. Full stop. Next para. It is further argued that in view of the valuation of the suit as disclosed in the plaint being rupees 79,93,083.11p, comma, the same fell within the concurrent jurisdiction of the commercial division of this court and the commercial courts in the City Civil Court at Calcutta. Full stop. Hence, comma, in the absence of any specific designation of any particular court in the City Civil Court of Calcutta, comma, it was open to the plaintiff/respondent to approach the commercial division of this court to file the suit. Full stop. Having had such option but deliberately chosen not to do so and file the suit in the City Civil Court at Calcutta, where no specific court has yet been designated as a commercial court, comma, it should be construed that the suit was filed as an ordinary suit, not coming within the ambit of a commercial suit under the 2015 Act, and as such, comma, this division bench has determination to take up the appeal in connection with any order passed therein. Full stop. Next para. A peculiar conundrum has brought to light in the present case before us. Full stop. Although in exercise of the power conferred under section 3 within bracket 1 of the Commercial Courts Act 2015, comma, the governor of West Bengal, comma, in consultation with this court, comma, had constituted, comma, vide a notification dated March 20, 2020, comma, with immediate effect, comma, 2 commercial courts at Calcutta for the purpose of exercising the jurisdiction and powers conferred on those courts under the 2015 Act, comma, fact remains that no specific commercial court has come up till date in pursuance of such notification. Full stop. Hence, comma, now we further take judicial note of the fact that there has not yet been any specific notification designating any two particular benches of the City Civil Court at Calcutta as commercial courts in pursuance of the notification number 156 JL dated March 20, 2020 referred to above. Full stop, next para, thus, comma, the position remains that as of today, comma, there is no specific court or bench in the City Civil Court which has been particularly designated by name as commercial courts within the contemplation of the 2015 Act. Full stop, next para, the larger issue which falls for consideration, comma, thus, comma, is whether the operation of the 2015 Act would remain in limbo merely because there is an administrative void in specifically designating two courts as commercial courts in the City Civil Court at Calcutta. Full stop, next para, a composite reading of all the provisions of the Act, 2015 Act, clearly indicates that the same came into force with effect from with effect from its date of notification, that is on October 23, 2015. Full stop, next para, thus, comma, on and from October 24, 2015, comma, if the valuation of a dispute comes within the comes within the definition of specified value under section 2 within bracket 1 within bracket small I of the 2015 Act, and if the matter pertains to a commercial dispute within the meaning of section 2 within bracket 1 within bracket small c of the said Act, comma, there is no option open to the parties to approach an ordinary civil court with the said dispute, and it is the commercial court or the commercial division of this court, comma, depending on territorial jurisdiction, comma, which and only which has the exclusive jurisdiction to take up such suits. Full stop. In such a situation, comma, there is no other option for this court but to judicially interpret the fix which we are in by interpreting that, by construing all the benches in the City Civil Court at Calcutta, comma, till the formation of two specific commercial courts in terms of the notification dated March 20, 2020, to be deemed to function as commercial courts within the contemplation of the 2015 Act. Full stop, next para, otherwise, comma, the effect would be disastrous, comma, since all the commercial suits which have been filed in the interregnum after the enactment of the Commercial Courts Act 2015 before the City Civil Court, comma, by treating those to be commercial suits within the contemplation of the 2015 Act, comma, would be rendered bad and or non-maintainable, comma, for no fault of the litigants. Full stop, next para, as such, comma, the only way we can harmonize between the gap in actual administrative action in forming commercial courts in the City Civil Court of Calcutta and the purpose and intention of the Commercial Courts Act 2015 is to bridge the two by construing all the benches of the City Civil Court of Calcutta which are functioning at present to be empowered to entertain commercial suits stroke commercial disputes within the contemplation of the 2015 Act till two specifically designated commercial courts come up in the City Civil Court at Calcutta in pursuance of the notification bearing notification number 156 JL dated March 20, 2020. Full stop, next para. Seen from such perspective, comma, we find that on a plain reading of the plaint in the instant suit, comma, which is the genesis of the present matter, comma, the same was for a dispute of specified value coming within the contemplation of 2015 Act and relates to a commercial dispute between the parties. Full stop, next para. Also, comma, in paragraph 17, the plaintiff made its intention very clear to treat the suit as a commercial suit by taking resort to Section 12 capital A of the Commercial Courts Act 2015 and asserting that the dispute between the parties is a commercial dispute. Full stop. With regard to the discrepancy and or error in the affidavit, comma, which is not in proper format, comma, it is always open to the defendant stroke appellant to take such point, to raise such objection before the trial court. Full stop. However, comma, such defect per se does not render an otherwise commercially suit a non-commercial suit only for such reason. Full stop. Next para. The appellant, comma, otherwise, comma, is justified in submitting that the caption within double inverted commercial suit, double inverted clause of the plaint does not ipso facto render it to be a commercial suit under the 2015 Act, since even before the promulgation of the said Act, comma, commercial suits being captioned as such were being filed in the City Civil Code. Full stop. However, comma, even without laying stress on the caption of the plaint, comma, for the reasons as indicated above, comma, we find that the court concerned in the present case, that is the 6th bench of the City Civil Court at Calcutta, acted as a commercial court within the definition of the 2015 Act, and as such, comma, an appeal against an order passed by the said court under Section 13 within bracket 2 of the 2015 Act shall lie before the commercial appellate division of this court and not before this bench, which is acting as an ordinary appellate civil court, civil bench. Full stop. Next para. Accordingly, we hold that accordingly, we release the matter on, then it should be filed also in proper format. Accordingly, we hold the present appeal not to be not maintainable in its present. We'll give you that leave. No, it cannot be. You have to file it in a different format. Not maintainable in its present form. Full stop. Leave, comma, however, comma, is granted to the appellant to present the appeal in appropriate formal before the commercial appellate division of this court within a fortnight from date. Full stop. Next para. It is made clear that in view of the bona fide error and misconception of law under which the appellant was proceeding, comma, in view of the legal void in the field, comma, we deem the benefit of Section 14 of the Limitation Act to be extended to the appellant for the period during which the appeal was pending before this court and the further period of a fortnight which we grant for presentation of the appeal to the appellant.
Will the interim order continue, my lord?
My lord, the
No,
interim order, my lord,
cannot
would
continue.
kindly vacate, my lord, because my lord is disposing of.
In view of the above, comma, the interim order granted earlier stands vacated with liberty to the appellant to renew such prayer before the commercial appellate division along with the appeal as and when the same is presented before the same division. Full stop. It is further clarified that we have not entered into the merits of the respective contentions of the parties at all.
I'm grateful, my lord.
Thank you. ঘেটে রেখে দিয়েছি যে কিছু করে আমি তো আমি তো জানি অনেক কিছু হয়নি প্রসেস আছে ওখানে ট্রানজিশন আর ওখানে জয়শ্রী ভালো পড়াচ্ছে মানে একটা শুরু হয়েছিল কি সব হয়ে গেছে দেখছি
Plaintiff
মধ্যে চলবে তো দেখছি Yes.
But plaintiff is the appellant before your lordship, my lord.
Right.
Suit for declaration, injunction, and partition has been dismissed, my lord, on the ground that, my lord, in the plaint it was stated that the sum of the properties have been wrongly mutated in the portion of the property has been wrongly mutated in the name of the respondents, my lord. The court holds that as per section 51C, you have to move the land reforms tenancy tribunal first, thereafter file partition.
Where are the reliefs of the prayer portion of the plaint? Shows there. Have you annexed the plaint? No. Should have annexed the plaint, Mr. Chen.
My lord, I've got
Not
it.
expected. You have a copy?
My lord, yes.
Settled consequential relief যদি হয় in aid of the main relief যে
page
record
7,
correction করতে হবে তাহলে
page 6 and 7, the prayer post.
6 and 7.
Running page 6 and 7.
Oh, sorry. Yes, if you agree, we'll dispose of the appeal itself. Why keep it pending? We'll grant stay. It will remain forever before this court.
Application be disposed of.
We'll dispose of the appeal and the application together and remand it to the trial court to hear it on merits, decide it
The
on merits.
difficulty, my lords, he is appearing for some of the respondents only.
6 and 7.
And there are 3 sets of respondents, my lord. State also, my lord, was a party and my lord appeared and contested by filing written statement.
We'll fix the appeal and application together for hearing. Have you granted an injunction?
My lord.
That injunction will continue. We'll fix the appeal and application. We'll hold that. We'll say that you will prepare informal paper books within a week. You have to annex only the plain. No. Yes. Oh, here the suit has been dismissed at the outset or at the final hearing?
Final hearing.
Then that cannot be done. You'll be very happy, Mr. Sen, to get an injunction till eternity. No, we'll record something in order, serve notice on the other respondents and come back.
But I served, my lord, the others, my lord, received, my lord. Only respondent number 2, my lord, refused. So that is also good service.
Good service, but that is for the purpose of the application. They have to be given a notice.
Serve upon the
Advocates in the court. The present application has been filed in respect, in connection with an appeal, which involves a very short question. Push up next para. The learned trial judge dismissed the plaintiff's stroke appellant's suit for declaration of title, partition, as well as consequential permanent injunction on the ground that the records of rights, that in the records of rights, the subject property was recorded, portions of the subject property were recorded in the name of some of the parties to the suit. Push up next para. The court proceeded on the premise that the suit is as such, barred. Where is that finding?
That my lord will find, my lord, in the memorandum of appeal, my lord. Judgment para 58, my lord. Para 58 of the judgment. It's a longish judgment.
Para 58 onwards, my lord.
Para 58 onwards.
Yes,
my lord has recorded, my lord, in the interim order, my lord.
Very well. Barred under section 51, capital C of the West Bengal Land Reforms Act 1955. Pushed up. However, we prima facie find from the records that the learned trial judge proceeded on a fundamental misconception of law, inasmuch as the reliefs claimed in the suit could not be granted by the authorities under the West Bengal Land Reforms Act 1955, pushed up, even if the consequence of the grant of the decree as sought in the suit might be that the records of rights are required to be corrected in consonance therewith, the same would only be a collateral effect and does not determine the ambit of the suit itself. Pushed up. The suit has been filed clearly for declaration of title and partition, which are the primary reliefs sought. Pushed up. The other reliefs are only in aid of the said reliefs. Pushed up. It is only the civil court which has the jurisdiction to decide such issues and grant the reliefs as sought in the suit, and as such, the impugned judgment is prima facie palpably erroneous. Pushed up next para. However, the court is handicapped due to absence of the other respondents than respondent numbers 6 and 7 at this juncture. Pushed up, since all the respondents have been substantially served, which is borne out by the affidavit of service, can 1 of 2024 is disposed of by restraining the respondents by an order of injunction from transferring, alienating, encumbering, and or creating third-party interest in the suit property, and or from making any construction in the suit property. Full stop. However, comma, in view of the short ambit of the appeal, comma, the appellants are directed to prepare and file informal paper books within 4 weeks. You take out certified copies. Informal paper books without comparing with the records within 4 weeks from date, and circulate copies thereof on the learned advocates for the respondent. No, circulate copies thereof on the respondents, comma, directly and stroke or through their learned advocates in this court, and stroke or through the learned advocates appearing for the absentee respondents in the court below. Full stop. Next para. Upon such service being effected, comma, liberty is given to the parties to mention the appeal for hearing on the basis of the informal paper books. Full stop. Insofar as service of notice of the appeal is concerned, comma, the appellants shall put in due requisites for service of notice of appeal on the respondent numbers 1 to 5 and 8 to 10.
But so far as 4 and 5, BLRO and state, that can be
Waived. Acha. Acha, 1.
They contested, they filed it instead.
Then you have to.
I will give the office of the.
That is direct service. যা বললাম 2 10 10 দিয়ে শেষ করলাম তো 8 to 10 within a week from date. This much you cannot do further. Thank you.
I am for the plaintiff respondent.
Yes, Mr.
I am for the appellant, my lord.
Right.
I have served the my lord, with the affidavit of service, my lord. I'm.
What is the judgment and degree?
I'm humbly praying, my lord, as a week's time, my lord, to come back, my lord.
Why?
That there are some.
Are you enjoying any interim order?
No, my lord, no.
Then we
They also put the decree on execution.
What is the degree? Degree for?
Eviction.
Degree for eviction.
So why are you taking time?
But there's some problem, my lord. That is the reason why. A week's time, my lord.
All the respondents have been served. You are appearing for all the respondents.
All the respondents.
All the respondents.
I am for the plaintiff respondent, yes.
All the respondents. Affidavit of service filed to be kept on record. Full stop. On the prayer of learned counsel for the appellant, the matter is adjourned till when?
Week, my lord.
Till February 24, 2025.
Instead of 24, can it be taken up at 25th?
Very well. Till February 25, 2025.
Number 28.
For the respondent.
Respondent. None appears for the appellant, although the respondent is represented through counsel. Full stop. Let the matter stand adjourned for the day. Let us give them another chance. If they don't appear tomorrow, last chance, then. Yes. Guardians and Wards Act, custody. Why don't you give a notice to them that it was appearing? Should you put that in our order?
I appear to the respondent, my lord, custody, their prayer refused. My lord,
Yeah, Your Lordship.
Your matter is over.
My apologies, Your Lordship.
Din ওটা দিন ওই অর্ডারটা কেটে দাও. Yes, you take up the matter. You are asking for custody of a child.
No, Lordship. Only 28, I'm in 28.
Here, the case, the father is being the natural guardian, the custody has been denied. Under section 12, on the ground that he is not at all, my lord, eligible. It is, my lord, I think, contrary to the recent judgment passed by the Honorable Effect Court, my lord, where it has been categorically stated that other, my lord, the guardianship right should be given preference over any other, my lord.
Father is. It's not the right of the father. It's the paramount consideration is the welfare of the child.
But that
What
has
is
not
the?
been discussed.
She or he, daughter or son? Son. What is the age?
The age is 7. Subject to correction, age is 7.
Subject to correction by whom?
My
2018,
just
but here is 20.
My lord, what happened, my lord? The mother has a premature death.
Acha.
Thereafter, my lord,
Who are they then?
my lord, they are the maternal grandparent.
Oh, yes, there is a judgment probably.
Yes, very recently.
Have you
my
got
lord.
that judgment?
Yes, sir.
Is that in that packet?
Yes, no, that is it.
That judgment is in that packet.
No. That is in with my
Cite it.
I am citing now. Can you see, my lord, this judgment has been recently.
I saw it in live law, so that does not. You have taken out from which website?
I have downloaded. My lord,
From the Supreme Court? This is not the Supreme Court.
no, this is my lord, Supreme Court. Not,
Supreme Court website.
my lord, yes, my lord, not the Supreme Court official website. My lord, I have downloaded the live law. Because my lord, the Supreme Court official. What
Live law is not. You cannot take that.
Have a look, well.
We have a look, but you have to take it out from the official website of by the name of the parties. You can get it from the official website of the Supreme. Have it and come back tomorrow. And give him an advance notice. Give the names of the parties to him. He also come prepared on that. That is against you.
State of Uttar Pradesh.
We saw it on the live law also, but that live law is not. I mean, till now not recognized.
But my
Not
lord, they
recognized.
are my lord, the heaviest corpus. My lord, only but my lord, after all, my lord, that is also maintainable.
What habeas corpus?
My lord, what happened, my lord? The petition. They are.
Why was it not granted to you?
But it was not granted, my lord. I fail to understand, my lord, why. But there is no cogent reason has been given. Only ground says that because my lord, I made once in a 3 months, my lord, that is the only consideration.
The child is otherwise with you.
Yes.
When did the mother die?
Mother died in 2022.
Since then, the child is with you.
Before
Well,
that,
the child has been forcibly taken from my position. So
Yeah.
mother was there for treatment.
They will bring that judgment. Come back tomorrow. Learned counsels for the appellant seeks to rely on a judgment and is requested to cite a formal copy thereof. Puts up accordingly. Let the matter stand adjourned till tomorrow. What is the defect? Wrongly classified as FAT. Oh. No, the subsequently it has been. It has been admitted then. It has been admitted.
No, not yet admitted. It for the first time appeared.
আচ্ছা যেটা বললাম যে appear tomorrow under the heading order 41 rule 11 of the code of civil procedure. এটা order 41 এ দিয়ে দেবেন। এটা মিস অ্যাপিল তো অ্যাডমিশন হয়নি, এটা মিস order 41 এ যাবে। ওটাই তো ডিফেক্ট।
Repetition right only once, my lord, in a.
No, we'll think about that definitely. But you also go through that judgment and just bring that judgment tomorrow.
Right.
Item number 29 with 30.
So the defendant,
Yes.
counter claimant, Lord, is
Give
the
us half a second, Mr. Kaur. Yes, sorry. Counterclaimant is the appellant.
is the appellant with your lordship. Lord, suit for Lord declaration of
Two
tenancy.
appeals.
Lord, two appeals. One against
Dismissal of decreeing of suit and
the other thing is the problem is, Lord, on the last occasion I indicated, Lord, the trial court's Lord department is not signing the decree. Now, Lord, what I have today, as of now, Lord, they say that they will issue a decree, Lord, on the suit, but they will not issue a decree on counterclaim.
file a certified copy. Will give you leave to file with certified copy.
But that we have done. But the problem is the decree also has to come of the counter. Subject to what for? Lord, same thing happened.
No. You file 2 copies of the decree of the suit or seek dispensation in one of the appeals. Will grant that. Do that.
On the last occasion, this came up in another appeal. Lord, direction was passed by this honorable court. I had to go to city civil court with this direction, and thereafter, Lord, the counterclaims decree. That's the habit.
Let us gloss over these things. We'll give you liberty to
the last occasion.
Yes.
Your lordship had passed an
No,
order.
but then the effect is that one of the appeals is without a copy of the decree. You have annexed a certified copy of the original decree.
Has not been made available. Lord, this week they said they will sign it. This appeal was filed with the leave.
In which one have you filed the copy of the judge?
None of the both appeals, because both appeals were filed with the leave of your lordship, because certified copy was not made available to us. That's why without certified copy, but Lord, with the copy available on the internet, Lord, we had filed this appeal. We were expecting, Lord, that certified copy will be issued in the meantime.
Certified copy will be issued when? One certified copy will be issued when?
Lord, they have told this week they will supply. because one of the signatures in the exhibit section
At least
is
one
missing.
of the certified copies has to
That
be
I
on record.
understood.
Otherwise,
That's
there will
why
be
it
other
is submitted.
difficulties regarding valuation and all. এটা হবে না।
Lord, if a
I have
direction from my lord,
You have got a certified copy?
I have no, only the Xerox copy of certified copy. Yes.
degree of degree.
Yes, yes, certified copy. He has got.
দেখো 1432 sorry
So you pay the balance amount, Mr. Kormokar, what is spent there to get the certified copy and take that degree and file it. You have to pay the balance amount only. That may be substantial, much more than your court fees.
কেমন ভাবে করেছে আমার সাইড সার্টিফাইড কপি তুলে নিচ্ছে
You are Radhesham Keshari
yes Lord.
and you are Lukhirani Pal.
Only for respondent number 1 Radhesham Keshar. Yes.
Yes.
Sorry, my lord, I'll
Ask Lukhirani Pal to pay the compensation, the balance amount to him. Take his certified copy, file it, we'll take it on record and hear out the appeal, the application.
সার্টিফাইড কপি আছে
আমার কাছে শুধু জেরক্সটা আছে এখন
Lord takes it up, Lord.
No, we will take it up. 2 weeks after, because we don't know whether for sure that will be given to you within a week.
only,
they have
only
basic
one
law, I
year may
understand.
kindly be granted to file affidavit in opposition to the Canada.
Very well.
Injunction was only with respect to not to alienate and
Well, that can be done in the meantime. You file your affidavit in opposition within a fortnight, file within 1 week. In the meantime, then we'll have to pass injunction also ad interim.
And
injunction is there, your lordship.
Oh,
has
injunction
asked
is
for the
already
last-
there. Very well.
till disposal of the can application.
Very well. It is pointed out by learned counsel for the appellants that the certified copies of the judgment and degree have not yet been prepared by the concerned department of the trial court. Full stop. Leave is granted to the appellants to file certified copies of the same on the returnable date. Full stop. Next para. In the meantime, the respondents shall file affidavit in opposition to both the applications. To both the applications within a fortnight from date. Full stop. 3 weeks. Within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The applications shall be listed next on March 24, 2025.
Lord, may I file the affidavit of service?
Affidavits of service filed today be kept on record. Yes. Yes.
29 and 30, my lord.
29 and 30 দুটো হয়ে গেল একসঙ্গে দুটো একসঙ্গে yes
I beg to appear on behalf of the respondent number 1.
Section 5 has been allowed.
Lordship, I beg to appear for the appellant's lordship.
Section 5 was allowed.
Yes, it was allowed, lordship. Lordship, in this matter, I have been briefed at a later stage.
That's
When
right.
I have come in, lordship, I have noticed that in the preliminary degree, lordship, the quantum of shares has not been
Well,
declared.
there is no question of preliminary degree in the suit because the suit is with multiple players. My suit.
No, he is challenging what? You are challenging the final degree.
Lordship, in
He's
a
challenging the final
preliminary degree, lordship.
Well, may
Yes.
I just put it out in a nutshell? There were prayers for partition. There were prayers for injunction. My partition prayer was disallowed because some of the parties have been left out. So the suit cannot be decreed on the basis of the partition which has been prayed for in the plaint. Only with regard to the injunction which I am entitled to because I am admittedly in possession of that Fokit Delen property so that the defendant shall be restrained from not to actually dispossess me or not to actually disallow me to actually take possession of that property. Only to that extent this injunction, that permanent injunction has been passed as I am in possession of that property. Only this part has been allowed, other parts has been dismissed. It has been allowed in part. The decree is allowed in part. This is the sum and substance of the decree. There is no question of any preliminary degree. There is no question of any partition. The court has not gone into that because some of the parties I have left out and I have not made them as party. So in the given situation, my lord, my title execution is pending, and with police help, it is returnable on March. And my lord,
Title execution for violation of injunction.
only violation of injunction that I am admittedly in possession, which they are not allowing me to enter the premises. Only to that extent and nothing.
You are not aggrieved with the other part.
No. Even I have not got any decree to that other part also regarding the schedule B of the plaint.
That's
only
what
to
we
the
are
schedule
asking.
B.
You are not aggrieved with that.
Yeah, I am not aggrieved with that. I have not also preferred an appeal against that decree, my lord.
Yes, Mr. Rai, what do you say? I mean,
Yes,
what is
Lordship.
the defect in the flaw in the
defect, I'm explaining, Lordship. Lordship, if Lordship
Can 4
takes
is
up
for
the
what? What is the
preliminary degree, Lordship. This is
Yes.
a preliminary degree against which the first appeal has been filed, Lordship. This first appeal has been filed against a preliminary degree.
There's no question of any
Lordship may
preliminary.
kindly take up the memorandum of appeal. The decree is stitched along with it, Lordship.
preliminary degree was passed?
Yes, Lordship.
No. There was
Absolutely.
Let
The
us see.
stated preliminary degree has been passed. Lordship will see. This is a suit for declaration and injunction.
Where is the preliminary degree? What are you saying?
Lordship, the degree is also annexed, Lordship, along with the.
My lord, I will read the entire decree, my
No,
lord.
no, I am reading it. The suit for declaration, mandatory injunction,
It was not
partition, and for
allowed.
the premises.
Arey Baba re.
The Lordship.
Mr. Rai, please come to the ordering portion.
Yes, yes.
Read it out. What Mr. Das said is perfectly right.
The instance should be decreed in contest on part without cost. You get a degree of permanent injunction, yes, but this is a preliminary degree, Lordship. The degree is.
But you are right in a
The
sense.
degree is there, Lordship. Kindly see the degree.
You are right in a sense, Mr. Rai, that do get a decree for declaration that they are owners of the suit property. That is given.
Lordship, in a suit for partition knows that preliminary degree and final degree, 2 degrees are given.
No, but the shares have not been declared.
That is what I'm saying. So the degree is not complete, Lordship.
The shares cannot
How
be
can the
declared
degree
because
the
some of
partition,
the legal heirs have not been made parties to the suit. So that
all
in
people
that
are parties, Lordship.
in page 5, internal page 5, it has been stated that the said two persons or the legal heirs or the representative are also not parties in the suit, and there is no whisper in that regard, neither in the plain nor in the written statement and in the additional written statement filed by the parties. In that case, there is no scope to pass any decree relating to partition of the suit property, as has been alternatively prayed by the plaintiffs in the suit. It may be further stated that reasonable opportunity were also given to the plaintiff's
Mr.
side.
Rai, there is the scope of
Lordship,
remanding.
kindly look at the issues, Lordship. There also the issue is
Yes,
there.
issues
whether
have been
degree-
decided. Why should you look at the issues? They have been decided. The decision is that they have been declared. It has been stated that it cannot be, no partition degree can be passed because all the co-sharers and are not parties, and declared only that they are co-owners, and permanent injunction.
They are admittedly in possession.
Disturbing possession.
Lordship, kindly look at the plaint.
Plaint has been has culminated in a decree. Why should you look at the plaint? That has not been granted. That's why it's decreed in part.
Yes, my lord.
Yes, but
That's why
this
It
a
has
part
not
of
been
a
granted.
degree then, Lordship.
How can it be a preliminary degree? It's a final degree. The suit
The
is
final
disposed
degree has
of.
been disposed of.
Suit be and the same is decreed in part.
Yes,
That is the partition.
Not granting shares and not directing partition.
absolutely, my lord.
There is no
God
question.
wanted.
We'll say that Mr. Ryan, Mr. Das, if you both of you agree, we can dispose of this appeal.
This person has got a share of 1% only, Lordship.
We can give you liberty to file an independent partition suit with you in any event.
Yes,
You can file a partition suit and have a
Get and
partition. So that they are restricted to their share.
They are only doing this, my lord, to restrain my execution. Actually.
Kindly let me submit.
Yes.
In a suit for partition and mandatory injunction, when a person says that I am a transferee of a particular share and I'm getting this particular room, the view of the Supreme Court till now is the same, Lordship. That is, if you want to get possession of the share, you have to have partition. Without that, you
With
cannot
regard to that room, there has been no degree
No,
passed.
here,
With
how do
regard
they
to only
claim?
the property.
They claim
But I will
view
be
of the
allowed.
Section
I would
40
be insisted by them to
Section
actually
44
take
is
the
also
property.
there. Section 40. It's a dwelling house, family dwelling house.
Yes,
They
family
dwell
dwelling.
there. That's what I'm saying.
I am also in possession. They are actually.
They are saying
legally-
one of the sisters has given me possession. That is how they come.
Then you have a question. You have asked for a remand in this application. There is no scope of any remand in this application because you don't feel this is a
This is not-
preliminary degree.
Yes,
This is a
yes,
final degree.
final degree.
But Mr. Rai, you have a point. If you take the
Suit is
plea of,
disposed of, Lordship.
if you take suit is disposed of here.
Nothing remains, Lordship. So no partition can be given.
No.
They have asked for partition, it has been refused.
Yes.
But then can
Has been refused.
they have possession without partition? The view of the
Possession is already with us.
get-
They are restraining us. That's why only.
Mr. Rai, both of you cannot.
Yes.
Lordship, may I read out the portion of the judgment regarding
Yes.
possession, which is saying?
Yes.
May I?
Yes,
point
section
out that
44 TP Act is there.
Yes. No. The portion which is saying that Gita Mollik has given her share, they gifted her share, and that is how they are saying that we have become the owner. So Gita Mollik's room, they are saying that we must be getting possession. We were in possession since then. But the view of the court is that if you want to have possession, then you must have partition.
What is that? What is that view? No, no. What is the trial court's finding first?
Trial court's finding, Lordship, kindly turn to page 2, Lordship, of the. impugned
Have
trial
they
court.
given any proof of their possession?
Regarding position,
We have a
regarding position, they are saying, Lordship,
Have they given any proof of their possession? Any concrete proof of their physical
how
possession?
they got position.
Have they shown any proof of their possession that they're in possession?
They have only said Gita has given us.
Said not about what they said. What is the proof they have given to establish their possession? That is what we are asking.
Subsequently transferred 1/185 share of her share by executing a gift in favor of the plaintiff.
What is the meaning of proof, Mr. Rai?
That is held that after
Held that means
decision-
proof.
Yes, decision with respect to that proof. Now let us see with the plaintiff.
Proof, Mr. Rai, Praman. Exhibit, document.
The inheritance is there. They are the owners, so they must get their position. That is what it's stated here.
দেখি কোন এক্সিবিট হয়েছে কিনা হ্যাঁ এক্সিবিট হয়েছে কয়েকটা
Exhibit 2, that is a deed of gift.
এক্সিবিট গুলো পেজ 4 পাবেন
Yes.
Thank you, Mr. Rai, for assisting us. Take your seat. We'll go through the exhibits. The gift deed গুলো produce করছে you have inherited you have got the property by gift deeds but that does not itself mean you are in possession.
I was in possession actually. They are actually trying to restrain me.
We don't
from
find any
entering
proof
in
of
that
possession?
premises, not with regard to the first floor flat. I have not got degree to that effect. I have only got degree.
No,
that
how
I
could the court declare? Mr. Roy has a point there. How could you be declared to have possession and that permanent injunction?
Possession means with regard to the premises that I will be have a right of free entry to that premises.
No, no.
With
These are completely different things.
Yes, madam.
You have a right to enter into the premises is
Yes.
different from granting possession, restraining them from disturbing your possession.
Yes, my lord. The decree
You are
is
hit by section 44 if it's a dwelling house.
the
You cannot.
plaintiffs do get a decree for declaration that they are the co-owners of the suit property. We have been declared as co-owners of the
Even if you are stranger co-owners, you don't have a right of possession. No.
and the plaintiffs do get a decree for permanent injunction against the defendant in respect of A schedule property. And schedule A is the one of the premises number. That is,
If you are a stranger, not a purchaser, you are a stranger donee, you don't have a right of possession. If it's a family dwelling house,
a family dwelling house, my lord, it was gifted by the sister.
you have a gift, you have a title, but you cannot have possession. Unless in a partition suit instituted, see, somebody seeks partition, unless one of the co-sharers seek partition.
My lord, I have
They
not
have to
any-
seek partition for you to get that. And in your suit also, they could file a counterclaim, or in their defense, they could have asserted that, yes, I want partition. That would entitle you to get possession. Either they have to assert that they want partition in their written statement even, or they have to file a suit for partition. Unless a co-owner files a suit for partition, a stranger does not have a right of possession in a dwelling house wholly resided over by the family members. No. This possession decree is bad.
My lord, there are, it's not dwelling house, my lord. I mean, there are actually shops also have been, I need to take instruction with.
We don't find any evidence in the record on that. No evidence was laid on that also.
Yes.
So then let us decide the dispose of the appeal and remand the suit back. Not on what he is seeking to grant a final degree, definitely not. But remanded only on the point as to whether it's a family dwelling house. If it's a family dwelling house wholly occupied by the members of the family, then in the absence of any partition prayer by the co-owners, you are not entitled to enter into
My lord,
possession.
sir, yeah.
This
I
is
am
bad.
representing Dilip there, but he has got a share who was in possession. That is the defendant, respondent number 4. That is my
Who
lord.
was the plaintiff?
My lord, the plaintiff was Gita De. My lord, the
Dilip De and Jonaki Ghosh.
Arati De.
No.
My lord, the plaintiff.
Jonaki Ghosh and Dilip De are the plaintiff.
Arati De was the original plaintiff. Arati De died. Thereafter, Dilip De and Jonaki Ghosh was substituted.
They were her heirs.
Yes.
Arati was a stranger. Stranger.
Arati
Arati
got
had
his.
1 minute. Arati was a stranger, Doni.
Arati got his share by way of a gift deed.
She was a stranger to the family.
That
How is
was
she related to the rest of the family?
rest
She is
of-
not
that
a
is a
Mollik.
parental house. Parental house. Arati there is.
Arati is a daughter of the family.
Yes.
Arati gifted her share to the brothers long back in 74. And that is
It's
also
not
an
the
exhibit.
case. He's a,
That is
he's
also
a-
an exhibit.
he's a member of the family.
None of you are apprising the court properly. Don't mislead the court on facts. Who filed the suit originally?
Originally,
I have filed the suit.
Arati De and Jonaki filed. Arati got the share from another sister. That sister,
Maybe from sister. Arati was also a member of the
Yes,
family.
the member of the family.
Arati had
He was
gifted her
very
share
much-
long back in 1974 to the brothers.
What about the other
After that,
plaintiff?
she had no share.
Wait, don't get so excited. What about the other plaintiff?
The other members also gifted her. Now only one sister was left who was having a share. She has gifted to Arati.
So
After that, she has filed this
the
suit.
present plaintiffs are not strangers to the family.
Not strangers to the family.
Strangers, after
They
giving
were-
away their share, they became strangers. They were no longer member of the family.
One sister.
Who are Dilip De and Jonaki Ghosh? Are they members of the family?
Yes.
Jonaki is the daughter of Arati and Dilip is the husband of Arati.
They have been substituted after the suit has
Then
been
they are
filed.
members of the family.
They are members of-
They ceased to be the members after they gifted away their share
There
to
is
the family members.
No evidence
In
to that effect.
1974, it is exhibit
There is
C, Lordship. Lordship will
no
kindly
evidence
see.
to that effect.
Anyway, your application is for the present application is CAN 4. CAN 4, you have sought for a direction to remand the matter to the court will.
Lordship, the question I can answer.
We cannot at an interlocutory stage direct the appeal to
But I can answer Lordship's question whether we was a family member or not.
He's a family
That I
member.
can answer.
Okay, we will look into the evidence and decide, prepare paperbooks and all. This application will direct to be heard along with the appeal, because at the interlocutory stage, we cannot say without hearing the appeal that it will be remanded.
That is
Please, Your
absolutely
Lordship.
correct, Lordship.
CAN
but
4 of 2024 has been filed,
Lordship,
seeking
allow me to allow some grounds in the memorandum of opinion, Lordship.
seeking a remand of the appeal, seeking a remand to the learned court below. Push up next para. However, it would be premature to adjudicate such application at this juncture unless the appeal is heard on its merits. Full stop. Accordingly, let CAN 4 of 2024 be listed along with the hearing of the appeal. Full stop. Next para. The appellant, you are for the plaintiff's
I am
defendant.
for Dilip Kumar De.
Not for Jonaki.
No, my lord.
Both were plaintiffs together,
Daughter and mother.
father and daughter. Three are there. You are family members.
She is the daughter of Arati.
My lord,
You are appearing for whom? Dilip.
I am appearing for Dilip. I need to get an Vakalanama executed.
In
on
view of
behalf
appearance of respondent number 1 Dilip De through his learned advocate, service of notice of the appeal is dispensed with on the said respondent. Post up, the appellant shall put in requisites for service of notice of appeal on the respondent numbers 2 and 3. Full stop. The trial court records be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of filing, 8 weeks from the date of service of notice of arrival on the trial court records on the learned advocate for the appellants. Push up liberty to the parties to mention the appeal for hearing, for inclusion as and when the same is ready for hearing.
Lord, already my lord has passed this order in an earlier occasion. They tried to move a stay application, which my lord refused.
We have
Already there was
passed
a-
these orders.
These orders have already been passed,
Yes,
Lordship.
and they have not carried out also.
তাহলে এই যে বাকি
No,
সবটা করলাম
notice of
শুধু
they
যেখানে
have
শেষ
not
করলাম
carried
যে
out
application will be heard along with the hearing
compliance
of
of
the
your
appeal. ওখানে stop বাকি রেখে দিন।
records has not come yet, Lordship.
your my lord's previous order. They have not carried out
So,
and complied
the
with
order stops at this will be heard along with the appeal.
Yes, ma'am. Please, your lordship.
Along with the appeal আর কোন ডেট না লিস্টে বাইরে চলে যখন appeal hearing এ আসবে তখন তার সাথে
Add some grounds, Lordship, in the memorandum of opinion, Lordship.
Grounds.
now this is no.
Kindly, Lordship,
This
allow me,
cannot
kindly
be
allow
allowed.
me liberty to add some grounds, Lordship.
Yes, always attack. Liberty is granted to the appellant to add further grounds to the memorandum of the appeal, which shall be incorporated by the learned advocate on record for the appellant by tomorrow. For sub next para, a copy of the amended memorandum of appeal shall be served on the learned advocate for the respondent number 1, as also directly upon the absentee respondents.
Please, your lord.